Court officer? Court officer? Court officer? Hello?
Sir, ಹೇಳಿ ಸರ್.
ಇದು ಟೋಟಲ್ 15 ನಿಮಗೆ ಬಂದಿದೆಯಾ?
ಸರ್ 16th.
16th 15th ಅಲ್ವಾ?
ಇಲ್ಲ ಸರ್ 16th. JMCPCನಾ?
ಅಲ್ಲ, ಇದು ಜ್ಯೋತಿ ಮೂಲಿ ಮನೆಯವ್ರದ್ದು.
ಸರ್ ಇಲ್ಲ, ಅದು ನಮಗೆ ಬಂದಿಲ್ಲ.
ಓಹೋ, ಸರಿ, ಓಕೆ. ನನಗೆ ನಿಮಗೆ ಹೋಗಿದೆ ಅಂತ ಹೇಳಿದ್ರು. ಓಕೆ, ನಿಮ್ಮದು 16 ಅಲ್ವಾ? ಓಕೆ, ಸಾರಿ, ಡಿಸ್ಟರ್ಬ್ ಮಾಡಿದೆ.
Contesting disputes in Andy. Grantees one ಅಲ್ಲ ನಿಮಗೆ. Grantees before this legal extra. Partition is in the prior to
4993. Serial number 45.
ಅಲ್ಲ, ಯಾವ ಲಿಸ್ಟ್, ಯಾವ ಸೀರಿಯಲ್ ನಂಬರ್?
45.
ಯಾವ ಲಿಸ್ಟ್ ಸರ್?
45.
ಯಾವ ಲಿಸ್ಟ್ ಅಲ್ಲಿ? ಮೂರು ಲಿಸ್ಟ್ ಇದೆ.
45. 499.
ಇದೆ ಮೇಡಮ್, ಇಲ್ಲೇ ಇದೆ ಮೇಡಮ್. 940 ಗ್ರಾಂಟ್ 8/9.
SC/ST ಮ್ಯಾಟರ್. ಹಾ,
ಸೀನಿಯರ್ ಪ್ರೊಫೈಲ್ ಇಲ್ಲಿ ಬಂದಿಲ್ಲ.
ಅಲ್ಲ, ಅದು ಸಾಹೇಬ್ರು ಕರಿತೀವಿ ಸೀರಿಯಲ್ ನಂಬರ್.
ಸರ್ ಲಿಸ್ಟ್ ಕಲಿತಾರ?
ಹೌದಾ
ಸರ್ ಲಿಸ್ಟ್ ಲಿಸ್ಟ್ ಕರಿತೀರಾ? ಲಿಸ್ಟ್
CMP ನಮಗೆ ಆರಾಮ
ಎಲ್ಲ ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ತಾರೆ.
He spoken to. Yesterday, what happened today? I have informed opposite counsel HC Shivaram to take care of it because my auntie has passed away.
On transfer petition ತಾನೆ?
Transfer. There are bulky documents and judgments are they cannot held and disposed of manner. Held and number of there are 3
ಆಯ್ತು.
here.
ಟೋಟಲ್ 16 minutes.
I'll release it on Monday.
Tuesday.
Tuesday. Unless there's some urgency, if you mention, I'll take it up, or else every matter will be re-listed.
Thank you.
Bye.
Date is fixed on 20th. Date is fixed on
The court order says there are too many matters on Tuesday.
Total 16 minutes. Total 16.
Court number 16 ಇದೆ, ತುಂಬಾ ಮ್ಯಾಟರ್ ಇದೆ ಅಂತ Tuesday ಹಾಕೋದಕ್ಕೆ. They'll scatter it over 1 or 2 days.
20th.
Whatever they'll fix.
20th.
Number 60, at reserve 2006, the Catholic state currently
We'll come back next week.
valid to connect number 4 and 5. I filed an application for vacating of refund.
I am not the regular court, so it will come next week. Unless it's very urgent and you mention it, I will not take up any matter.
For adjournments, list number 1. Page number 8.
Serial number 1, my lord. Serial number 1. Press time for.
But I
Very
approached
clear.
the last is.
Please wait, please wait.
Lordship, serial number 2, my lord. Council are recording, not information, my lord. Please, kindly have it. Keep on.
Serial number 1 also, my lord. Council is not.
ಅವ್ರು ಅಪೋಸ್ ಮಾಡ್ತೀರ ನಿಮಿಷ ಇರ್ರಿ ಕೇಸ್ ಕರೆದಾಗ ನೋಡ್ತೀನಿ.
Page number 9, seal number 30 to 39. Page number 10, seal number 40.
Selected matter, CP 340 of 24. For the respondent, 35, 45.
Post along with.
Number.
340 of 24.
Page number 10, seal number 40 to 46. Page number.
45.
Serial number 46, please, my lord.
Have it on next week, any day.
You are for
Respondent 1 minute.
2015, please wait.
Lord, serial number 46, my lord. Could your lordships have it on 26th, my lord?
Same thing, please wait 2015.
Please, my lord.
Page number 11, seal number 47 and 48.
Serial number 47, my lords. There's some inconvenience. The council is.
Please wait, madam, please wait.
Page number 12, seal number 49 to 51. Page number 13, seal number 52 to 56.
Lord, serial number 54, Lord. I'm thinking for a week's accommodation because of LL. Next week on date, please. Date, Lord.
22nd. 22nd.
Released. All right, released.
Next any date, ma'am.
ಯಾವುದು?
I am there for respond number 4 and 5. madam.
22, 22nd,
Any date, maybe.
ಕೊಟ್ರಲ್ಲ
22nd. Page number 14, seal number 57 and 58. Page number 16, seal number 59 to 62. Page number 17, seal number 63 to 65.
Respondent number 5. Some inconvenience.
Please wait, 2012.
Page number 18, seal number 66 to 68.
68, madam. We'll have it on next week, please.
60,
68, serial number.
please wait 2015.
Page number 19, seal number 69 to 74.
72, my lord. Senior ಹೋಗಿದ್ದಾರೆ, so 2 weeks time.
Released. 22nd.
Thank you, my lord.
Page number 20, seal number 75. Number 3 for non-compliance of office objection.
Serial number 3, my lord. Serial number 3, my lord. I propose to do this. Third time, 1 week finally, failing which.
List
So the third time,
number 2.
in the estimate.
Yeah, date.
Serial number, fourth time.
Date.
Compliance of, I'm for the petition, my lord.
Correct, serial number 8 ತಾನೇ ನಿಮ್ದು.
Week's time, my lord.
ಸರ್ ಪೆಟಿಷನರ್ ಅಂತ ಕೇಳ್ತಿದ್ದಾರೆ.
Serial number, petition, my lord. Petitioner. Serial number 8, I'm for the petition, my lord.
Mallikarjuna BC.
BC Mallikarjun.
Third time matters, 2 weeks failing which will stand dismissed.
Serial number 3, my lord.
Come, I'm-
Serial number
listen to- Third time, all matters, 2 weeks failing which will stand dismissed. Fourth time, 1 week failing which will stand dismissed. Fifth time, 7th time, it will stand dismissed by 2:30. If it's not completed.
Serial number 2, my lord. Serial number 2, my lord. Serial number 2, my lord.
ಎಲ್ಲ 2 weeks ಕೊಟ್ಟಿದ್ದಾರೆ.
2 weeks failing which will stand dismissed. Don't comply, automatically it will be
Yes,
dismissed.
my lord. Come to that.
Serial number
Fourth
18.
time, one time,
Yes, my lord.
1 week failing which will stand dismissed.
Serial number
Fifth
8.
and 7th, 8th, by 2:30, if you don't do it, it will be dismissed.
List number.
Serial number 18. ಅದರಲ್ಲಿ ಆನ್ ರೆಕಾರ್ಡ್ ಕೌನ್ಸಿಲ್ ಎಕ್ಸ್ಪೈರ್ ಆಗ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಸೊ ಪಾರ್ಟಿ
This
ಇನ್ಸ್ಟ್ರಕ್ಷನ್
is 8th time.
ಆನ್ ರೆಕಾರ್ಡ್ ಕೌನ್ಸಿಲ್ ಎಕ್ಸ್ಪೈರ್ ಆಗ್ತಿದ್ದಾರೆ.
On record, yeah.
ಐ ಆಮ್ ಸಾರಿ ರೆಫರಿಂಗ್ ಅಡ್ವೊಕೇಟ್ ಮೇಲೆ ಎಕ್ಸ್ಪೈರ್ ಆಗ್ಬಿಟ್ರೆ
ಏನ್ ಮಾಡ್ತಾರೋ 2:30 ಮಾಡಿ. 8th time I can't grant time. You comply
Tuesday.
by 2:30.
ಟ್ಯೂಸ್ಡೇ.
Serial number 2.
List number 2.
List number 2 ಎಲ್ಲ
ಅಲ್ಲ ಡೇಟ್ ಮೇ ಬಿ.
ಕೊಡ್ತಾರೆ.
Eight, if I may just request the matter to be referred for mediation because there is chances of the matter getting settled.
The CST matter, what is the reference?
My lords, 8 CP matter, my lords. List number 1.
Then list number.
All right, I'll wait.
List number 1 for preliminary hearing, seal number 1, Chokkareddy.
Petitioner in this case, waste time for 1 week time. Regular counsel is
ಏನ್ ಮೇಡಮ್?
Grant was under the 1940 Land Revenue Act.
convenience.
ಅವ್ರು ಬರ್ತಾನೆ ಇಲ್ಲ. Last time objections cure ಮಾಡಕ್ಕೂ ಬರ್ಲಿಲ್ಲ.
One shot at me.
Dodging the matter, my lord.
Does he have an interim order?
No,
What is the urgency?
I do not. Matter is settled, my lord. Issue is settled by the
Yes.
court.
One shot at me began.
22nd.
Next time ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಡಿಸೈಡ್ ಮಾಡಿ.
22nd. Seal number 2 adjourn.
22nd.
Seal number 3. Sushant Tiwari.
For the petitioners, my lord. My lord, challenging the DC and the AC order, my lords, the impugned order. Setting aside my sale, my lord, declaring it as to be null and void. Additionally, my lords, I'm also challenging the amendment to section 5, my lords, of the PTCL.
Lord,
There, I believe, my lords, there are a bunch of matters which are already adjudicated.
Sale of the year 1998, my lord.
Court ಇಲ್ವಾ?
ಇಲ್ಲ, court permission ಇಲ್ಲ. I'll take notice, my lord.
CGP accepts notice for R1 to R3, issue notice to R4. This is an interim stay.
My lords may be connected to the other matters, my lords, which are already adjudicated. They are also listed on the 21st, my lords. I'll produce a memo to that effect.
Seal number 4, Shri M. Shiva Prakash.
In the suit, IA number 1 and 2 are the applications. One is for injunction, another is not to alienate. After contest, both the applications are allowed in favor of this plaintiff. Court has on material document, material facts, it has come to conclusion with all those things. Now afterwards, there are troubleshooters there in the place. I made an application for,
You are for the defendant.
I am for the plaintiff,
What is the suit for?
suit for permanent injunction.
Based on,
Based on my title deeds and my position and allotment, all those things.
what was the defense?
Defense is that the land which was earlier, which was not sold by them and it is not identified, all those things are frivolous and vexatious defense they have taken. After hearing both the parties, the humble court has come to conclusion and granted this order of injunction. Also an application for not to alienate the property. Now my fourth application is a
ಎಮ್ಮೆ ಹಾಕ್ಲಿಲ್ವಾ ನೀವು?
ಅವರು ಹಾಕಿದ್ದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ, ಅದ್ರ ಪರ್ಟಿಕ್ಯುಲರ್ಸ್ ಏನು ಕೊಡ್ಲಿಲ್ಲ.
ಎಮ್ಮೆ ಹಾಕೋದ್ ಬೇಡ, ನೆಟ್ಟಿಗೆ ಇಲ್ಲೇ ಬರ್ಬೋದ?
ಅಲ್ಲ, ಇದು ಪೊಲೀಸ್ ಪ್ರೊಟೆಕ್ಷನ್ಗೆ 151. ಅವರು ನನ್ನ ಆರ್ಡರ್ ಮೇಲೆ ಹಾಕಿದ್ದೀನಿ ಅಂದ್ರು, ಅದ್ರದ್ದೇನು ಡೀಟೇಲ್ಸ್ ಕೊಡ್ಲಿಲ್ಲ. ಆಮೇಲೆ ಅದು ಅವ್ರು ಮೂವ್ ಮಾಡಲಿಲ್ಲ. ಲಾಸ್ಟ್ ಇಯರ್ ಆಗಸ್ಟ್ ನಲ್ಲಿ ಆಗಿರುವಂತ ಆರ್ಡರ್ ಇದೆ.
There is an application of for police protection. ಏನಾಗಿದೆ ಇದ್ರ ಮೇಲೆ ಆರ್ಡರ್ ಏನಾಗಿದೆ?
Impugned order refusing to pass an order to extending police protection to me by directing the local jurisdictional police.
Take out notice, issue notice. Counsel is permitted to take out notice on the respondent through work counsel in the trial court. Relist or
One date may be given.
29th.
29. Obliged.
Seal number 5, Shri R. Shashidhara.
Purchaser writ petition, my lord. This is not, no documents are available to show that it is a granted land, my lord.
ಏನ್ ಮೇಡಮ್? ಮೇಡಮ್.
And AC also records the finding,
Serial number 5.
page number 51, your lordship, again.
The finding is that there is a grant.
No finding is also that there is no Sagoli chit available, no document is available. And AC records the finding that this transaction not attacks the provisions of PTCL Act. Only on the ground that land belongs to.
ಏನ್ ಮೇಡಮ್?
Page number 51 ನಲ್ಲಿ. Point number 5. ಈ ವಿವಾದಿತ ಜಮೀನು ವರ್ಗಾವಣೆಯು PTCL ಕಾಯ್ದೆ 4ರ ವಿರುದ್ಧವಾಗಿದೆ. ಸದರಿ ಜಮೀನು PTCL ಕಾಯ್ದೆಗೆ ಒಳಪಡುವುದಿಲ್ಲ ಅಂತ ಏಸಿನ ಹೇಳಿದೆ.
Issue notice, CHB accepts notice for R1 and R2. Interim stay
Not for my lord, hand delivery.
and delivery.
Urgency has ಪಾಣಿ ಎಲ್ಲ ಚೇಂಜ್ ಮಾಡ್ಬಿಡ್ತಾರೆ. This land is also acquired for my lord KDB.
ಅದನ್ನ RTC
ಚೇಂಜ್
and delivery permit.
Seal number 6,
Madam.
Shri Sunil Shastri.
And for the Commissioner, my lord, I filed a memo for withdrawal.
Additional expenses.
Seal number 7, Sumant Bharadwaj.
Petitioner, my lordship. The handsome duly served on the advocate of the
How was
respondent.
served? When was it served?
13ನೇ ತಾರೀಕು, my lordship.
Monday.
Ah.
It is stated that copies of the petition have been served on the respondent's counsel in the trial court. Relist on.
Interim order kindly may be extended. Which-
Interim order extended.
22nd. Seal number 8,
But
That's appeal for the petition.
I filed my wakalat for the respondent. I also request it.
Transfer to where?
Yes, that's to senior civil judge at Wascote. Already, my lords, 2 petitions has already been transferred. That is pending before the senior civil judge at Wascote. Now, recently, my lords, in the year 2023, my lords, petition has been filed for that is pending before the senior civil
What
judge.
is the petition that you have filed?
My lords,
What is the 2 petitions that you have filed?
my lords, I have filed the petition under section 13. The respondent has filed the petition under section 9. My lords, 9 petition has already been transferred to senior civil judge at Wascote. Both the petitions are pending before the senior civil judge at Wascote. This petition has to be transferred and it is convenient to both the parties.
Plus, may I, just one, there is high chances, in fact, both the parties want to live together. And in fact, GNWC is already referred for mediation. So if this can be referred for mediation, all that they have to finalize is where they have to make a residence. They per se do not have any issues between each other. In fact, husband has filed for restitution of conjugal rights. So if this
Yes.
matter can be
But she has filed for divorce.
Yes.
divorced, but she is okay. She wants to live with him. She has also expressed. And the mediation
But
in
she is-
JWC is going on, and I think BMC is a better place where they can mediate and the both of them can, because child is, my lord,
What is
Is the
your
inspector, my lord, excise inspector.
sorry, my lords.
What is your avocation?
Avocation, he's, I think, working in Bangalore, my lords. He's working in Bangalore. Her
What
parents,
does he do?
plus, he's here, I can find out.
It's excise inspector. my lords.
He's here only.
And what is the difficulty go to Wascote for next day?
No, no, not like that, my lords, because
Even
they
he is
can
staying.
make,
Not agreeing for that.
no, she, in fact, if she's present, she will tell that she's ready to
That's-
join.
So many times matter has been referred to mediation. But she has not agreed. She's so many occasions.
Not
but
at
he has
least if he's-
he has tortured. Because of that reason, let's,
Settlement ಆಗುತ್ತೆ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ, ನೀವು ಆಗಲ್ಲ ಅಂತಿದ್ದೀರಾ?
no, let's, in fact, mediations already, let's, so many times.
Get your party before the court. Let
Yes,
us
let's.
relist on.
22nd,
Both the parties be present.
Yavat,
22nd.
grateful.
Seal number 9. Sumant L. Bharadwaj.
Lordship, the advocate of the respondent refused the hand summons. Regular date ನಾಳೆ ಇದೆ, ನಾಳೆ ಸರ್ವ್ ಮಾಡ್ತೀವಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್.
Relist.
Entry order kindly may be extended.
22nd. Seal number 10. VB Sidramaya.
Petition in this case, my lord. Lord, kindly pass for my lord, I'll comply the office objection.
Seal number 11.
I pay for the petitioner, my lord. I've taken out notice in paper publication. I filed those copies also before the court.
Right, order date 27/9/24 is accepted. Respondents called out absent, hence their list expired.
May be posted for evidence, my lord, hearing.
Undertaking you given to pay the court fee?
Yeah, no, there's no
Yes,
court fee here. I will have to
One-
pay. No, I'll have,
1/24 is for dispensation.
I'm sorry, I think this is not my matter then, ma'am. I was told it's 11.
It is 11.
Yeah, Rego and Rego, my lord.
Correct. I have accepted the paper of publication.
Yes, ma'am.
There's one more application pending for dispensation of notice to the deputy commissioner.
Your lordship and give me time, I'll make a submission on that, my lord. Because court fee is paid after the grant, my lord. It's probate duty 39,000 is capped.
You undertake, I'll dispense with.
I can deposit it in advance itself, also, not a problem.
Since the learned counsel undertakes to pay the maximum court fee of rupees 39,000. Notice to the deputy commissioner regarding verification of the valuation is granted. Released on
29th. 29th.
Obligement.
Seal number 12.
Lord, I filed a memo for retirement, my lord, in respect of R3 and R4.
Since Ranjan Kumar K has entered appearance for R3 and R4. Yes, hello.
No,
You had filed.
I have filed memo for retirement.
Yes, Narayan Swamy has entered appearance for R3 and R4. Ranjan Kumar is permitted to retire.
Seal number 13.
Filed the IA for amendment. Respondent is not on 12/11. Not may permitted to carry.
State. Antrega.
I'm permitted to carry out.
Paso.
It will be taken up on Tuesday, Mila.
Released on.
22nd, 22nd,
I'll carry out the amendment.
Friday amendment.
22nd.
No, I may be permitted to carry out the amendment.
Please do.
Seal number 14.
Acharya.
For the respondent number 12.
4, 3, 8 and 9.
Any pass or you do that? That was reserved for some time.
Yes.
Where is Acharya? Paso.
Seal number 15. Kaleshappa.
1 week time you have granted, please, Milord. Another connected matter, please, Milord. 14/6/8/2022. ಇದರಲ್ಲಿ ಇನ್ನೊಬ್ರು ಬೇರೆ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು ಸೇಮ್ ಆರ್ಡರ್ಸ್.
ಅಲ್ಲ R7 ಯಾರು?
R7 ಪಾಪು ಅಂತ ಸುಮ್ಮನೆ ಅವ್ರ ಹೆಸರು ಅಷ್ಟೇ ಪಾಪು ಅಂತ ಅವ್ರೆ.
ಇನ್ನೊಂದು ಮ್ಯಾಟ್ರ್ ಏನಂತ ಹೇಳಿರಿ ನೀವು?
ಇನ್ನೊಂದು ಮ್ಯಾಟ್ರ್ ಸೇಮ್ ಬೇರೆಯವರು ಚಾಲೆಂಜ್ ಮಾಡಿದಾರೆ ಸ್ವಾಮಿ ಡಿ ಸಿ ಆರ್ಡರ್.
Post along with
14/6/8/2022.
ಬರ್ಕೊಡಿ. ಕೊಡಿ.
Second. Seal number 16. Jai Kirti.
For defend, for respondents.
Short accommodation to.
What is I1 to I3 to bring the LRs on record?
Respondent number 11 has died, filed an application, necessary applications to bring his LS on record.
ಹಾಕಿದಿರಾ?
Application there's some office objections.
Malad, the case of Malad, the court below, impleading of the legal heirs of the plaintiff Malad. The same has been challenged Malad before this honorable court. In the meantime, Malad is not taking steps.
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ ಅವ್ರಿಗೆ?
Copy.
ಅದು ಕೊಟ್ಟಿಲ್ಲ.
I shall furnish one.
Please.
Allow the applications.
Impleading application, yes,
Their application.
yes, ma'am.
Since the right to sue survives on the
Copy
applicants.
Court.
IA 1, 2, 3 or 24. The said applications are allowed. First statement to be amended. What is the matter about?
No, then LR application is filed by some persons claim to be the LRs of the plaintiff, that's
For- for
disputed.
What
And the
for second
defendant,
defendant?
please,
Suit for
suit for declaration,
who died?
the original plaintiff died,
Suit for injunction will not declaration.
original plaintiff died, and some persons claim to be the legal class 1 heirs have filed application that's been opposed. Without any inquiry, that application has been allowed. I dispute the fact that they are the legal heirs. An inquiry ought to have been held under our 22 Rule 5,
I leave that question open if you want. They are representing the estate of the deceased.
No, they're not the class 1 heirs.
They're the class 1 heirs. Let them represent the estate of the deceased. Somebody has to represent the estate of the deceased. What difference does it make whether they come or what is your relationship?
Milord, we are relatives, Milord, my husband's brothers, Milord. Milord, plaintiff,
Husband's brother.
brothers, because no issues for the plaintiff.
How come the brothers are not coming?
Milord, here, my husband and myself both are no more, Milord, here. Plaintiff has no more. Now, since there was no marriage at all for the plaintiff and the plaintiff and the husband of the plaintiff.
Come again. Suit is by whom?
Injunction, suit is by me, my lord.
By Putterama.
Puttiramma, my lord. For injunction, my lord.
Putterama died.
Died, my lord.
She had no issues.
No issues.
Her husband is not alive.
No, not alive, my lord.
Then who are you?
Now I am the brother of the husband, brothers of the husband, my lord. Brothers. Own brother, my lord.
Puttiraman brother.
No, not Puttaram brother, my lord. Puttaraman's husband's brothers.
Can they be LRs?
My lord, yeah, my lord, in the Hindu, the transfer of property goes to, as per the Hindu Succession Act, husband's,
Husband's property.
Yes, yes, my lord.
Disputed, request your
Husband-
lordship kindly out next week, my lord.
If
I
she,
shall get ready of the facts and argument.
if in the plaint, she says it is a property of the husband and she had succeeded to it. If they have no issues on her death, it will go to the LRs of the husband only.
My lord, it's a suit for declaration. I'm not, today I'm not ready. Lordship kindly fix a date, my lord, on Wednesday or
The
Thursday.
matter of
I shall-
2003 is pending, my lord.
Lordship
for
kindly
injunction.
fix a date, my lord. Next week, any date, my lord.
22nd.
Much obliged.
Number 17,
Much.
Shriyam Srinivas.
The petitioner. I shall comply with the office objection. A week's time may be granted.
Weeks time is.
My lords, T.N. Vishwanath's name may be reflected in the, we have obtained NOC Wakalat just last week. Last week ನಮ್ಗೆ NOC Wakalat ಬಂದಿದೆ.
It is reported that Shri T.N. Vishwanath has entered appearance on behalf of the petitioner. Office to verify and print his name.
After 3 weeks, can you stay there? Then let us see.
Entry model ಇದೆಯಾ?
Huh?
Entry model ಇದೆಯಾ?
ಇದೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡರ್ ಇಲ್ಲ ಸ್ವಾಮಿ. ಐ ಆಮ್ ರೆಪ್ರೆಸೆಂಟಿಂಗ್ ಅ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇನ್ ದಿಸ್ ಮ್ಯಾಟರ್. ದಿಸ್ ಇಸ್
Everybody
ಆಫೀಸ್ ಆಫ್
announced
I'm a caveator. I'm representing caveator in this matter, my lord. It was listed for non-compliance of office objection. Till date, it is not compliant, my lord.
Seal number 18, Shri Allah Bakash.
Memo is filed seeking to withdraw the petition. Acceptance of memo petition dismissal withdraw.
Seal number 19, Srimati Kavita HC.
When did Act 12 die, madam?
In this matter, my lord, R12 is the I am the subsequent purchaser petitioner. He is my vendor, my lord. The contesting respondents, that is the LRs of the grantee, they are already on record and they are represented, my lord.
The petitioner
I'm seeking
contends that
dispensation.
He is the subsequent purchase, he is the purchaser from the 11th respondent and are from the 12th respondent. And R12 had no subsisting interest in the subject matter of the writ petition. Hence, taking of steps against the deceased R12 is unnecessary.
Please, obliged, grateful.
Seal number 20,
Interim order may
Nice.
please be extended, my lord. Interim order may please.
seal number
Not
20.
my instructions is not this respond number 5 is still alive. I will get affidavit filed. ಅವ್ರು ಬದುಕಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ, ನಾನು ಅಫಿಡವಿಟ್ ಫೈಲ್ ಮಾಡಿಸ್ತೀನಿ.
ರಿಪೋರ್ಟ್ ಮಾಡಿದವ್ರು ತಿರೋಗಿದ್ದಾರೆ ಅಂತ.
ಅಲ್ಲ, ಲಾಸ್ಟ್ ಟೈಮ್ ಕೋರ್ಟ್ ನೋಟಿಸ್ ಏನೋ ಸರ್ವ್ ಆದಾಗ ಇಟ್ ವಾಸ್ ರಿಪೋರ್ಟೆಡ್ R5 is dead, but my instructions not R10, not the LRs R5 to R9 are LRs of the R10. They are already on the record. That I will file a memo. But my lord, my instruction is R5 is still alive.
R4 and R5 are brothers, huh?
Not sir, R5 to 9, my lords.
R5 to R9 are the LRs of R10.
They are the legal heirs, my lords of R10.
Since council submit that R5
Sorry, R4, my lords, R4 to R9.
are the LRs of the deceased R10 and they're already on record. Hence, respondents 4 to 9 shall be treated as the LRs of R10. Senate Council also submits that R5 is actually alive and an affidavit to that effect would be filed. The said submission is taken on record.
Interim order may be signed.
Affidavit acting.
Seal number 21, Shri Shriya Revi.
Prepared for the petitioner's counsel, my lord, where the purchasers, we were not made parties, neither our vendor nor the purchasers of sites were made parties. Assistant Commissioner rejected the application. By order annexure A, Deputy Commissioner takes the view, in view of the amendment, the delay of about 17 or 18 years will not matter. Therefore, he takes that and
Amendment challenge ಮಾಡಿದ್ದಾರೆ ನೀವು?
Challenge ಮಾಡಿ.
ಅದನ್ನು ಮಾಡಿದ್ರು.
Issue notice, CGP accepts this. respondents 1, 2, and 3. This should be an interim stay.
Please.
Copy ಕೊಟ್ಟಿದ್ದಾರೆ ಅವ್ರಿಗೆ.
Copy ಅವ್ರಿಗೆ we tried in the afternoon. Yesterday I ಕೊಟ್ಟಿಲ್ಲ ಸಮಯ ಕೊಡ್ತೀನಿ.
For reporting compliance, serial number 22, Srivastava.
I appear for the respondent. One of the land acquisition officers and the deputy secretaries are here. What I ascertain, my lord, is that the process is underway. What happens, my lord, is that this particular issue has been placed before a committee. My lord, this matter arises out of utilization of 5 gunta. You made a submission. Yes. That the matter has been settled.
In fact, my lord, it's not settled, my lord. What has happened, the process is underway. In fact, we have also placed before a subcommittee. My lord, I want to place things on record. It is not as if we are not going to give them the sites. But my lord, there's one small process which has to be undertaken by 2 different departments in the same BDA. My lord, may understand one thing, my lord, our endeavor is to ensure that he gets justice. 5 guntas of land has been utilized. Now, my lord, it's now placed before a subcommittee consisting of 4 different officers. My lord, they are in the process. My lord, this process of allotment, legal allotment would take probably a month's time, after which, my lord, it will go before the deputy.
To take possession of somebody's property, you don't require a subcommittee.
My
To
lord,
give back land, you want a subcommittee to be formed?
my lord, it's not that, my lord, it's not that way. What happens is that process has been followed and that.
When was the land taken over?
My lord, it has been taken over quite some time, my lord. I
When?
understand. It's an old acquisition, my lord. I cannot.
What is the kind of?
My endeavor is not to trouble. Can I make one request to the honorable?
How many times have I adjourned the matter?
Yes, my lord. If I may be given probably about 3 months' time, I will not even get back like this.
I gave you more than 3 months' time here.
Yes, my lord, it is true, my lord. But this time I will not ask.
I'm not inclined.
The officers are.
They have lost 5 guntas of land long time ago.
Yes.
Who's to compensate them for that loss of time?
Yes, my lord, it is true. But the thing is.
You can't take advantage of this situation.
It is not so, my lord. In fact, we have actually been cooperative. It may not seem so on record, but my lord, I've got the file, my lord. We have actually placed it before the committee. We will ensure that it's at a fast pace. I'm making a submission, my lord, for the bar in front of my office.
I accepted your submission on 4 occasions.
This time, my lord, my lord,
and you ultimately said that
I can also file an affidavit, my affidavit if need be, my lord. I will place on record everything, my lord, that things are in place. We will file, we will ensure that the committee approves it, and after that, my lord, the process is.
Who heads the committee?
My lord, it has got the secretary, my lord, secretary.
Ask him to be present.
The government of Karnataka, my lord, it's not that, my lord,
you cannot take this.
Can I make a request, my lord?
You cannot take the court and the petition for granted.
My lord, can I make one?
We cannot work at your convenience.
It will not be done, so, my lord.
It has been done.
Can I make one submission, my lord? In fact, I have also spoken to my learner.
Petition
is not here today, yes. But we feel, my lord, that matter. But only one indulgence.
I accepted your submission on at least 4 occasions.
My lord, I'm obliged. Deeply
and I have lost trust in your submissions and in your client's ability to abide by your instructions.
My lord,
or it's the committee, let him be present.
My lord, this time, in case it is not done, my lord, I would leave it to them.
I'll grant you 2 weeks' time. If you don't do it, over setting the committee.
2 weeks' time, it may not be possible if in view of the facts, my lord.
Make it work. You have made the court wait for 4 months or maybe even more.
Can I finally 2 months? I will see.
Weeks ಅಷ್ಟೇ 2 weeks ಅಂದಿದ್ದೀನಿ ನಾನು.
Once a committee approves, then my lord, it will come back to us. We will allotmental. I can ask this off.
If the formation of a committee is a problem, get the person. Then if the committee can't sit to decide on giving land to the person whose land you have taken forcibly.
My lord, is the government, which my lord, they are doing it. It is like an interaction between 2 different committees of the state and the BDA.
You may have 1,000 difficulties. You should also look at the difficulty of the citizen who has lost 5 guntas of land. You seem to act like as if he can wait forever and you have your own problems.
My lord,
if you and I had lost land, would we have kept quiet?
Yes, my lord, I fully.
Then what is this attitude that we are going to take 3 months, 6 months to sit and discuss?
It is not so, my lord. Process, I would say.
If the process is such that to a person who's been robbed of his land, if you take 2 or 3 months to take a decision, after 6 months of time granted by the court, there's no meaning in time.
At least 45 days to 50 days. After this, I don't want to come back again.
Whoever is secretary or whoever, ask him to be present before the court. I'll record a submission that this is what is requested and this is unacceptable.
I'll just 1 second. my lord, we can have the committee, my lord, in 2 weeks, my lord, I will try to.
I'll have it after 2 weeks, whatever you want to do it by then. Don't make me pass any order which has,
My lord, as far as.
I'm inclined to grant him damages for the loss of this land for the past several years.
At least, my lord,
If an auction purchaser does not pay money to you, what is the interest that you charge?
it is, my lord, my lord,
Take away his land and
I might not
this
have.
casual attitude of the officials is not correct.
I might not have answered many of the questions posed, my lord, but the fact, my lord, is that it is not as it is made out to be. There is no harassment in this case. There is a delay. There is a delay.
You take away his land, then you promise him land and you're saying there's no harassment?
In fact, that is true, my lord. But that process in that.
Whatever is the process, expiry date,
Once.
I'll call it after 2 weeks. If you do it, fine. Or else you'll keep the secretary
My
present.
lord may say, in 2 weeks' time, my lord, the committee approval of the in place, I'll place. Then, my lord, the other things.
Whatever you want to do, Unikrishnan, do it in 2 weeks. No further time.
At 3 weeks. 3 weeks. 2 weeks.
ಆಮೇಲೆ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ every day 1 lakh cost ಆಗ್ತೀನಿ.
Hello, my lord,
Payable.
my lord, my officers are here. I'm speaking in front
Your
of them.
officers
If it
were
doesn't
there from
happen,
the beginning.
Then whatever has to happen, will have to happen.
Then I'll pass it today only. Why should I wait?
3, no, ಮಾಡ್ತೀನಿ ನಾನು. Ultimately, my endeavor is to close it. 3
The
weeks.
deputy secretary, 2 and 3, na?
2, 3 and the land is not. Ella 3 jana.
And the election officer present to the court. Shri Unikrishnan Land Construction with BDA assures the court that the subcommittee, which is to take a decision in this regard, will positively take a decision within 2 weeks and report the same to the court within 3 weeks. Relist on. On that date, if you don't do anything, there will be serious consequences
6th
on all the
December.
concerned.
6th December.
Yes, sir.
Grateful.
For hearing on IA, seal number 23, Shri O. Shivaram Bhatt.
Lord, I am filing the objection, my lord. Now, my lord, the parties to the list, they entered into a compromise petition.
Who has made the application?
Now, he says that he was the family member. He neither was a party in the suit, my lord, suit of the year.
Ask for the compromise decree to be set aside.
My lord, 1992.
The suit. Not a part. Then how can you make an application? If you are agreed with the compromise, file a separate suit. You cannot file
My lord,
application
this person,
in which you are not a party and say the compromise is intended to be set aside.
my lord, this person, my
Last
lord,
time also you did not come. The time before last also you didn't come.
Just yesterday, they have served the official copy.
When the case was posted, you did not come. Pasor,
my lord,
Not in town. Some death is found there is out of.
Monday.
Any day for.
Monday.
Monday, Rajay, Tuesday.
19th.
Hey, file the objection statement.
Alla registry lag.
Please, please.
Seal number 24, Shri Shahbaz Hussain.
Okay.
FIR for respondent number 2.
Lord's
Your
matter was
Lordship,
disposed of by order
this-
dated 26/7.
This matter is concerning that agriculture land in respect of which street lines were laid. It was not agriculture land, but residential land.
What is the clarification? Please?
Your Lordship, the clarification that we've sought is page number 3 of the application, if your Lordship sees.
Page number 3.
Page number 3, para 11 that we've extracted. The respondent shall take into consideration that by virtue of the order of conversion being granted, the entire corridor area cannot be used for erecting residential buildings. The third respondent shall therefore consider payment of compensation in respect of the corridor area, keeping in mind that entire piece of land under which lines were drawn cannot be used as provided under the permission granted under section 95(3) of KLR Act. Now, your Lordship, they are giving me the compensation only at 15% of the land value of that land that falls under the corridor.
My direction only to consider. What is the clarification that you require?
Your Lordship, when the matter was argued, your Lordship had indicated that the entire stretch will become useless for me. I will not be able to use it.
If they have refused that consideration, if they have given some reason for it, I can't clarify it now. You may have to challenge it, isn't it?
That's correct.
Can I ask for clarification?
But the only point that we were trying to raise here, your Lordship, one more point that we're trying to raise is there are central government guidelines which have been passed.
It's a separate petition. How can you see for clarification?
Very well, your Lordship. But
I had taken your grievance apprehension into concern and I directed them.
yes,
If they have disregarded it,
yes,
you know what is to be done. I can't turn the clock back now.
yes.
Lords, may I make a submission, Maharaj? There are 2 aspects. Along with the application, kindly see page 7. The DC has passed an order. Second,
Second, it is for him to thereafter either challenge it or. The second aspect is I have preferred a writ appeal in respect of the order dated 26. That would get frustrated if this
Want to
application.
withdraw this? You want to dismiss? What do you want to do?
I'll withdraw this, your lordship, with liberty to file another.
Once the petitioner seeks permission to withdraw the application with clarification and seeks liberty to, on the ground that he wishes to challenge the order passed pursuant to the order passed by this court on 26th of July, 2024. Application is dismissed or withdrawn. Reserving liberty to the petitioner to challenge the order that is stated to be passed pursuant to the order dated 26th of July, 2020.
For further consideration, seal number 25, Sriyesh Srikanth.
Counsel appearing on behalf of the respondent number 4, my lords.
Yes.
The counsel seeks time, my lords, that the senior is not feeling well, is suffering from an eye infection, so hence seeking for an adjournment, my lords.
They have been seeking time after time, my lord.
You took time,
My lord,
last time somebody took time on your other Itane
apartment.
3 ಸಲ ನೀವು ಟೈಮ್ ತೊಗೊಂಡ್ರೆ ಇವಾಗ ಅವ್ರಿಗೆ ಚಾನ್ಸ್ ಇವಾಗ.
It's a genuine reason, my lord.
Last time I was not there.
Relist.
22nd.
Good job.
Oblige, my lords.
Seal number 26.
I appeal for the petitioner.
Chandra.
My lord, we have filed the counter affidavit as directed by your lordship.
What was your affidavit?
My lord, we have wielded some power, there is no doubt about it. And the billing pattern is, my lord, what?
19/9/2024 is my affidavit. And there is a counter affidavit, my lord, on 5/11/2024.
99 or 29?
20th.
My lord, that is already taken on record
99.
on the last occasion.
19/9, lord.
What did they say in the affidavit?
My affidavit is 7/11/2024.
What did they say in the affidavit?
My lord, kindly turn to my lord,
My affidavit, my lord. My lord, I have said, my lord, that there was consumption, and my lord, we said that there are equipments which cannot stop. They have run. He has wheeled energy. He has consumed energy from the grid. Also, so it was not a situation where there was complete shutdown. That's what I pointed out, my lord, in the affidavit.
Para 7.
Yes. Para 6 and 7, my lord, I have mentioned. I also have mentioned, my lord, that this minimum charge is not something which we have demanded at all. It's demand charges as in the tariff order. The clause which my lord pointed out in the contract, lord, was pertaining to demand charge. The question posed to me was, have you claimed any minimum charges, which is at clauses at page 24, clause 3 of the writ petition.
Yes.
But there is no minimum charge which is claimed. I've shown the bill also. Demand charge arises from the tariff order, my lord. I will point out, I have copies of tariff order. It
What
is,
do you mean by demand charges under the tariff order?
my lord, calculating tariff for HT consumer, he's a HT2A consumer. In the calculation of tariff, there is a provision for demand charge. So, my lord, that is calculated based on the contracted demand.
That is again, that would be a minimum charge, isn't it?
My lord, they make regulation makes a distinction between minimum charge and also demand charge, my lord. There is some calculation difference. If, my lord, I can point out, my lord, from the regulation itself, that there are two different concepts altogether.
When this agreement was entered into, what was the concept of a minimum charge? Whether you use electricity or not, you'll have to pay the minimum charge. Now, if this demand charge is on the basis of a contracted demand
Yes.
that they had made, it would be a minimum charge, isn't it?
Lord, there are two, Lord,
Because it's not based on the consumption then.
Even if my lord, I have to keep that infrastructure and energy available, because at any given point of time, it is possible to
That is
make a demand for that energy.
That is a minimum charge, isn't it?
Lord, minimum charge is a different, kindly see, my lord, the regulation. They are
maybe quite similar, my lord, but they make the difference between the two. Lord, in the what do you have there? In the regulation, supply conditions, page 2, my lord, 2.222. Demand charge refers to the charge levied to a customer which is based on the contracted demand and maximum demand recorded. 2.41 at page 3, bottom of the page, is a concept of minimum charge. Minimum charges means minimum charges payable under the tariff schedule in force from time to time.
What is the minimum charge under the tariff?
Kindly see now.
Tariff schedule.
Lord, tariff order extract I have produced. Tariff order. In that, Lord, HT2A tariff.
Page?
At page 40. Top of that page, demand charge rupees 210 per kVA of billing demand per month. So this is, my lord, what is there in the rate schedule.
So this is the minimum charge, isn't it? Whether he uses the power or not. He has to pay you 210 rupees per kilo kVA.
Yes, my lord, that is the contracted demand. But the concept, my lord, is of a minimum charge and a demand charge is not because there are separate.
What is whatever be the nomenclature. This is not based on this consumption.
This is based. Its production due to COVID and consumed the bare minimum electricity for lighting, security, CCTV for the equipments which cannot be shut down. So as Lord, I had pointed out, my lord, that this is an industry where industry cannot shut down at all because this is a rubber, my lord, tire making rubber based industry. So they admit, my lord, that the factory was running.
No. Equipment which cannot be shut down.
Yes. So basically, my lord, equipments could not be shut down, which means that they were in running condition. Therefore, the consumption.
No, but
there is a slight dip, my lord. There is some dip in the consumption, but it is not a situation where, my lord, there was complete shutdown. There is, my lord, equipments are on and it could be used at any given point of time.
I was given the impression by you that the factory was run.
It could have been run.
The production did take place. Therefore, they're not entitled for the benefit under the contract. Now, if they were to say that certain machineries could not have been shut down, for which electricity was consumed, that will not tantamount to saying that there was production going on.
My lord, because they said, my lord, nothing was happening there. I was able to point out, my lord, that there was consumption that was happening, and it is not small consumption. It is, my lord, a large consumption that is happening. He is wheeling energy. He is taking energy from me. Both are being used.
What do you mean by wheeling energy? He was produced?
He is buying power from outside, from independent agencies also. He admits the fact that he was getting energy from outside the grid also. Independent power producers who are selling energy to him. And also he is taking energy from me.
That consumption in that period as compared to the time when he was not wheeling was more or less the same, or was there?
But it's less. It is less.
By what percentage would it be less?
But they have given, my lord, in their affidavit, they have page 3 of their affidavit. We are now concerned, my lord, with April.
2020, there are two installations.
We are concerned with,
April 2020.
no, but there's a
March.
drastic reduction both in the wind energy as well as in the.
There is
consumption.
reduction. There is reduction, but my lord, it's not a complete shutdown.
Still drastic from 25 lakhs to 70,000 is a drastic reduction.
25 lakhs to, yes, my lord.
I mean, 25 lakhs in March.
Oh,
In March also, we worked only for 3 weeks. But earlier, kindly see, my lord, for the month of December,
For April, we need to give them.
28 lakhs. Allah, there is reduction, my lord. So it was not a situation where there was complete shutdown. And my lord, the notification, my lord asked me a specific question, whether this was permissible to run the industry. For that, my lord, page 187, this 15th of April 2020 notification.
If the consumption has come down from 25 lakhs or from 30 lakhs to 91,000, then I'll have to accept this contention that
There is reduction, my lord. There is reduction in consumption.
not just reduction, massive reduction.
That may not make much of a difference, my lord. Going by the writ petition, my lord, I will be able to point out that his specific case before this honorable court is that government came with a notification, Annexure N, page 47, which made certain concessions in respect of different kinds of industry.
Even if we ignore Annexure N, he'll fall back upon the agreement. Agreement gave him that right, was regarding waiver of the minimum charges.
force majeure circumstance.
Minimum charge. Yes.
So for the month of April, why can't you consider? He is a regular consumer of yours, and if you treat him like this.
Lord, I cannot only make a concession so far as he's concerned, Lord. I'll have to globally do it. Government looked at it and made, my Lord, kindly see Annexure N.
The government, let's assume that it's a general circular. In the light of a contract that you have with them, you have to abide by the terms of the contract. How can you ignore the contract?
Lord, that's why I point out, my Lord, so far as, see, there is no challenge to the demand charges at all. He does not say, Lord, his grievance is Annexure A, Annexure N gave certain benefit to a MSME, which is waiver. When it comes to non-MSME, it talked about a deferment.
Annexure?
Annexure N, page 47. Lord, order dated 8/5/2020. MSME ಕೈಗಾರಿಕೆಗಳಾಗಿ ಗುರುತಿಸಲ್ಪಟ್ಟು ಆಧಾರವುಳ್ಳ writ petition, page 47.
No, the prayer is only to relax the payment of demand charge. Fixed charge.
Yes, the ground is, the ground raised in support of that, if you see, Lord, page 10, Roman 5, is that a concession is conferred on an MSME. You extend the same concession as a matter of policy to me also.
No, but they do rely upon the agreement, isn't it?
Yes, my lord, in both the cases.
Lord,
This is one of the additional grounds that they have raised. The main.
para
ground is
3,
the
my lord, they
contract.
say that minimum charge is levied and therefore you waive that minimum charge is ground number 3.
What is this demand charge that you made for the month of? April?
Same amount, my lord, consistently the same amount.
That is as per the tariff order, my lord.
16 lakh 95,000. In one case, 18 lakh 74,000
Only
rupees in
refund
another
16
case.
lakhs 95,000.
Oh.
No, if I follow the petition, this is all that will be refunded.
No,
16
no,
lakhs
this is so far as he's concerned, my lord, but I will have to apply this to all over the state, which means that, my lord.
I don't know whether you have contracts with the other consumers.
Yes, my lord, without contract, I cannot supply.
You have, then you are bound by the contract.
Then, my
Okay,
lord, I will have, my lord, a large revenue implication. Looking at that only, my lord, this policy is made. Now, my lord, as there is no challenge to the tariff order, there is no challenge, my lord, to this notification.
The tariff order, he says there is a contract which would override the tariff order in situations of force majeure.
Lord, if
Unless you show me from the tariff that even in the cases of act of war or some natural disaster, the consumers still have to pay. Or this is notwithstanding the contract that you entered into.
Lord, the contract itself refers it back to tariff to be determined from time to time, clause 9.
It is a tariff, but the conditions of supply are under the contract. If the contract says in respect of certain situations, you won't collect, you can't collect. If you do collect, it will be in accordance with the tariff order. That is all.
Lord, so far as contract is concerned, it does not say I cannot collect. It only says, my lord, that there could be a reduction if they ask for reduction. Now he is saying, my lord, I did not ask for reduction. But because he does not want a reduction in the demand, it is only temporary. Therefore, he wants that to be granted as a concession to say that for those months, he wants waiver of those demand charges. So that is how, my lord, even if we read, my lord, clause 3, on which, my lord, he's placing reliance upon, page 24. Reduction in minimum charges, page 24.
Yes.
If at any time consumer is prevented from receiving and using electrical energy supplied under this agreement, either in the whole or in part, owing to causes like war, mutiny, riot, earthquake, hurricane, strike, tempest, and accident to machinery, or if the supplier is unable to supply power for the reasons stated above, the contracted demand for such period shall be altered accordingly, provided due notice of such cause or extent of such reduction sought for is for the full billing month. So this is the provision, my lord, that is there. And kindly see 9 at page 26. Payment of power supply charges, taxes, etc. From the date of commencement of supply until termination of the agreement, the consumer shall pay to the supplier for the energy supplied during the prescribed billing period at the rates specified in the supplier's tariff in the class of power supply in irrespective of the installation being in the service or under disconnection. So this is also the provision, Lord, which takes it back to the tariff.
Subject to clause 3. Clause 3 gives them that concession. Clause 9 mandates it whenever you use electricity, it will be as per the tariff order. That is all. You can't relate the two.
Lord, I'm only saying, my lord, that the demand charge is relatable to clause 9 because it is directly linked, my lord, to the tariff order, which I've been able to show, my lord, that there is there are two distinct concepts.
At best, I can make an observation that nothing said in this order would be treated as a precedent for you to take some making not only in respect of this particular contract. Something like that. If
Lord, he is a very big industry, and for 1 month, my lord, he is not shown what is the great financial distress that will be caused to him.
He will also put the same argument to you.
Of course,
also
very big supplier.
And losing 16 lakhs would not be.
No, my lord. Then, my lord, I being state, my lord, I will have to hold the same scale, my lord, when it comes to others also. So if it's because there is he does not use fully the demanded supply at that point of time. If he is supposed to, my lord, this can happen at any point of time. So if that is to be, my lord, construed as a situation where he should get this concession, my lord, then others, my lord, everybody else will also, my lord, make a demand. That then, my lord, it is the situation, my lord, is that, for example, my lord, these are all intertwined in this sense. For example, my lord, if there is a thermal generator, for example, my lord, UPCL, Udupi Power, my lord, I have a PPA with him for taking so much energy. Now, my lord, I have to take that energy and pay at that particular rate. Lord, there is a two-part tariff so far as these industries are concerned. One is, my lord, fixed charge, and my lord, the other one is fuel-related variable charge. If I don't take power from them, which is contractually tied up with them, I have to pay them deemed generation, which is linked to the demand.
That is under the normal circumstances.
Even now.
Suppose there is a war. Then if there's a contractual clause which says in such an event, you don't have to pay that fixed charges. Then the situation changes, isn't it?
Lord, yes, my lord, if there is a specific clause to force majeure clause.
Unfortunately, there is a clause here.
Lord, that is, my lord, my only submission, my lord, is that is not pertaining to the demand charge, which is demanded. There are only two judgments, my lord, which relate to this. I showed Andhra judgment, my lord, which my lord has already seen. I've not produced it here, but I relied upon it earlier also. Andhra court not specifically went into this issue, page 87.
87 of?
This today's compilation, my lord, I've there's a copies of earlier given, but I've made it part of this compilation.
Southern Power Distribution Company, na?
I had pointed this out, my lord, on the first day also.
In this case, there was no such contractual clause.
Clause illa anta, that's what, my lord, there's no reference to such a clause, is what my lord pointed out.
Any other?
This, my lord, is then similar situation arose, my lord, in Gujarat.
Judgment is that?
Lord, Gujarat judgment, my lord, is at page 56.
56, sir.
56. Lord, the facts, my lord would find at paragraph 5 at page 58. May I read, my lord, para 5?
There also there is no
Similar situation.
Contractual clause.
contract illa.
I'll point out, my lord, this is the, my lord, demand, what was challenged. 85%, my lord, similar to what provision we have. Para 6, if the petitioner do not undertake any manufacturing activity for whatsoever reason, petitioners are bound to pay minimum contract demand charges. Then, my lord, next paragraph, para 7, my lord, refers to the shutdown, my lord,
No, show me the
close down orders passed.
Show me the paragraph relating to the contractual clause, which was existing in that case.
Lord, they refer, Lord, to a Supreme Court judgment and say, Lord, what would be the implication and why the extensions which are being sought cannot be granted. There is no reference to any force majeure clause specifically, my lord, that is dealt with in this.
This can't be a proposition, isn't it?
Lord, my submission is the government came out with a notification, Annexure N. They made a different categorizations and government granted, my lord, concessions of different nature.
My understanding is, suppose he is seeking for a concession under a government order. That is to be strictly construed. There is no question of ambiguity or interpreting that. If he falls within it, he falls within it, or else he is out of it. But if there is a contractual clause, his reliance on the government order is of really no consequence. His entire case would rest on the contractual clause, nothing else.
Lord, for that, my answer, my lord, is that what it contemplates is a minimum charge, which I have not levied. Minimum charge and demand charge are different concepts under the conditions of supply. I have levied demand charge in terms of clause 9 of the contract, which requires me to levy that. There is no challenge to either the tariff order or the demand charge that has been made. Therefore, my lord, my submission, my lord, is clause 3 will not have any application whatsoever. And in this case, my lord, of course, my lord, para 44 of this Gujarat judgment, which again relies, my lord, on Supreme Court judgment in Indian Oil Corporation. They are basically on the issue of if the government has come out with a policy and he is asking for waiver, in effect, my lord, what he is asking for is extending the waiver granted to only MSME for some period to him also. So, Lord, so far as that is concerned, my lord, it is covered by the Indian Oil Corporation, which is followed by Gujarat, my lord, exactly in the similar situation. And so far as clause is concerned, my lord, my submission is it is not governed by this. It is governed by the tariff order.
April 20 matra, April 2020.
Oh, 2020. And and last, my lord's order in Renuka Sugars, my lord, I am only relying on para 37 at page 212. Again, on the issue of rebate and policy. And can a consumer claim this as a matter of?
It's not a rebate, it's a contractual right.
No, it is not.
It is a
Now he's
contractual right that is exercising.
not.
I said,
To
if
that-
it was a government order, we'll have to construe it strictly. We can't extend the benefit more than what has been granted. That, to that extent, I'm with you, but
Yes.
this is not a rebate. This is a right that he has under the contract. He can enforce that right.
But my only submission so far as that is concerned is not that it's not
April
that charge.
2020 ಮಾತ್ರ refund ಮಾಡಿ. 16 lakh something.
ಇಲ್ಲ, ಎರಡು installation
There
ಇದೆ.
are two installations, my lord.
ಯಾವ್ದು ಯಾವ್ದು?
My lord, your lordship may kindly see my affidavit on page 3.
But then
57.
because it is not full shutdown.
HT 57 and HT 138.
138 for the month of March. In the case of HD 57, the 16,95,750
16 lakhs and 18 lakhs.
and 18 lakhs.
ಎರಡು.
Yes.
But because this is not a complete shutdown or reduction, the question of full waiver will not arise. Therefore, my lord,
No, if
my
you
lord
don't
comes,
dispute is the fact that for a tire manufacturing company, they can't shut down the entire plant and certain electricity has got to be used. Then that minimal usage really would be of no consequence unless you say to that extent you will have to reduce.
no, it cannot be a full waiver.
Proportionately ಅಂತೀರಾ ನೀವು?
Well, at least my lord, it cannot be at no stretch of imagination could it be a full waiver at all.
No, see, he
Then my lord, that has to be worked out.
he was forced to undergo this. It was not his own making.
No,
If
he
had
could have run.
If it contributed in any way to this kind of situation, then he is out. This
But-
was something which everybody faced,
Correct.
including
So,
him. And if he does not run the factory at all, and yet you ask him. to
Lord,
pay the
he
contract.
makes of course, consumption shows that there is a reduction. To answer my lord's question, my lord, as to whether he could have run the industry, that is provided in my compilation, my lord. I have produced the government order when it's in an industrial area and an industry. There is provision 15 for running the industry.
Correct, but how will the workmen come?
It provides for it. It's clause 15 at page 187 provides for it, my lord.
You are not able to run the high court. You are expecting factory workers to come
Yeah.
and
We were working online, my lord. What they were doing,
they cannot work online.
They can't work online.
Lord, they might have been supplying, etc. My lord, manufacturing might have got affected to a large extent.
April 2020 for those two, for
Yes.
those two installations and directly.
No, it can only be, my lord, then, my lord, he has given a representation annexure L. Let there be a direction, my lord, to consider this and give a proportional, my lord, rebate of some sort, because he gave a representation annexure L. His grievance is,
You tell me what is the proportion that is used, I'll pass an order only to that effect. Suppose you use 10% and 90% is not used. 90% you grant him that amount of that 34 lakhs, whatever. ಬೇಕಾದ್ರೆ memo ಹಾಕ್ಕೊಡಿ.
My lord, we have
That
given
is-
that also. Your lordship may kindly turn to
He wants
paragraph
to-
5.
He wants to collect some money at least from you.
Yes, yeah, my lord, in the case of one installation, 3.1%. In another case, it is 5.1%.
You want to fight for such a small amount?
like, for him also, my lord, it's not even a ant bite for an
ನೀವು-
industry like this. He
ನೀವು
wants to
ಇಬ್ರು
fight for
ಅಲೆ
it, my lord. I also, my lord, have to protect it to some extent, at least my revenue, my lord.
As a
Otherwise,
special case ನೀವು ಮಾಡ್ಕೊಂಡಿದ್ರೆ I would have given my seal of approval to it. I can't do that on my own. I have to go only by the legality of the demand. If you had agreed and if you had agreed to give him some concession, that was a different thing. As a one-off case, if you had given him some concession, as against 34 lakhs, 50-50 ಅನ್ನೋ ಅಂದಿದ್ರೆ maybe they would have agreed. ಏನು ಕೊಡಲ್ಲ ಅಂತ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ರೆ ಅವರು I can't be caught in between.
maybe we can explore, my lord, as to whether he can make some concession.
I'll
Make him
reserve
agree.
it. Whenever you tell me, I'll pronounce the order.
Yes,
Direct.
Seal number 27. Sri Venkatesh Narpatti. Seal number 27.
For the petitioner, Lordship had posted this for further hearing. To consider whether or not the petitioner has locus to file these petitions. And
Now that I have shut down 14A,
there is another development, not the court, two honorable division benches of this on court have held that we have locus to file it.
no, but if 14A goes, then what happens?
14A goes, my lord, then it opens Pandora's box. My lord.
14A goes, then this also would go, isn't it?
Would your lordship have this after 2 weeks? Great.
29th.
Great. And in fact, we are also waiting not for the
Extraction from mistake.
detailed order. Great.
Seal number 28, Sridhar Prabhu.
I'm appearing for the respondent.
I had shown, my lord, the letter,
On the
and
last
lordships had
occasion-
indicated that same may be, my lord, considered. Because if you are not installing the prepayment meter for whatsoever reason,
May I make a submission? On the last occasion, I have taken a time for the my lord regarding the prepayment meter. Now, as per the circular issued by the KERC, the bid has already taken place, my lord. And they have they have to give the contract, my lord, that was commenced and the bid has taken place, my lord, already. And the meeting was held up on today itself, my lord. They are having to finish that prepayment meter. They are going to do it, my lord, within a 4 to 6 months. My lord.
For 6 months.
Yes, my lord. Because ಅದನ್ನ
I am also,
ಮಾಡ್ಬಿಟ್ಟು ಅದ್ರದ ಎಲ್ಲ ಜನರೇಟರ್ ಎಲ್ಲಾನು ಚೇಂಜಸ್ ಮಾಡ್ಬೇಕಾಗತ್ತೆ ಅಂತ ಹೇಳಿದ್ರು ಅವ್ರು ನಂಗೆ ಇವತ್ತು.
You want to file a memo, shall I record your statement?
Allah,
You can
Ali
record.
Tanka, lordships may, that is why, my lord, they are also aware, page 4 of the memo that I filed, that arrangement can continue. Whenever, my lord, they come out with the meter, they can install it and take it.
Security deposit 5% and
How?
ಅಲ್ಲ security.
Page 4
My
of
lord,
my memo. my lord.
That only I am making the submission. Whatever the circular issued by the KERC, my lord, based on that, we have called for the tender. Now the,
until such time.
Yes,
yes, my lord.
that's all I am praying for. They are also aware, page 4 of my memo. my lord.
Clause para 7.
Yes. If the prepayment facility is not,
At half monthly energy charges in advance without insisting any security under section 47 1 year.
that's all I am asking. That's all I am asking. And I have already paid that amount.
My lord, this is the, as per the KERC rules, my lord, wherever there is a new connections, my lord. For the new connections only, there is a prepayment meter and permanent meter.
Illide are very new connections can.
They have produced, that's
Allah, if I have a meter, I can also ask switch over to prepayment meter, isn't it? ನಿಮ್ಗೆ ಅನುಕೂಲ ಅಲ್ಲ ಪ್ರೀಪೇಮೆಂಟ್ ಮಾಡಿದ್ರೆ.
ಅದೇ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಈಗ ನ್ಯೂ ಕನೆಕ್ಷನ್ಸ್ ಮಾತ್ರ ಅದು ಸರ್ಕ್ಯುಲರ್.
Are your rules? They have made that rule. Even first they introduced only for temporary connection. my lord. That's their discretion. ಅವ್ರು ಯಾರಿಗ್ ಬೇಕೋ ಆ ತರ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ತಾರೆ.
ಅಲ್ಲ.
Rules don't provide it, law doesn't provide it.
My lord, as per the circular issued by the KERC on 6/2/2024.
Now, let us read section 47. Does it confine the application of prepayment only to a category of consumers?
No, my lord, we are providing the prepaid meters and
ನೀವು ಹೇಳೋದು ಹೊಸ ಕನೆಕ್ಷನ್ ಮಾತ್ರ ಕೊಡ್ತೀವಿ ಹಳೇದು ಕೊಡಲ್ಲ ಅಂತಿರಲ್ಲ.
ಈ ಸರ್ಕ್ಯುಲರ್ ನಲ್ಲೂ ಇಲ್ಲ ಅದು.
I am existing postpaid consumer. Suppose you have prepayment facility, I'll switch over.
yes, my lord.
How can you say no, I'll give it only to a new connection?
No, my lord, I'm not saying that one, my lord. They are about to hold the meeting on today, my lord. What the decision with the minister, my lord?
You take your time.
Minister,
Yes,
Until
ma'am.
then you will suffer the consequences.
All the concerned,
This 4/6/2024.
yes,
Yes.
my
This
lord.
order you accepted, you are bound to accept.
Yes, my lord.
This is half monthly charges.
ಅಷ್ಟೇ.
ನೀವೇ ಮಾಡ್ಕೊಂಡಿರ್ತಾನೆ.
ಅಲ್ಲ, ನನ್ಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿರೋದಷ್ಟೇ ಸ್ವಾಮಿ. ಇವತ್ ಮೀಟಿಂಗ್ ಇದೆ, ವೆದರ್ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಮೀಟರ್ಸ್ಗೆ ಕೊಡ್ಬೇಕು ಅಥವಾ ನ್ಯೂ ಮೀಟರ್ಸ್ ಕೊಡ್ಬೇಕು ಅನ್ನೋದು ವಿ ವಿಲ್ ಮೇಕ್ ಅ ಡಿಸಿಷನ್ ಅಂಡ್ ವಿಲ್
Read that letter dated 6/2/2024.
Para 7.
if the prepayment facility is not put in a place on 1/7/2024, the
No,
consumer.
read from the beginning.
Yes. Please find the enclosed here with the proceedings on the meeting held on
All new installations.
from 1st April 2024, distribution licensee shall provide the smart meter to all the new installations with swappable and models with an option of swapping GPRS and FR communication systems. However,
So if the regulator says only for Prabhu,
new
the
installations.
regulator only says for new
No, no,
installations.
that what they say is, my lord, 114, it is compulsory. It doesn't prohibit the existing consumers from opting.
Which clause says?
Existing
relates-
No, no, this is letter, my lord. The act itself says,
But they
yes.
are bound by what the regulator says.
Yes, my lord.
No, the,
Regulator says only for new
no,
installations.
no, 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 my lord, I'm sorry. No, no, lordships may see the regulations itself. Lordships may see, my lord, the regulation, this letter is in furtherance of that. Lord may see the petition rejoinder that I have filed and the regulations therein, my lord. Regulation, page 20, KERC prepayment meter regulation antane madidare.
ಅದ್ರಲ್ಲಿ?
That rejoinder that I have filed on,
Page?
yes, that is, my lord, page number 20 it starts and 23 is the applicable provision, my lord. Adralli existing and new anta bardidare. 3, my lord, regulation 3, applicability of procedure for availing facility under prepayment meter, prepaid meter. Lordships get it, my lord. Page 20, annexure K of the rejoinder submissions that I. Lordships have it. Sir.
These are draft regulations.
Allah, this is final only. Ide fine. Final. These are in force. Page 23, ink page 23,
Regulation
3.1.
three to new and existing.
How,
ಅಂತ ಹೇಳ್ತಾರೆ.
ಅದೇ, that's what, make an
Regulation
application for so and so.
For that reason only, my lord, they have held up the meeting today with all the
But then
concerned
you'll be
officials.
bound to take only half monthly charges.
This is from 6/3/24.
6/3 neither.
Yes,
This was before that then?
yes. That was, my lord, this one.
6/2/2020.
There are statute regulations now in force. That letter would have no consequence.
Aದೇ, that's what I'm saying. That letter has no consequences.
So ಈಗ
ಇದ್ರ ಪ್ರಕಾರ ಅವ್ರು ಕೊಡ್ಲೇಬೇಕು, ಕೊಡ್ಲಿಲ್ಲ ಅಂತಾದ್ರೆ
ಏನಿದೆ?
ಅದು full refund ಅದು that your lordships will find 47, my lord. It has to fall security. ಇದರಲ್ಲಿ regulation 4 of that same regulation 4, in case new connection with prepayment meter. ಅದರಲ್ಲೇ ಇಲ್ಲಿದೆ ನೋಡಿ. ಇದರಲ್ಲಿ in case new connection, lordships may ignore that, provided that in respect of existing consumer migrating, lordships have it, my lord. Regulation 4, migrating prepayment metering arrangement, the security deposit with the so and so shall be adjusted against the last bill, including arrears.
What is the security deposit that is required under 47(5)?
That I paid, no. That initial security deposit I have to pay at the time of collection. Connection ತಗೋ ಈಗ ನನ್ನ ಹತ್ರ ಆ DD ಇವ್ರು ಕಟ್ಸ್ಕೊಂಡ್ರಲ್ಲ, ಅದು UPI ನಲ್ಲಿ ಬರೋದಿಲ್ಲ, DD ಕಟ್ಬೇಕು ಅಂತ ಮಾಡಿದ್ರಲ್ಲ, ಅದೇ. Provided that in respect of existing so and so migrating to prepayment meter so and so, security deposited with the licensee shall be adjusted against the last bill arrears, if any, and balance, if any, so and so shall be settled in full force at once. Provided further that case of conversion of so and so against security deposit shall be paid by the consumer in addition to other.
ಅಂದ್ರೆ
ಅದೇ
prepaid to post.
ಆ ಕನ್ವರ್ಷನ್ ಚಾರ್ಜಸ್ ಪೇ ಮಾಡ್ಬೇಕಂತ. That I have already paid.
Then you can't collect security charges at all now.
That's all.
At least under the letter.
ಅದಾದ್ರೂ
you could
ಬರ್ತಿತ್ತು.
collect half monthly charges. Now you can't do anything.
Lords Magna, today they have a meeting regarding this subject only, my lord. 10 days time may be granted. In the meanwhile, what will be the outcome? I'll make a submission. That was the instructions they have given me. Ma'am, whether existing, we have to migrate it for the prepaid meter or not, we are having the meeting today with all the concerned officials.
I
They
wrote
said
down,
with
my
the
lord,
MT, my lord.
deposited the entire amount as directed by your lordships. I did not stand on formalities even for UPI.
They told me,
ಈ
my
ತರ
lord,
ಮಾಡ್ಬಾರ್ದು.
they're agreeing for the, whatever the
Agreeing
circular
on-
issued by the KERC. We
Circular
can
ಅಲ್ಲ
take the meeting.
regulation.
Based on that, we will take a decision, my lord, they said.
I bore
That
down,
was
my
the
lord,
only
whatever your
instructions
lordships
I
said.
have received.
No, but then you'll be disobeying the KRC order, isn't it?
Regulations.
The first one was until the regulations came in, you would take only half monthly charges. After the regulations, nothing. Now you are again demanding a security deposit.
Paid also, already paid. DD
But
is,
what is the security deposit that you paid?
yes, that is
16,000,
not 13,000 something and initial, that is additional security deposit paid. Both put together, my lord, they have the amount.
The total security deposit you have paid.
Total security deposit is in the range of 16,000 rupees. Subject to correction.
16,000,
16,000 ಅಂದ.
That is for 3 months. Huh?
2 months.
2 months.
2 months.
You will have to take 4,000 instead of 16,000.
ಅಲ್ಲ ಇದ್ರ ಪ್ರಕಾರ ರೆಗ್ಯುಲೇಷನ್ ಪ್ರಕಾರ ಅದನ್ನ ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಬೇಕು ಅಂತ.
ನನಗೆ ಒಂದು ಮತ್ತೆ ದಿವಸ existing whether they are doing.
The regulations are there.
Yes, my lord. Even I'll ask
It
them.
is
The
post of-
regulation says that. For that reason, they held up the meeting today, my lord.
Held up alla adi.
They are
Have it on Wednesday, you get instructions by Wednesday, or else I'm.
next Friday, my lord.
But I'm proposing to pass an order that you will comply. with this.
Next Friday, my lord.
I can only adjust it, for harmonious construction, this and the letter together, and
Yes, sir.
strictly speaking, he is not liable to pay anything.
Two division bench judgments also.
I'll.
And UPI also, my lord, I compromised. I
That
bowed
4
down.
to 6 months time, I'll accept, but until then, you'll only collect half monthly charges.
Apala ತಗೋಬಾರ್ದಂತ act ಅಲ್ಲಿ ಬರ್ತದೆ.
ಅಲ್ಲ, actually, they ಇನ್ನು ಕೊಟ್ಟಿಲ್ವಲ್ಲ. In the event you have a new prepayment meter, then you don't
No,
have to pay.
that is not new. Lordships may see 47.
If
In
you-
case the,
If you
yes,
are given a prepayment meter now, even for an existing consumer, you don't have to pay.
yes.
But as of now, you are not paid.
No, my
You're
lord.
not given.
My lords may see, the what is, lordships may see, my lord, subject to provisions of this section, distribution licensee may require, who requires a supply of so and so under 43 to, I am reading, my lord, 47, as the case may be. Idrallene, if a person referred to in 2, if I am ready to take, my lord, the supply, then, my lord, they shall not insist on security ಅಂತ ಇರೋದು ಹೊತ್ತು ಅವ್ರು ಕೊಡೋದು ಬಿಡೋದ್ರ ಮೇಲೆ ಇಲ್ಲ.
As of this new regulation which have come into force from March,
Yes,
will exempt you from paying any security deposit if you are installed a prepayment meter.
if I opt for it, my lord.
No, if you opt and if they give you,
Yes, Allah, your lordships may, provided that in respect of existing consumer migrating to prepayment so and so, the security amount deposited with the licensee shall be adjusted.
correct, first ನೀವು prepayment meter ಹಾಕ್ಬೇಕು.
Migrating again.
First prepayment meter ಹಾಕಿದ್ರೆ then this will come into play.
ಹಾಗಾದ್ರೆ what I am
Half monthly charges is all that you will have.
ಅಲ್ಲ, ಮುಂದೆ ಅಲ್ಲ, adjusted ಅಂತ last bill, it is the entire security deposit has to be adjusted.
Comment it is given to you,
Yes.
prepayment meter is installed, then the question of adjustment.
No,
Until then, that letter of 6/2/2024 asking you to pay half monthly
Allah,
charges.
no, my lord, I'm so sorry, my lord. The act says, if I am ready to take supply under the prepayment meter is the act provision. Here also, my lord, here also, it only says existing consumer migrating means, otherwise, my lord, I'll myself install it, take their vendor approval and install it. If they stand on formalities, let them permit me to install it. I will take it, their approved vendor in the nane hakbudti. And they will do
Instructions.
I'll.
Hence, Wednesday, my lord,
I
because
propose to follow that letter
Yes,
till you install the prepayment meter.
I'll.
and that UPI also, my lord, that issue has paled into oblivion. It's all surfaced because of that. They had accepted under UPI, I would not have even insisted.
You also achieved your objective, isn't it?
No, they achieved their objective through me. ಈಗ ಟೆಂಡರ್ ಕರೆದು ಅವರಿಗೆಲ್ಲ
Followed that, comply.
For admission, seal number 29.
My lords, counsel appearing on behalf of the petitioners.
What is the CP about?
My lords, as seeked in the serial number 25, senior is unwell, so kindly be adjourned for the day, my lords.
Your lordship, we have already filed the Tahsildar report, your lordship.
In indigent percent.
No, your lordship. Page number. Kindly go through that, this thing. Tahsildar report. ಈ ಬಗ್ಗೆ ಉಪ ತಹಸೀಲ್ದಾರ್ ಉತ್ತರಳ್ಳಿ ಹೋಬಳಿ ನಾಡ ಕಚೇರಿ ವರದಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಶ್ರೀಮತಿ ರಕ್ಷಿ ಸರ್ ಅವರು ಪ್ರಸ್ತುತ ಅವರ ಅಜ್ಜನ ಮನೆಯಾದ ವೈಭವ್ ನಿಲಯ ಸೋಹನ್ಸೋ ಇವರ ತಂದೆ ಡಾಕ್ಟರ್ ರಾಮಲಿಂಗಪ್ಪರವರು ಪಶು ವೈದ್ಯರಾಗಿದ್ದು, ತಾಯಿ ರೇಣುಕಾಂಬರವರು ತಮ್ಮ ಜೀವಿತಾವಧಿ ಶಿಕ್ಷಣ ಇಲಾಖೆಯಲ್ಲಿ ಸೇವೆ ಸಲ್ಲಿಸಿದ್ದು 31/1/2011 ಮರಣ ಹೊಂದಿರ್ತಾರೆ. ರಕ್ಷಿತಾರವರು BE ವಿದ್ಯಾಭ್ಯಾಸ ಪೂರೈಸಿ ಹಾಲಿ ಹ್ಯಾಸ್ ಡಿಜಿಟಲ್ ಸೊಲ್ಯೂಷನ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ ನಲ್ಲಿ ನೌಕರಿಯನ್ನು ಮಾಸಿಕ ರು 21,800 ಪಡೆಯುತ್ತಿರುವ ಬಗ್ಗೆ ಮಾಹೆ ವೇತನ ಪತ್ರವನ್ನು ನೀಡಿರುತ್ತಾರೆ. ಡಾಕ್ಟರ್ ರಾಮಲಿಂಗಪ್ಪ ಗಾಣಗಿರವರು ರಕ್ಷಿತಾರವರ ತಂದೆಯಾಗಿದ್ದು, ಇವರ ಆಧಾರ್ ಕಾರ್ಡ್ ಸೋ ಅಂಡ್ ಸೋ ರೇಣುಕಾಂಬ ಚುಂಚಘಟ್ಟ ಮುಖ್ಯ ರಸ್ತೆ ನಮೂದಿಸಿ ಇವರು.
What is the suit?
And they are also having, they are seeking for relaxation of that court fee 45,000, your lordship.
What is the suit for? Partition.
Yes, yes.
That's court fee.
Court fee relaxation. Declaration suit, your lordship, in OS number 4964. And even they're having ಎರಡು ಅಂತಸ್ತಿನ ಕಟ್ಟಡವಾಗಿದ್ದು ಬಾಡಿಗೆ ಮನೆ ಇಸ್ಕೊತಾರೆ.
Realist. 22nd. Seal number 30. Shankar Narayan Bhatt.
ಇಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ?
Husband has filed a petition for dissolution of the marriage at Chandrapatna Court.
From Priyapatna to Chandrapatna, my lord.
Prepayment to Hunsura.
Hunsur Chikka,
My objection is, my lord, after marriage, my lord, there are two issues, my lord. ಎರಡು ಮಕ್ಕಳು, they are staying with the parent, father, my lord. Father is an, my lord, health inspector, is working in Irisave, my lord, and also looking after the two children. By lifting two children, my lord, she went to parental home.
Children are with you.
With me, my lord.
For that allegations, counter allegations are there. She was thrown out of the house and.
I'm not in the merits. If he has two children to take care of, and if
two-
he's staying at Irisave, why should I transfer it to Hunsur? You can come to
One
Chandrapatna.
submission, out of two children, my lord, one son died about 4 months back, my lord. Because he was not keeping good health, but under mysterious circumstances, he died. And when the petitioner went there to see the body of the wife, she was severely assaulted and she was not allowed to see the body at all. And she was.
What is there to show that she was assaulted? Did you lodge any?
FIR was filed, my lord, right? In this, after filing of the petition, this
The
is.
fact that an affair was registered?
That's what I was informed.
I have no knowledge.
If she has been assaulted, then you'll have to go to Hunsur.
No such thing has been happened, my lord.
If there is an FIR, I'll send you to Hunsur.
You'll get instruction.
You have the copy of the FIR?
No, my lord, I don't have right now. Right. And further, my lord.
Produce the FIR, I'll transfer it to Hunsur.
If I last. Here in another, to reach from Hunsur, this.
There is no FIR, you will come to Chandrapatna. If there's an FIR as suggested by you, then I'll transfer it.
Nevertheless, my lord, of course, I'll ask my party, but the fact, make one submission.
I'll apply the same yardstick to the husband also. If he has a child to look after, he can't travel, you will have to travel.
No, the child is already about 8 years, 9 years old and attending the school, and their family members are there. Whereas the difficulty of the petitioner is to reach from Hunsur to Chandrapatna, it will take about 6-8 hours, my lord. If he starts at the morning 6 o'clock, she'll be able to.
If you have an FIR, that is.
Yes, I'll get. 2 weeks, my lord.
Wednesday.
Oh, my lord,
31, Shri Madhusudan.
Transfer from Chikmagalur to Bangalore, my lord.
Correspond, I have no objection, my lord. My only request is to dispose the MC as expeditiously as possible.
One case irodu?
My lord, actually what happened in this case, already MC was filed in Bangalore and it was.
No, apart from this, is there any other case?
There are 2 cases in Bangalore, my lord.
Two
One is
cases in
criminal miss
Bangalore.
and one is for maintenance.
Chikmagalur ಒಂದೇನೇ ಇರೋದು?
Chikmagalur ಒಂದೇ ಇರೋದು. Husband.
The wife is before this court seeking for transfer of MC 60/2024, which had been instituted by the husband at the Principal Judge Family Court, Chikmagalur, to the Principal Judge Family Court at Bangalore. So counsel for the respondent husband permits that the husband has no objection for the said request. In view of the above, MC 60/2024, pending on the file of the Principal Judge Family Court at Chikmagalur, is withdrawn and transferred to the Principal Judge Family Court at Bangalore. Since both the parties are present, they shall appear before the Principal Judge Family Court, Bangalore on 15th December. Bill number 32. Yes, Digan. ಎಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ?
Yes, Digan. RB Deshpande, correspondent.
our husband transfer, my lord.
ಲಕ್ಷ್ಮಿ ಅಂತ ಇದೆ. Petitioner is the wife.
DP 183.
ನೀವು ಹಸ್ಬೆಂಡ್ ಅಲ್ವಾ?
DP 183. Sorry, my lord, by mistake, file ತಗೊಂಡು.
Mysore to Bangalore.
by mistake, misplaced.
ಇಲ್ಲ ಬೆನ್ ಏನಂತ ಬಿಡಿ ಮೈಸೂರು ಮಕ್ಳಿದಾರ?
Lakshmi Sandeep.
The wife is before this court seeking for transfer of MC 888/2023, which the husband has instituted in the court of the first additional principal judge family court Mysore to the family court at Bangalore. The wife states that she is residing with her parents at Bangalore and it will be difficult for her to travel to Mysore. In my view, this request of the wife is reasonable and will have to be accepted. Consequently, MC 888/2023, pending on the file of the additional principal judge family court, Mysore is withdrawn and transferred to the family court at Bangalore. Since both the parties are represented by counsel, they are directed to appear before the family court, Bangalore.
16th December.
To take further instruction.
16th December. Seal number 33, Srimati Rachita Rajshekar, appearing for the petition in this case.
For its one, my lordship.
ಎಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ?
It's from Bangalore to Mangalore.
Objections ಇದೆ my lord. Next short date ಅಲ್ಲಿ ಕೊಟ್ರೆ senior
Objections.
ಹುಷಾರಿಲ್ಲ. ಅದು transfer ಗೆ has the respondent is a doctor. He is not able to like attain the cases in Mangalore.
And wife is also a doctor.
Please, my lords, at Mangalore.
Will also have the same problem.
Now she is, presently she is
He is
employed.
a sick.
Presently she is employed in Mangalore, my lords, along with 2 children.
My lordship short date ಕೊಟ್ಬಿಡಿ. Senior ಗೆ ಹುಷಾರಿಲ್ಲ ಅದಕ್ಕೆ
Madam.
ಬರಕ್ಕಾಗಿಲ್ಲ my lord.
The wife is.
Objection file ಮಾಡ್ತಾರೆ.
ಏನ್ objection ಹೇಳಿ?
ಅಲ್ಲ transfer ಗೆ
Consider objection, that is no objection. He has 2 children to take care of, isn't it?
yes my lord.
Then the wife is before this court seeking for transfer of MC 307/2023, which is pending on the file of the principal judge family court Bangalore to the court of the first additional principal judge family court in Bangalore. The wife contends that she is a doctor who has been employed in Bangalore and her 2 children aged 10 and 10 years and 2.5 years are admitted to schools at Bangalore, and therefore it would be impossible for her to travel to Bangalore to defend herself. In my view, this request of the wife is genuine and acceptable, and accordingly, MC 307/2023, which is pending before the principal judge family court Bangalore, is withdrawn and transferred to the first additional principal judge family court at Bangalore, since both the parties are charged.
17th December. Seal number 34. KB Bhoja.
Appear for petitioner in this case. Bangalore to Haveri ಗೆ transfer to
Bangalore to
Haveri.
Not for the respondent. Filed vakalat recently, not.
ಬಿಡಿ ಇದಕ್ಕೆ ಯಾಕೆ ಸುಮ್ಮನೆ?
ಅಲ್ಲ ಆಯ್ತು ಅಲ್ಲಿ I am told, my lord, there is threat, my lord, to his life. That is the reason, my lord,
ಏನ್ threat?
the marriage, my lord, is the second marriage to the respondent herein. Out of this, first wife died, my lord, during labor. And he has a daughter to take care and aged parents at Bangalore. He has filed the petition at Bangalore.
No issues with her.
No issues with her.
ಅಲ್ಲಲ್ಲ.
No issues with her.
ಮಿಸ್ಲೀಡ್ ಮಾಡ್ತಾ ಇದಾರೆ. ಫಸ್ಟ್ ಮ್ಯಾರೇಜ್ಗೆ ಮಗು ಇದೆ. ಅವ್ರು ಏನಂತಂದ್ರೆ ಈ ಸಪ್ರೆಸ್ಡ್ ದಿ ಫಸ್ಟ್ ಮ್ಯಾರೇಜ್ ಅಂಡ್ ವಾಟ್ ಸೆಕೆಂಡ್ ಮ್ಯಾರೇಜ್.
ಒಂದ್ ಮಗು ಇದೆ ನೋಡ್ಕೊಳಕ್ ಅವ್ರಿಗೆ. ಒಂದ್ ಮಗು ಇದೆ ನೋಡ್ಕೊಳಕ್ಕೆ.
ಅಲ್ಲ ಮಗು ಇದೆ ಸ್ವಾಮಿ.
ಬಿಟ್ಬಿಟ್ಟು ಅವ್ರು ಹಾವೇರಿಗೆ ಬರ್ಬೇಕು ತಾನೆ.
ಅಲ್ಲ ಅಲ್ಲಿ ಗ್ರ್ಯಾಂಡ್ ಪೇರೆಂಟ್ಸ್ ಹತ್ರ ಬಿಟ್ಟಿದಾರ ಅವರು ಮಗುನ.
ನಿಮ್ಗೆ ಪ್ರತಿ ಇಯರಿಂಗ್ ಕಾಸು ಕೊಡಿಸ್ತೀನಿ.
I will pay, my lord. I will pay the expenses, my lord, for her travel.
345 kilometers ಡಿಸ್ಟೆನ್ಸ್ ಇದೆ.
10,000 ರೂಪಾಯಿ ಕೊಡಿಸ್ತೀನಿ ಪ್ರತಿ ಸಲ. Every time you come 10,000. Whenever you come. ಲಾಯರ್ ಫೀಸು ಆಗುತ್ತೆ ಅದಕ್ಕೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ ಏನಂತಂದ್ರೆ ದ ಪೇರೆಂಟ್ಸ್ ಆಫ್ ದ ಪಿಟಿಷನರ್ಸ್ ಆರ್ ವಿಲೇಜರ್ಸ್ ಅನ್ಎಜುಕೇಟೆಡ್. ಏನು ಕೆನಾಟ್ ಕಮ್ ಅಲೋನ್ ಟು ದಿ.
10,000 ರೂಪಾಯಿ ಕೊಟ್ರೆ ನಿಮ್ಗೆ ನಿಮ್ಮ ಪೇರೆಂಟ್ಸ್ಗೆ ಪ್ಲಸ್ ಲಾಯರ್ ಎಲ್ಲಾನು ಆಗುತ್ತೆ. ಇಯರಿಂಗ್ ನೀವು ಯಾವ್ಯಾವ ಬರ್ತೀರೋ ಅವಾಗ ಕಾಸು ಸಿಗುತ್ತೆ.
ಅಲ್ಲ ಸ್ವಾಮಿ ಇದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ಸೈಟೇಷನ್ಸ್ ಆಗ್ತಾ ಇದೆ.
What do? You're a software engineer.
Yes.
So after
1000 is lower on the lower side. then.
And her presence, my lord. my
he's not
request is,
paying
my lord.
any maintenance also.
Is there an order for maintenance?
No, ಇಲ್ಲ. ಅಂದ್ರೆ ಫೈನಾನ್ಷಿಯಲಿ ಇನ್ಕೆಪಾಸಿಟಿ ಅದು. ಇದರಲ್ಲಿ
ನೀವೇನ್ ಮಾಡ್ತೀರಾ?
ಸ್ವಾಮಿ ಹೆಡ್ ನೋಟ್ ಅಲ್ಲಿ
ಅವ್ರೇನೇ ಇಲ್ಲ ಸ್ವಾಮಿ. She is a housewife.
ಈಸ್ ಹೌಸ್ ವೈಫ್
ಇದನ್ನೆಲ್ಲ ಇದು ಗೊತ್ತಿದ್ದು ಈ ವಿಚಾರ ಎಲ್ಲ ಗೊತ್ತಿದ್ದೇನೆ she gave her consent, my lord, for the marriage. And no, my lord, after that, my lord, she has started.
Have you made an application for maintenance?
No, my lord.
ಇನ್ನೂ ಇಲ್ಲ ಸ್ವಾಮಿ. ಜಸ್ಟ್ ಫೈಲ್ ದ ವಕಾಲತ್ನಾಮ ಇನ್ MC petition, husband petition. He is also filed the wakalat in my petition in the restitution of conjugal rights in the Haveri.
ಈ ಒಂದು ಹಾಕಿದಾರಾ?
ಹೌದು sir.
After this, my lord, they came, my lord, for the mediation. In the mediation, my lord, they it was not accepted. Only once, my lord, they came. During that process, my lord, they filed restitution of conjugal rights at Haveri.
You are
Two types.
You are prepared to concede for grant of maintenance. Then I'll transfer that restitution as well as this to Bangalore. If you are not, then either you have to go for that restitution case.
May I request, my lord, for Monday, my lord, I will contact.
Tuesday.
Please,
He
Tuesday.
is working with
Sorry,
a reputed
Tuesday.
company, drawing salary of more than 30 lakhs. Sir.
30 lakhs
30 lakhs.
per month.
ಹೌದು sir. ಅಲ್ಲ per annum.
30 lakhs per month ಇದ್ರೆ 20 ಲಕ್ಷ ಅವರೇ ತಗೊಳ್ಳಿ ಸ್ವಾಮಿ.
ಅವ್ರ ರೀಸನಬಲ್ ಮೇಂಟೆನೆನ್ಸ್ ಕೊಟ್ಟು ನಿಮ್ ಸಮಾಧಾನ ಇದ್ರೆ ವಾಲಂಟರಿಲಿ ಮಾಡಿದ್ರೆ
ಅಲ್ಲಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗ್ಬೇಕು ಸ್ವಾಮಿ. ಅವ್ರು ಯಾಕಂದ್ರೆ she cannot come alone without
Okay, I'll see that you are paid. Why are you worried? He has a small child to take care of. Realist. Reasonable compensation. Maintenance. Pay slip ತೋರಿಸಿ ಎಷ್ಟು ಕೊಡ್ತೀರ ಅಂತ ನೀವು ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿದ್ರೆ then I'll record your statement that you are willing to pay every month without prejudice to our right and then transfer.
Please.
35 adjourned, seal number 36.
Could it be on Wednesday, my lord? I'm sorry. Could it be on Wednesday, my lord? Wednesday. Obliged.
First part.
Yes. ಎಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ?
Belgaum to wife filed marriage through Belgaum to Bangalore. Belgaum to Bangalore.
What is your objection?
They are not filing any case, madam. She is also.
ಹಾಕಿದ್ರಲ್ಲ ನೀವೇ ತಾನೇ ಹಾಕಿರೋದು.
Now only divorce only. She is not filing any. If she mediation is done, it is welcome, madam.
ಆಯ್ತು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ರೆ ನಾಲ್ಕು ಕೇಸ್ ನಡೆಸಿ ಅಷ್ಟೇ ಬೆಳಗಾಂ.
Madam, Belgaum to Bangalore. Here.
I will transfer it as sought for. ನೀವು ಚಾರ್ಟ್ ಅಕೌಂಟ್ ಇಡ್ತಾನೆ. The wife is before this court seeking for transfer of MC 484/2023, which has been instituted by the husband and the family court Belgavi to the family court at Bangalore. It is the case of the wife that she has a 6-year-old daughter to take care of, who has been admitted to the BGS World School at Bangalore, and therefore it will not be possible for her to travel to Belgaum, which is about 500 kilometers away. So in my view, the cost shown by the wife is sufficient to transfer the petition as sought for. Consequently, MC 484/2023, which is pending on the file of the family court of Belgavi, is withdrawn and transferred to the family court at Bangalore. Both the parties are sworn.
17th December.
17th will have to appear.
Seal number 37, Srimati Sunita. Seal number 37, Srimati Sunita Singh.
For the petitioners, please, your lordship's wife's petition. Please.
Madam, ಸರಿಯಾಗಿ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
To be transferred from Haveri to Bangalore, please, your lordship. She's having a child. The divorce petition has been also pending in the High Court of Karnataka, please, your lordship, and the GNWC has
You're breaking up. I can't hear you.
been filed by him in Haveri, please, your lordship.
No, you are seeking.
Your lordship, my wife's petition for
Shall I pass it over? I can't hear you properly. Witnessed.
Seal number 38, Sri Sachin BS.
For petitioner, my lords. Bangalore to Nanjangudu.
My lord, he is working as a. ಮೆಟ್ರೋ ಸ್ಟೇಷನ್ ಕೆಲಸ ಮಾಡ್ತಾರೆ ಮೆಟ್ರೋ ಸ್ಟೇಷನ್ ಇಲ್ಲಿಂದ ನಂಜನಗೂಡಿಗೆ ಇವ್ರು ಕಷ್ಟ ಆಗುತ್ತೆ ಸರ್ 4 ವರ್ಷದ ಮಗು ಇದೆಯಲ್ಲ ಅವ್ರು ಹೌದು ಹೆಂಗ್ ಬರ್ತಾರೆ ಮತ್ತೆ ಮಗನ್ ಬಿಟ್ಟು ಇಫ್ ಶಿ ಇಸ್ ನಾಟ್ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಟು ಕಮ್ ವಿತ್ ಜಾಯಿನ್ ವಿತ್ ಹಿಸ್ ಯು ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ದ ಪಿಟಿಷನ್ isn't it? No.
Yes, for restitution of conjugal rights.
Yes, for what? For divorce?
Restitution
of conjugal rights. ನೀನು ಹೋಗ್ತೀರೇನ್ರಿ ಅವ್ರ ಜೊತೆ
ಹೋಗಿಲ್ಲ ಅಂತಂದ್ರೆ ಮ್ಯೂಚುವಲ್ ಅಲ್ಲ ಮ್ಯೂಚುವಲ್ ಆದ್ರೆ
ಅವ್ರಿಗೆ ಆಫರ್ ಮಾಡಿ ಇಷ್ಟು ಕೊಡ್ತೀನಿ ಮ್ಯೂಚುವಲ್ ಕೊಟ್ರೆ ಅಂತ 4 ವರ್ಷದ ಮಗು ಇದೆ
ಮಾತಾಡೋದು
ಮಾತಾಡಿ ಏನ್ ಮಾತಾಡೋದು ಇಸ್ ಶಿ ಪ್ರಿಪೇರ್ಡ್ ಟು ಗಿವ್ ಅ ಮ್ಯೂಚುವಲ್ ಡೈವರ್ಸ್
Yes, my lords.
then what is her demand?
I'll seek instruction, my lord. It may be refer for mediation, my lords.
Wednesday.
Please, my lords.
Seal number 39. Egade Ramchandra.
Connected matter, my lord, I am appearing for the wife, my lord.
Appear for the connected matter.
There are, that was my,
Why 2 petitions?
because husband also, I think, so recently, my lord.
Husband has filed the petition. First petition, CP number 433. In the other matter, I am giving a copy. This 433 notice agilla. Copy ಕೊಡ್ತಾ ಇದ್ದೀನಿ.
Take notice. ಎಲ್ಲಿ ಕೇಳ್ತಿರೋದು ನೀವು?
Chitradurga to, I am transferring from Chitradurga to Davanagere.
For the wife.
Wife, my lord.
ಎಲ್ಲಿಗೆ?
Chitradurga to Davanagere, man.
ನೀವು?
ದಾವಣಗೆರೆ to ಚಿತ್ರದುರ್ಗ.
Because, my lord, I filed the restitution of conjugal before the Davanagere court, my lord.
My lord.
He filed the 13-1 in the.
ಇದು ಒಂದು ಕಾಪಿ ಕೊಡ್ತಾ ಇದ್ದೇನೆ. Some mediation is possible. I will also try for let him consider. I request my friend to just
ನೋಡಿ ಏನಾರು ಆಗುತ್ತೆ ಅಂತ
explore the possibility because the once for all ಇದು ಬರೀ ಈ ಟ್ರಾನ್ಸ್ಫರ್ ಬಗ್ಗೆ ಅಲ್ಲ whole issue is to be. ಯಾಕಂದ್ರೆ ಒಂದು ಕಾಂಜುಗಲ್ ರೈಟ್ಸ್ ಇದೆ ಒಂದು ಇದಿದೆ.
Sir, 22nd. 22nd.
ಅಲ್ಲ ಇನ್ನೊಂದು ಸ್ವಲ್ಪ ಡೇಟ್ ಕೊಡಿ
29th.
ಆಗ್ಬೋದು.
Seal number 40, PP Nataraj.
Transfer petition. Bangalore to Karnataka, sir.
Bangalore to
Karnataka.
Karnataka.
ಹೌದು sir. Husband filed a divorce petition in family court at Bangalore, sir.
Issue notice. Petitioner is directed to take out notice on the respondent through his counsel in the trial court, informing him that the matter will be taken up for final disposal on 29th.
29th.
Interim state till then.
Seal number 41, Shiv Shankar.
Kindly pass over, my lord. Kindly pass over.
Department inquiry.
My department inquiry, copy serve ಮಾಡಿ.
Okay.
Seal number 42, Srimati PV Nidishri.
I appear for the petitioners, my lords. My lords, it's a petition for grant of letter of administration. It's been filed by the wife and the daughter of the deceased, my lords.
Wife and daughter.
Wife and daughter. They're the only surviving class 1 heirs, my lords, in the matter.
What are the assets?
My lords, there's 2 properties in Bangalore, my lords. The entire asset is worth 7 crore. 7 odd crores.
In view of the undertaking given by the petitioner that they would be willing to pay the maximum court fee of rupees 39,000. Notice to the deputy commissioner regarding verification of the valuation is dispensed with. Issue notice. Then,
My lords,
issue a
paper,
citation
yes,
to be published in Deccan Herald,
Hindu and the Udevani. The
Hindu and
Hindu and the Udevani Karnataka edition.
Bangalore edition and Udayawani Bangalore edition. Fixing the date of hearing as so on.
6th to 12, on or before 6th to 12, January 6th. For hearing the book. Seal number 43. R.V. Srinivas Reddy.
I'm for the petitioner, my lord. Yes, ma'am, lord. My lord, yeah, in this case, my lord, the petitioner had purchased the land from 3 acres land, which is survey number 44.
When did you purchase?
It in the 1996, my lord, 1996.
When was the land granted?
Yes, my lord, it's a land granted, but in the year of
Havaga.
1956, 1957, my lord. And
You have.
I have
2008 application for resumption.
And she was in the possession in that property for 12 years, my lord. And after the respondent number 3.
$5,600, 15 years alva. ಅದೇ ಅವತ್ತು 21st. 22nd.
22nd, madam. Number 44, Shri Prakash T. FR.
For the respondent numbers 4, 8,
I appear for the petitioner. The assistant commissioners and the deputy commissioners' orders are under challenge under the PTCL Act. Lord, the assistant commissioner records that the grant was in the year 1978. The deputy commissioner differs with him and says that the grant was in the year 1980-81. In the order of the deputy commissioner, it is very clear that it is a cut and paste, my lord. He refers to, my lord, before the assistant commissioner, my lord, the land measuring 3 acres in survey number 44 of Timmanhalli in Chikbalapur Taluk was the subject matter of the dispute. Lord, the deputy commissioner, my lord, may kindly peruse ink page 21, the DC's order at annexure B, relevant portion, my lord. At ink page 21, internal page 4. Assistant, may I read, my lord?
Yes.
It starts with the word, my lord, the assistant commissioner ಅವರು ಸಂಬಂಧಪಟ್ಟ ಕಡತವನ್ನು ಸಲ್ಲಿಸಿಕೊಂಡಿರುತ್ತಾರೆ. ಸದರಿ ಕಡತ ಹಾಗೂ ಪ್ರಸ್ತುತ ಕಡತದಲ್ಲಿನ ದಾಖಲಾತಿಗಳನ್ನು ಪರಾಮರ್ಶಿಸಿರುತ್ತೆ. ಲಭ್ಯವಿರುವ RR ಪ್ರತಿಯಂತೆ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ತಾಲೂಕು ನಂದಿ ಹೋಬಳಿ ತಿಮ್ಮನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 44 ಪೈಕಿ 3 ಎಕರೆ ಜಮೀನು ತಹಸೀಲ್ದಾರ್ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ತಾಲೂಕರವರ ಆದೇಶದ ಕ್ರಮಾಂಕ LND ಸೋನ್ಸೋ ರಂತೆ 15 ವರ್ಷಗಳ ಕಾಲ ಪರಭಾರೆ ಮಾಡಬಾರದೆಂಬ ಷರತ್ತಿನ ಮೇರೆಗೆ ರಾಮಪ್ಪ ಬಿನ್ ಮುನ್ಷಾಮಪ್ಪನವರಿಗೆ ಮಂಜೂರಾಗಿದ್ದು ಅದರಂತೆ MR ನಂಬರ್ ಸೋನ್ಸಂತೆ ಹಕ್ಕು ಬದಲಾವಣೆ ಆದೇಶವಾಗಿರುವುದು ವ್ಯಕ್ತಪಟ್ಟಿರುತ್ತದೆ. ರೆಸ್ಟ್ ಮಲಾಡ್, the rest 3 to 4 paragraphs, my lord, it is refers to some other order, some other land, some other survey number. My lord, may kindly peruse the next sentence, next paragraph. ದರಖಾಸ್ತು ಕಡತದ ಆದೇಶ ಹಾಳೆಯಲ್ಲಿ ವ್ಯಕ್ತಪಡುವಂತೆ ಕ್ರಮಾಂಕ ಸೋನ್ಸೋರಂತೆ ಗುಡಿಬಂಡೆ ತಾಲೂಕು. The dispute is relating to Chikbalapur. ಗುಡಿಬಂಡೆ ತಾಲೂಕು ಕಸಬಾಬಳಿ ಇರಿಗರೆಡ್ಡಿ ಹಳ್ಳಿ, ನಮ್ದು ತಿಮ್ಮಣ್ಣಹಳ್ಳಿ.
So the next three paragraphs are not relatable to your land. ಮೇಲ್ಕಂಡ ಮಂಜೂರಾತಿ ಅಂತೆ 20/11/81 ತಿಮ್ಮನಹಳ್ಳಿ ಗ್ರಾಮದ ನಂಬರ್ 44ರಲ್ಲಿ 3 ಎಕರೆ ಜಮೀನನ್ನು.
ಹೌದು, ಅದು ಎಂಟೈರ್ ಥಿಂಗ್ ಈಸ್ ಡಿಫರೆಂಟ್. 3 to 4 paragraphs. My lord, he says at ink page 22 internal page 5, my lord, the last paragraph, he refers to the very same alleged grantee. ಮೂಲ ಮಂಜೂರಿದಾರರಾದ ರಾಮಪ್ಪನವರಿಗೆ ವಿವಾದಿತ ಜಮೀನು ದಿನಾಂಕ ಲಾರ್ಡ್ ಇಂಟರ್ನಲ್ ಪೇಜ್ 22, internal page 5, ಲಾರ್ಡ್ ink page 22 of the DC order. The next page, the last paragraph. ಮೂಲ ಮಂಜೂರಿದಾರರಾದ ರಾಮಪ್ಪನವರಿಗೆ ವಿವಾದಿತ ಜಮೀನು 20/11/81. Lord, the assistant commissioner decides the list, my lord, on the basis that the grant was 1978. Deputy commissioner decides.
Which is the correct order of grant?
1978, 2011, 19.
What is the contradiction?
There is a delay of 16 years, my lord.
The grant is in the year 1978. The first sale takes place on 27/12/1989 within the not stipulated time, and not there is also no permission obtained as required under the notes.
But when did you initiate the proceedings?
2005, my lord.
2005.
2005-06.
ಸಡನ್ ಗುಡಿಬಂಡೆ ಯಾಕೆ ಹೇಳಿದ್ರು ಅವರು?
By oversight.
No, but
He's
even
fine.
if I ignore those two paragraphs,
Yes,
the
Lord.
last paragraph in page number 5
Yes, ma'am.
refers to the grant of 2011-81.
Please, ma'am.
Please, Lord.
No, not 81, my lord.
Survey number 44, 3 acres.
Lala. I send it back. Look at the last order, last paragraph.
Yes, my lord,
Is
81.
it 78 or 81?
78 lots.
AC says, my lord.
Oh. Ending is based on 81.
My lord, page 21, my lord, page 21, same, in page 4. DC order on him.
Like ಇದೆಲ್ಲ ಅವ್ರು ಹೇಳ್ಕೊಂಡು ಬರ್ತಾರೆ. Last, how do you answer para 22, page 22, last paragraph? ಮೂಲ ಮಂಜೂರಿದಾರರ ರಾಮಪ್ಪ ಅವರಿಗೆ.
Correct, my lord. ಮೂಲ ವಿವಾದಿತ 81 ದರಖಾಸ್ತು ಮೂಲಕ ಮಂಜೂರಾಗಿದ್ದು 95,000 ಚಿಕ್ಕಪ್ಪ.
And he says it is 78.
But whatever, my lord, even if it is assumed 80, my lord.
On application mind ಆಗಲ್ವಾ ಮೇಡಮ್?
My lord, he purchased in the year 89, my lord.
Correct.
Conditions violation, my lord, even 4-2 and 4-1, both
No,
the
but-
clause.
How is the finding now to be construed? Is it a finding that it was granted to a scheduled caste person here 78 or 81?
My lord, assistant commissioner, it's very clear, my lord, 78. Even assuming, my lord, 81 grant, my lord. 89 was the sale, my lord. 89 sale and
Except that-
15 years was the condition, my lord.
But should you not concur with the finding that this land was granted to scheduled caste in this particular date and this?
Yeah, scheduled caste and all, yes, I stated.
Lord,
my lord.
whether it is case is not followed, my lord. The division bench said that he has to give categorical find on 3 issues. He has to see the original grant or the contemporaneous documents.
For resumption was accepted by the assistant, was dismissed by the assistant commissioner.
Application was allowed.
Was accepted by the assistant.
Assistant commissioner allows, the deputy commissioner concurs.
While accepting the said application, the assistant commissioner recorded a finding that the land in question was granted to the original grantee on 2011-1978.
Please, ma'am.
So being aggrieved, the purchaser preferred an appeal. And in the appeal, it is noticed that the deputy commissioner makes a reference to land bearing serial number 28 belonging to, which is situated in Iregareddy Halli, and also refers to the grant made in favor of the original grantee relatable to, that is serial number 44, measuring 3 acres in Timnalli. There is an obvious contradiction or a discrepancy in relation to the land which the deputy commissioner was dealing with. It is also noticed that the deputy commissioner in his order has recorded that the original grantee Ramappa was granted the land on 2011-81. So this finding is contrary to the finding of the assistant commissioner that the land was granted on 2011-78. This would therefore indicate that there has been an application of mind by the authorities and the requisite requirements while considering the application for resumption has not been considered. Therefore, of the view, this is an appropriate case to set aside the impugned orders and remind the matter to the Assistant Commissioner, the direction to the Assistant Commissioner to record the findings that are necessary in application under Section 4 and pass appropriate orders. The petition is accordingly allowed.
1972-73 was the grant, my lord, and it was, my lord, Sagvalichi issue
Yeah,
dated
correct.
81.
Correct finding ಕೊಡ್ಲಿ ಆಮೇಲೆ ನೋಡೋಣ.
Yes,
Some time
81
frame,
ನಲ್ಲಿ Sagvalichi issue ಮಾಡಿದ್ದು ಅಂತ. That is not the grant date.
my lord may kindly fix some time frame. Otherwise it will remain, it'll go to the court.
But that is not good strategy for you. You are
Pardon?
I don't think it's good strategy for you. For a purchaser, why do you want?
As a delay is also there. Let-
45, Shriyarike. Petitioner, my lord. Yes. Lord, the grant was.
Seeking for adjournment. Okay, that council is engaged. 2015.
15.
9 years.
Years site there would be taken on.
You are purchaser or granting?
And the granting for granting.
In ground.
Ground it has now. Previous occasion, this court may not have remanded the matter back to deputy commissioner only on a point whether it's 15 years or 20 years. The non-alienation period is 15 years or 20 years. If it is 20 years, then they don't have the case. They are the purchaser. That is observation made by.
I'm sorry, my
Honorable
lord.
Court.
I'm sorry, it is not the only way.
Yes.
The fact remains that the grant was in the year 1954. My lord, the sale was in the year 1971. My lord, the restoration application was filed before AC on 9/10/1982. In 83, he passes an order. Appeal before DC is in the year 2010. 27 years delay. That was required to be considered by Deputy Commissioner. It was not considered. Matter came up before this honorable court, matter remanded. Plus now, he, without considering anything, delay his condoned 27 years delay. But then, whether it is 15 years or 20 years required to be seen. That he says, idi 20 varsha. That is, he holds that it is 20 years, non-alienation period. But then, for 27 years delay, my lords, there was an.
We'll come to the delay. Is it 15 years or 20 years?
According to me, it is 15. I got the notification filed before the court now at annexure, my lords.
Madam, what is the date of the grant and what is the period? What is the rule prescribed on that time?
My lords, may I draw the attention of the court to page number 70, my lords?
File means, my lord, 54.
Page number 70, my lords.
My lord, it was
Notification.
20 years, my lord.
Much?
20 years, my lord.
Page number 17, huh?
70,
My lord,
Yapattu, annexure
my lord,
K.
Here, my lord, in this case, my lord, application filed to 83, my lord, the act came into force 1979. Only 3 years of delay, my lord, it can't be taken as a 27-year delay.
20 years agidre.
Illa, my lord, immediately
Yes, it is
act came
15
into
years.
force, my lord,
My
immediately.
lords, I'll clarify it, my lords.
My lord, act came to their rescue only after, my lord,
What is this?
1979.
Page number 70?
70 is the
Can't be
notification,
taken.
my lords, referred in the impugned order. That is last, my lords, B.
Starts off at page 210. The notification.
My lords, that is notification, my lords. Here it is says notification number, my lords, here. The same notification number is referred by Deputy Commissioner.
Annexure K tane.
How the annexure K? My lords, GO number 7594-604 LR 266-50.
Which rule are you reading now?
My lords,
In annexure 70.
page number 70 annexure KL.
L ಓದ್ತಿದ್ದೀರಾ?
My lords, here it is, my lords. Illi, last ಅಲ್ಲಿ.
Date of grant.
Can I mark it, my lords?
ಮಾಡಿದ್ದಾರೆ 453 ಇಂದ 20 years.
My lord, this, as per this slab, my lord, table, my lord. 5/8/1953 to, my lord, 6/7/1955, up to 20 years, my lord. This is the slab.
Grant is on 3/8/54.
Can I mark it, my lords? Pencil.
Typed copy ಮಾಡ್ಸಿ madam.
Yes, my lord, I'll get it done. I'll get it done.
That is the only issue in the.
5/8/1953 to my lord, 6/7/1953, it was 20 years, my lord. Then it was got amended. ಇಲ್ಲಿ ಇದೆ ನೋಡಿ sir. No,
ಅದು serial number 5 ಗೆ you
please,
not put the GO number.
ಜೀವನ
Under which was amended.
yes.
but ನಮ್ದು ಇದರಲ್ಲಿ ಬರೋದು.
Melods, I have marked it now in the pencil melods.
But it.
Annexure K.
ಅಲ್ಲ, ಅವ್ರು
ಅದರಲ್ಲಿ ಆ ನೋಟಿಫಿಕೇಶನ್ ನಂಬರ್ ಇಂಪ್ಯೂನ್ಡ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಅವರು ಅದೇ ನೋಟಿಫಿಕೇಶನ್ ನ ರೆಫರ್ ಮಾಡ್ತಾರೆ. ಸೇಮ್ ನೋಟಿಫಿಕೇಶನ್ ಆಸ್ ಪರ್ ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಅಂತ. Melods, in this continuation of this, I draw the attention of the court to page number 72, my lords. Ali, fifth point number 5, my lords. Page number 72 ali, left hand side page, internal page number 214. Every grant of land under sub rule 1 shall be subject to condition where the grant is made free of cost.
Where are you reading?
214, my lord, 214.
214 internal page, my lords.
Yes.
Ali mark ಮಾಡಿದ್ದೇನೆ side ಅಲ್ಲಿ.
Grant of land
Shall be 15 years from the date of grant.
No, but what she says is, as per this notification at 4/8/53, it was period of 20 years. Thereafter, it has been amended and reduced to 15 years.
Please,
Well, the one referred by the deputy commissioner in the impugned order is the one which I am showing to the court now.
This GO number which you
How-
refer to,
how?
4th of
Advi.
August 83,
That
is an amendment to this particular rule 1 that is found at page 70.
How? That is exactly what I am saying, my lords. Now,
You have the copy of this book?
my lord, that
Because suppose this book is published after this particular date in 55,
I'll have to.
then it will be 15 years.
Yes,
If you have the book which is printed in 53.
I will search. I seek time, my lords.
Then which is the other GO?
my lord, I'll say verify. my
We
lord.
have to verify, my lords.
The only reason.
And that is the my lord, only after my lord, if it is in upset price, my lord, that is 15 years, my lord. There is no time, my lord, it is make 15 years ಅಂತ ಯಾವುದು ಮಾಡಿಲ್ಲ. All free grants, my lord, it is 20 years. Date of grant, we have to verify, my lord. On, my lord, dated 7/7/1955 onwards, my lord, it was free 15 years. But prior to this, my lord, their grant, petitioner's grant is prior to this. 7/7, sir. This is.
See, this is from 4th August.
20 years,
Yes,
4th of August. This entire notification is there.
I will clarify, my lords, that with this book again.
Because this is what it says.
I will just.
The entire notification is reproduced in Raghupati or Bokkale, which says 43(8), the grant of lands under sub rules 1 and 5 to persons belonging to depressed classes for an upset price, or reduced upset price, and to poor persons
Yes.
not owning land, should be subject to the condition that the land granted shall not be alienated for a period of 20 years from the date of the grant.
Allah, that is one part of it, my lord. In the
This is the rule that is prevailing as on 4th of August 53.
correct. Yes, my lord.
So if till the next amendment in the year 55,
Yes.
this was the period that will apply.
But my notification, which is contrary to this, my lords.
No, that's what I said. After 55, you're right.
No, it is not after 55. My lords,
Next amendment was in 56. So from 53 to 56,
I'll just verify it, my lords.
I think, madam, the 6th July 55 ಇರ್ಬೇಕು.
I'll,
The next notification,
yes, my lord.
because in this, the next notification,
Yes, my lord. 7/7/1955, my lord.
6th of July 55 ಅಂತ ಹೇಳುತ್ತೆ.
Yes, my lord.
ಆಮೇಲೆ 12th to 18th of January 56. That is incorporated in the land revenue code,
Yes, my
which I think is produced.
yes, my lord. That is not.
ಅದ್ ನಾನು ನೋಡಿ ಹೇಳ್ತೇನೆ. My lord, apart from that, there are other grounds we put it.
Another,
ಅಷ್ಟೇ ರಿಮೈಂಡ್ ಬಂದಿದೆ ಅಷ್ಟೇ ಉದ್ದೇಶ.
if the land is alienated after the,
ಹೌದು, ಅದು ಒಂದು.
ಅಷ್ಟೇ.
ಅಲ್ಲಲ್ಲ, ಅದಲ್ಲ. My lord, now kindly turn to the order passed by Assistant Commissioner, which is at page number 30, my lords.
If the land is sold after the term of the after prescribed term, before the 17 Act came into force, it's not a.
ಅಲ್ಲ ಅವರು they do not belong to depressed class. That is what I wanted to submit. No documents. My lord, that is the
Our
reason.
act depressed class ಆಗಬೇಕು.
ಅಲ್ಲ, they were the grantees claiming that it is under depressed class. No, they are not.
But the annexure G.
That annexure C is, I request the court, page number 30, my lords.
Where did you raise this contention that they were
Before
not?
the first appellate court, before the AC, everything has been raised. That was not touched at all.
You say that they are not belonging to depressed class?
Because no documents, absolutely no documents. Kindly turn to page number 30. AC court now in first order.
Who are the applicants?
My lord, according to me, they are not even grantees. Name has been changed in the RTC. Kindly look at the RTC.
Was this finding sought for when this court remanded the matter? No.
No, my lords, that order is also.
Increasing the grounds afterwards.
No, my lords, everything was kept open. The order is, the High Court order is also before this court, my lords.
Annexure G.
Annexure G,
Page
my lords.
59.
My lords, page 64, all contentions are left open, my lords.
If you have not raised this contention.
It is raised
Where?
before AC, before DC.
No. When the matter came up before this court.
It is raised. My earlier rate petition may be called for, it is before the court. Only page 64, only all contentions are left open. It is not limited to that.
My lord, page 21, my lord, Deputy Commissioner's order, my lord. He says, ಪ್ರತಿವಾದಿಗಳು PTCL ಕಾಯ್ದೆ, my lord. PTCL ಕಾಯ್ದೆ 4(1) ಆಕರ್ಷಿಸುವುದರಿಂದ ಈ ಕ್ರಯವು ಕೂಡ ಕಾಯ್ದೆ ಉಲ್ಲಂಘನೆ ವ್ಯಾಪ್ತಿಗೆ ಒಳಪಟ್ಟಿರುವುದೆಂದು ಈ ಮೇಲ್ಮನವಿ ಪ್ರಾಧಿಕಾರವು ಅಭಿಪ್ರಾಯಪಟ್ಟಿರುತ್ತದೆ. ಅಪೀಲುದಾರರು ಪರಿಶಿಷ್ಟ ಜಾತಿಯವರೆಂಬ ವಿಚಾರದಲ್ಲಿ ಪ್ರತಿವಾದಿಯಿಂದ ಈ ಹಿಂದೆ ಆಗಲಿ ಹೀಗಾಗಲಿ ಯಾವುದೇ ತಕರಾರು ಇರುವುದಿಲ್ಲವಾದ್ದರಿಂದ ಈ ಬಗ್ಗೆ ಮತ್ತೊಮ್ಮೆ ಚರ್ಚಿಸುವ ಅವಶ್ಯಕತೆ ಇರುವುದಿಲ್ಲ.
Already in last occasion, be that as it may, as observed, the matter has to go back to the appellate authority to consider the application for condition of delay and whether the grant was really made in favor of respondent number 1, and as to the conditions of the grant, whether the knowledge period is 15 years or 20 years. With 15 years apparently say in favor of the petitioner would be well within time. The first thing is the condition of delay.
Please.
Was it condoned by the Deputy Commissioner?
ಕಾಲ ವಿಳಂಬ ಅಂತ ಹೇಳ್ತಾರೆ. Yes, ma'am.
ಮಾಡಿದ್ದಾರೆ.
Page 18.
ಮಾಡಿದ್ದಾರೆ.
What was the reason for 27 years?
Notice note, order copy not served. This is the affidavit that is before the court. I have filed it. But copy is at page number, affidavit copy is at page number 41, my lords. 41. The relevant portion at next page, middle paragraph, my lords. May I read it, my lords? 42 only, page number 42 only, middle paragraph.
At that point of time, there was no provision for appeal. Section 5A was inserted.
27 years, how can you prefer an appeal? 3 decades.
It's after Section 5A was introduced. Not in light of these order.
You should have filed a writ petition. How can you keep quiet and then file an appeal after 27 years?
Not because there was a judgment by this court. The DC has also referred not the order of this court, WP.
When the order was passed, there was no provision for an appeal. It was final. What was your remedy? Then thereafter, can you take advantage of an amendment and then say, I'll file an appeal? 27 years is too much. What is the reason given the DC for condoning the delay?
Lord, DC says it should be liberally considered. Well, it's page number 18.
27 years. 27 years.
This can't be a ground. Page for 18.
commencement of arguments, I requested my lords from some time in this case.
Right, 27 years delay. ಅವ್ರದ್ದು ಮಾತ್ರ
ಡಿಲೇ ಇದೆಯಾ?
Provision ಇಲ್ಲ.
First application 83. My lord, new amendment prakaram. Even
Madam, this
assuming,
is a
my lord, 4-1,
this is
my
a
lord,
delay
20
in
years
fi-
was the condition, my lord, and
the delay in
permission,
filing the appeal.
please. My
So
lord,
if
first instant, my lord, first
this
instant,
is virtually a successive application.
my lord.
You
first-
file an application, dismissed, you keep it for 3 decades. Then you file an appeal and the deputy commissioner simply says, no, I have to construe it liberally, 3 decades.
My lord, first instant, my lord, within time they have filed the application, my lord.
I'm not on that.
No delay, yes, my lord.
After the order,
Yes, my lord.
can you wait for 30 years?
My lord, whatever, my lord,
Whatever ಅಂದ್ರೆ ಹೆಂಗ್ ಮೇಡಮ್ ಅದೇ
my
ತರ
lord, my lord, section 4-1 is very clear, my lord, 20 years was the condition, my lord, and that
not
is
on the
violated and
merits.
section.
How can the deputy commissioner condone the delay of 27 years?
The act itself, my lord, this is a depressive
Act
clause.
was invoked within time. You suffered an order. If you don't
Never-
take steps for 30 years,
Station where there were no limitation for this, lord. Approaching the deputy commissioner, my lord.
ಅದು ಒಪ್ಕೊಳ್ತೀನಿ,
authorities-
but
Yes,
ಒಂದ್ಸಲ ಅಪ್ರೋಚ್ ಆದ್ಮೇಲೆ if you suffer an order, can you wait for 30 years?
sale permission, my lord, after the act transaction has taken place, my lord.
Both I'm dismissing it only on the ground of delay.
My lord, now, my lord, new amendment, my lord.
No, that is an application for resumption. Here it was made within time.
My lord, even assuming.
Once
my lord-
once you know the law,
Yes,
once you make an application, suffer an order. You can't sit on that order for 30 years and then get up whenever you want. On the ground that the copy was not served on.
Object of the act, my lord, because, my lord, I hear that all the two, my lord, clauses, my lord, section, object of the act itself it defeats, my lord.
Merits ಮೇಲೆ ಅಲ್ವಲ್ಲ
months
madam,
ಅಲ್ಲ.
I'm only on the ground of delay. You would have kept it for
Only the-
3 decades, you would have made some improvement. Now, if all that is to be undone, in a couple of years, I can understand, not a couple of decades.
ನೀವು ಕೇಳ್ಬೇಕ್ರಿ ಅಲ್ಲಿ ಹೋಗಕ್ಕಾಗೋದಿಲ್ಲ. ನೀವು ಹೇಳಿದ್ರ ಸುಮಾರು ಕೌನ್ಸಿಲ್
Where's the affidavit? Page?
Mellas, page number 30, sorry, 40, Mellas, 41, sorry. 41 it starts, 42 is the relevant portion.
Yes. Chalva?
Please, my lords. Let's,
Just,
senior, my lord.
just one judgment is there, minutes, I'll just. But what is the effect of the amendment which was made by inserting section 5A was considered, minutes, by this honorable court. I understand, minutes, what your notes have already indicated,
Not for
that
3
the
decades.
delay, the delay is 27 years.
Not a small
in-
delay.
From the date of the original order. But what this honorable court said is it should be computed from the date on which the act came into force. So even then, minutes, there will be delay of 9 years, if that is to be taken by virtue of the orders of the coordinate bench. Even then, there will be a delay of 9 years. May I just refer to this judgment, minutes. This exactly a same case, minutes, which came before this honorable court. Paragraph number 2, may I request, minutes? The deputy commissioner having entertained an appeal under section 5A of the act against an order passed by the assistant commissioner, closing the inquiry under section 5 of the act after lapse of 21 years, having set aside the order and having directed the assistant commissioner for a fresh inquiry and decision, petition purchase of the property in the year 1974 to an extent of so and so, Madnaikali, Mandya district has been granted the Darkhas proceedings under the grant order of 53 is before this court containing deputy commissioner could not have entertained the appeal after a long lapse of time. Appearing on behalf of the petitioner, submissions of so and so is that the deputy commissioner could not have entertained the appeal after lapse of 21 years when the limitation prescribed under section 5A of the act is 3 months from the date of the order communicated. And that with the assistant commissioner having passed the order on 20/1/1986.
Please come to section 5A.
Lordships.
Section 5A is applicable only in respect of an order that is passed after the amendment act.
Lords, the court may not
Sorry,
take.
let's read the section, read the section.
Please.
Any person agreed by an order passed after the commencement of the.
After the commencement. They saw it.
So an appeal under 5A was competent only if the order was passed after 84. Sorry, after 92, I think.
84.
ಏನ್ರಿ ಇದು? 5A. Next page ಅಲ್ಲಿ ಇದೆಯಾ? ಅದ್ರಲ್ಲಿ ಇಲ್ಲ ಅದಕ್ಕೆ.
And see the second proviso. Provided
Provided
further
further, the
that
deputy commissioner shall admit an appeal against an order passed by the assistant commissioner holding the transfer of any granted land is not null and void before the such commencement. If on the said date, the writ petition preferred against such an order or appeal preferred against the order.
That is all. If you have not preferred a writ petition,
Yes.
you can't take the benefit at all. And 5A will be can be invoked only if the order was passed afterwards. Your appeal itself was incompetent.
So I'll just have a look at this. Shortest may have this matter on, because too many matters, I couldn't get ready with this. But I fully understand. This is the only limited point. If there is anything for this to submit, I will say it. Otherwise, I will leave it at that.
Wednesday,
Please.
Thursday.
Yes, Lord. Good.
So, I think the appeal itself was incompetent.
That's what I can see.
Seal number 46. Vishwanatha Regde.
Morning, I made mention, my lord. Records were called for earlier, my lord.
In matter,
My lord, the issue is, I am the original grantee under the Darkhast, that SC/ST grant. The respondent number 5 is a subsequent grantee. My grant is not cancelled. No order setting aside my grant. Subsequently,
you are the grantee.
I am the grantee. Original grantee is my client, my lord. In 1957, my lord, 12/5/1957, original grant was made.
When?
12/5/1957.
To your husband.
Please, my lord. The petitioner's husband, Ramaiah, was the original grantee. Lord, I'll just.
You made an application for resumption?
Lord, yes, my lord. It was sold in favor of 3 persons, Jalarappa, Vai Krishnappa, and Chikka Narsimappa. They are the brothers of respondent number 5 herein.
When was the sale?
Lord, sale date of
1865.
Yeah.
Avaga?
1965.
Lord, I filed a petition, my lord, before the assistant commissioner. That petition was allowed, and there is an order for restoration of the land in my favor.
Yavaga hakadre
That, Lord, I will just point out from the
Where is
record.
the order of resumption?
That is referred to in Annexure B, my lord.
Elimination 65.
1965, page 41, last line.
Date ಹೇಳಿ. Date.
Date ಇಲ್ಲ, page 1965, page 41, last line ಅಲ್ಲಿ ಇದೆ.
Page
41, Lord. From there it starts. Page 41, last line. ಸದರಿ ವ್ಯಕ್ತಿಯು ಎರಡನೇ ಎದುರುದಾರರಿಗೆ 1965ನೇ ಇಸ್ವಿಯಲ್ಲಿ ಮಾರಾಟ ಮಾಡಿದ್ದು 1982ನೇ ಇಸ್ವಿಯಲ್ಲಿ ರೀತಿಯ ಕ್ರಯಪತ್ರವನ್ನು ಅನೂರ್ಜಿತಗೊಳಿಸಿ ಸದರಿ ಸ್ವತ್ತನ್ನು ಸರ್ಕಾರದ
ಸೇಲ್ ಯಾರಿಗೆ ಮಾಡಿದ್ದು?
3 ಜನಕ್ಕೆ ಸೇಲ್ ಮಾಡ್ತಾರೆ.
ಯಾರ್ಯಾರು?
ಜಾಲಾರಪ್ಪ, ಕೃಷ್ಣಪ್ಪ ಮತ್ತೆ ಇನ್ನೊಬ್ಬರಿಗೆ
Chikka Narasimappa.
ನರಸಿಂಹಪ್ಪ.
They are the brothers of this respondent number 5.
Who is respondent number 5?
Narasimappa.
I am no way connected, Lord. He is making false submission.
Who? Jalarappa.
Jalarappa and othersಗೆ it was sold. The land was
And to Vai Krishnappa.
Please, Lord.
You made an application for resumption.
Please, my lord.
When?
That was
1981, my lord.
yes.
Order date.
Order is dated. Assistant Commissioner passed an order dated 10/9/82. By then, my lord, the original grantee Ramappa had died. The Assistant Commissioner directed that the land should be restored in favor of the petitioner, wife of the original grantee. And in 87/88, between 87/88 and 92/93, name of Ramappa was entered in the revenue records.
82 is the order of resumption.
Yes.
When were you put back in possession?
My lord, immediately, my lord, I was put back in possession, my lord, annexure B, my lord, your lordship will get it.
23/9/1982, my lord. 23/9/1982, Tahsildar re-grant in favor of the grantees.
The order,
It is Tahsildar restored, my lord. Resumed to the legal.
within 3 days,
Please, my lord. 23/9/1982.
within 13 days.
That was the, my lord, here it is stated, my lord.
Then when is the alienation? Thereafter?
Lord, there is no subsequent alienation, my lord. Land was granted.
82 ಇಸ್ವಿಯಲ್ಲಿ L&D ರೀತಿಯ ಕ್ರಯಪತ್ರವನ್ನು ಅನುಚಿತಗೊಳಿಸಿ.
ಹೌದು, ಅದು ಹಳೇದು. ಅನುರ್ಜಿತ ಆದ ಮೇಲೆ the wife of this Jalarappa becomes the member of the panchayat and also the president of the panchayat. That was between 1994 and 2002. When she became the member and the president of the panchayat, Aruru Grama Panchayat, there were 3 grants in favor of respond number 5. 1998.
Are you saying that the resumed land was once again granted?
Please, my lord. There is no cancellation of the grant made in my favor. But the same land has been granted in favor of respond number 5 on 18/6.
On what basis do you say that? That
Lord,
the same land was granted?
Lord, it is based on the records, my lord. I will point out, my lord.
Yes, madam, the same land was granted, resumed land? How can it be granted?
That is not stated, my lord. Same land and nowhere it is stated.
Not the same land, Lord.
ಯಾವ grant ಮಾಡಿದ್ದು second time?
Second time, 2 ಡೇಟ್ ಅಲ್ಲಿ 18/6/1998 1 ಎಕರೆ 20 ಗುಂಟೆ. ಸರ್ವೆ ನಂಬರ್ 131.
Survey number?
131. After, though the land granted was in survey number 96, after survey and Durast, it was assigned new number 131. And out of this survey number 131, 18/6/1998, 1 acre 20 guntas was granted.
30.
1 acre 20 guntas.
What was the original grant in your favor, in your husband's favor?
It was 3 acres was granted, but after survey, it was found that the land, actual land is measuring only 2 acres 34 guntas, and that was granted in my favor. That was.
What is the second grant?
Second grant is dated 5/7/2004, 25 guntas. 25 guntas. That also again in survey number 131 only. 10/8/2004. 10/8/2004. Again another 25 guntas in same survey. That while granting this land 25 guntas, it was shown as survey number 96.
Suppose there's a overlapping grant.
Yes.
Of your resumed land.
Yes, my lord.
Can you invoke PTCL land?
My lord, the proceedings were initiated, my lord. I being a grantee under the.
Remedy would have to challenge this grant.
Yes.
There was no contravention of any of the terms of the grant for you to.
Lord, I sought for restoration of the land in my favor under the PTCL Act.
How?
Under section.
You claim that you were put back in possession.
Yes.
Pursuant to the order of resumption.
Yes.
If you are in possession on the basis of the resumption order, how can you challenge a subsequent grant made with revenue authorities?
Lord,
maybe you should challenge it separately.
Lord, subsequent to my application, my lord, the respondent number 3 passed an order on 27/2/2009.
Was it with jurisdiction? Did he have jurisdiction to?
Lord, he has said, my lord, where, my lord, in the proceedings before the third respondent, all the 3 original purchasers were also parties.
Let us consider this situation.
Yes.
Let us assume that you had not made an application for resumption.
Yes.
And you had continued in possession on the basis of the grant. If that very land is granted to somebody else.
Yes.
Can you invoke the PTCL Act?
Lord, rightly or wrongly, PTCL Act was invoked, my lord, and authorities have exercised the power, lord, under the PTCL Act.
The situation is this.
Yes.
There are 2 grants.
Yes.
You have not challenged subsequent grant.
Lord, I have approached the authorities, my lord, challenging the grant and restoring the land in my favor.
I think you should prefer an appeal, challenging the grant on the ground that there is not a resumption in your favor. I will exclude the time that you have spent all these years.
Please.
Because I don't think From the facts that you have stated, you can't invoke PTCL Act.
Lord, so far as the law is concerned, my lord, in respect of land granted under the PTCL Act, Lord, all other, Lord, the PTCL Act would, provisions of PTCL Act would prevail in respect of the general law.
Absolutely.
Yes.
Provided there's a sale in transfer and contravention of the terms of the grant.
Yes.
There's no transfer by the grantee.
Please,
For you to invoke the PTCL, there should
Please.
be a transfer by the grantee.
that what transfer was made, my lord, has been set aside and I have been put back in possession.
So if on resumption,
Yes.
that land is granted by the authorities, you may have to challenge that grant, saying that you could not have granted the land which is already resumed in my favor.
Lord, in fact, once the assistant commissioner passed an order cancelling the grant and restoring possession in my favor, Lord, on the ground that the respondent number 5 was not heard, that order was set aside and matter remanded back to the assistant commissioner. Thereafter, Lord, the assistant commissioner dismisses my application, saying that you did not produce the grant order.
Because my impression is,
Yes.
I don't know the extent survey number 96.
Yes.
Normally, when lands are granted, it will be in a vast extent of land,
Yes.
out of which 3 acres is granted. After it is ported, it will be subdivided to several survey numbers spread across. There could be an overlapping grant. But suppose the authorities had granted these 3 lands in a separate place.
No, my lord, the respondent number 5 claims that he is in possession of the same land.
Then you will have to challenge this grant and say that I am in position, you could not have granted these 3 portions of land which have been resumed in my favor.
Lord, authorities
Good.
clarified, but same land was not granted, my lord.
Please take, Lord,
Clarified.
page 42, my lord, order of the Deputy
Either
Commissioner.
way, let him challenge it if he is so advised.
After, Lord, one document, Lord, the evidence adduced by him in a civil suit. My lord, I have produced along with the statement of objections. Please take page number 79. Is produced along with statement of objections.
79,
Lord, along with statement of objections. It's the evidence given by him.
79.
Please, Lord. ನಾನು statement of objections file ಮಾಡಿ.
2 page number ಇದೆ.
This statement of objections was filed on 6/11/20, my lord.
ಒಂದನೇ ಪ್ರತಿವಾದ ನನಗೆ ಅರ್ಜಿ ಆಗಬೇಕದ.
ನಾನು ನಿಶಾನೆ P1 3 ವಾದಿಗೆ ಮಂಜೂರಾದ ಎವಿಡೆನ್ಸ್ ಅವರು
Internal pages 10.
ಇಂಟರ್ನಲ್ ಪೇಜ್ 10 ಪ್ಲೀಸ್. ನಿಶಾನೆ P1 3 ವಾದಿಗೆ ಮಂಜೂರಾದ ದಾವಾ ಸ್ವತ್ತಿನ ಸಾಗುವಳಿ ಚೀಟಿಗಳು ಎಂದರೆ ಸರಿ. ವಾದಿ ಮೀನ್ಸ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ 5 ಹಿಯರಿನ್. ವಾದಿಗೆ ಮಂಜೂರಾದ 3 ಆಸ್ತಿಗಳು ಒಂದೇ ಕಡೆ ಇದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ, ಬೇರೆ ಬೇರೆ ಇದೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ಸದರಿ 3 ಮಂಜೂರಾದ ಜಾಗವು ಸರ್ವೆ ನಂಬರ್ 96ಕ್ಕೆ ಸೇರಿದೆ ಎಂದರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಸರ್ವೆ ನಂಬರ್ 96 ಒಂದೇ ಪೊಡಿ ಆಗಿರುತ್ತದೆ. ಸರ್ವೆ ನಂಬರ್ 96ಕ್ಕೆ ಪೋಡಿಯಾದ ಸರ್ವೆ ನಂಬರ್ 131 ಆಗಿರುತ್ತದೆ. ಸರ್ವೆ ನಂಬರ್ ದುರಸ್ತಿಯಾದ ಕಾಲದಲ್ಲಿ ಪೋಡಿ ಆಗಿರುತ್ತದೆ ಎಂದರೆ ಸರಿ. ವಾದಿಯು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಏನೆಲ್ಲ ದಾಖಲೆಯನ್ನು ನೀಡಿದ್ದಾರೆ ಎಂದು ನಾನು ನೋಡಿರುವುದಿಲ್ಲ. ದಾವಾ ಸ್ವತ್ತಿಗೂ ನಮಗೂ ಯಾವುದೇ ಸಂಬಂಧ ಇಲ್ಲ. ವಾದಿಯು ನೀಡಿದ ಆಸ್ತಿಗೂ ನಮಗೆ ಯಾವುದೇ ಹಕ್ಕು, ಅಧಿಕಾರ, ಹಿತಾಸಕ್ತಿ, ಸ್ವಾಧೀನ ಇಲ್ಲ ಎಂದರೆ ಸರಿ. ಸಾಕ್ಷಿಯು ಮುಂದುವರೆದು ಸರ್ವೆ ನಂಬರ್ 96ರಲ್ಲಿ 25 ಕುಂಟೆ, 96ರಲ್ಲಿ 25 ಕುಂಟೆ ಮತ್ತು ಹೊಸ ಸರ್ವೆ ನಂಬರ್ 131ರಲ್ಲಿ 1 ಎಕರೆ 20 ಕುಂಟೆ ಜಮೀನಿಗೂ ನಮಗೂ ಯಾವುದೇ ಹಕ್ಕು, ಅಧಿಕಾರ, ಹಿತಾಸಕ್ತಿ, ಸ್ವಾಧೀನ ಇಲ್ಲ ಎಂದರೆ ಸರಿ.
Was this suit about?
Suit for injunction filed by me when he interfered.
That is decreed.
That is decreed, and he filed a declaration suit that is dismissed. Both the cases,
Lord,
RS filed,
suit-
RS dismissed,
Lord,
no
this
RS is
suit
filed.
is for partition. There was a rift between the members of the family. This,
You have suffered an order, is it?
please,
There is no decree against you.
I produced the decree
yes,
copies
Lord.
also.
Lord, so far as,
Did you challenge it?
Lord, Lord, it was not challenged, Lord. Lord, what happened was, this Prakash, who is the witness, Lord,
Sure.
he also says, further says, Lord, my learned friend did not read it. Lord,
What the
Vadigu
court said,
Namago,
If you have not challenged a decree, even if it's a wrong decree,
Lord, kindly see, Lord.
binds you.
ವಾದಿಗೂ ನಮಗೂ ದಾವಾ ಸ್ವತ್ತಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ತಕರಾರು ನಡೆಯುತ್ತಿದೆ ಅಂದರೆ ಸರಿ, ಅವರೇ ಸಜೆಸ್ಟ್ ಮಾಡ್ತಾರೆ.
I will not go into this. If
Please.
you have suffered a decree
Please.
of injunction, you have not challenged it, there
Lord,
is a matter.
That is left to the parties, my lord, if they are.
I will simply say that the provision of the PTCL could not be invoked.
Yes.
Since there is a parallel grant, you do whatever you want.
Please.
The petitioner contended that her husband was granted 3 acres of land on 12/5/1957. In this petition, the authorities have recorded a finding that there was a sale. The petition also contends that this property, which was granted to husband, was sold in the year 1965 in favor of Jalarappa and V. Krishnappa. And an application for resumption was made, which was allowed by the Assistant Commissioner on 10/9/82, and the granted land was restituted in their favor. Next. The petitioner contends that the very same lands that had been granted to her husband was granted to respondents.
5, respond number 5 only.
Obrena.
Obre.
More grant andre
More grant to obre sri.
was granted to the fifth respondent on 18/6/98, 5/7/2004 and 10/8/2004. Next, the petitioner accordingly proceeded to make an application for resumption of the said lands. And the said application has been allowed by the Assistant Commissioner. Allowed or dismissed?
Once it was allowed, and thereafter it was in appeal, it was set aside and remanded.
It was allowed by, was accepted by the Assistant Commissioner, which has however been reversed by the Deputy Commissioner under the impugned order.
No, it was order dated 12/8/2009.
You have filed the writ petition against an order of the Assistant Commissioner, resuming or not refusing to resume.
Refusing to resume.
Then
Lord,
confirm in
after
appeal.
remand, my lord, these 2 orders were passed.
What are the 2 orders that are passed?
2 orders, my lord, that order rejecting my claim, dismissing my application.
And confirm the Deputy Commissioner.
Please, my lord.
The petitioner sought for resumption, and after a protracted litigation, by the impugned orders, the application for resumption has been rejected by the Assistant Commissioner and also confirmed by the Deputy Commissioner, and hence the writ petition. Not counsel for the fifth respondent contends that the fifth respondent had instituted a suit in OS 73/2010 against the petitioner and others seeking for a decree of injunction. And
They also filed a suit for declaration in OS 78/10. That is dismissed.
And the said suit has been decreed in favor of the fifth respondent. He also submits that the petitioner herself had instituted suit in OS
78/10.
seeking for a declaration,
Lord,
and the said suit is also dismissed.
Please.
And it is contended that these 2 decrees appeal ಆಗ್ಲಿಲ್ವಾ?
Appeal ಹಾಕಿದ್ರು appeal ವಜಾಯಿತು.
It is contended that as against the dismissal of the suit for declaration, an appeal in area number
Please.
154/2015 was preferred. And the same was also dismissed, and consequently, the claim of the petitioner that she was the owner of the land has been refused by the civil court and has become final.
Lord, one submission, Lord. Under 4(3), my lord.
Our contention.
Allala. Under section 4(3), any order of any authority is also, Lord, made applicable to, Lord, 4(2)(1) and 2, Lord, is applicable to order of any authority also.
What is the order that can be passed?
Lord, the order of granting the same land, my lord, to another person. 4(3), my lord. The provisions of
Yes.
the provisions of subsections 1 and 2 shall apply also to the sale of any land in execution of a decree or order of a civil court or of any award or
Sale. That is a sale.
Allah.
Sale of a land.
No, my lord. Last part, your lordship.
Provisions of subsection 1 and 2 shall apply to the sale of any land
In execution of a decree or order of a civil court or of any award.
That
or-
is sale pursuant to a decree, award, order of the authority.
Not
Not an
order of any authority, other authority.
A sale made pursuant to an order of the authority. There must be a sale for invoking section 4.
Yes.
No sale, you can't invoke section 4. at all.
Lord, this order of any other authority, my lord, would include a grant, my lord.
You are reading it disjunctively completely.
Please.
You are eliminating the first sentence. Shall also apply to the sale.
Please, my lord. Lord, my lord, the language used is, my lord, or order of any other authority.
ಎಲ್ಲ 4 or ಇದೆ ನೋಡಿ.
ಹೌದು.
Sale of any land
ಹೌದು.
in execution of a decree, first or order of a civil court.
Yes.
Or of any award or order of any authority.
Yes.
The sale must be pursuant to a decree of a civil court or any award or an order of any other authority.
Yes, my lord. So far as that, I would,
Elaborate.
please. That, your lordship may kindly note that contention and, lord, and reject it.
In the so, as noticed above, it is the admitted case of the petitioner that she had made an application for resumption and the land was resumed in her favor. So if that is the admitted position, the question of the petitioner invoking the provisions of the PTCL Act to set aside a grant made in favor of the 5th respondent would never arise. It is to be noticed that to invoke section 4, there must be a transfer of a granted land in contravention of the terms of the grant. And only then will the assistant commissioner or the deputy commissioner assume jurisdiction to order for resumption. The assistant commissioner or the deputy commissioner cannot sit in judgment over a grant made by a revenue authority in respect of that very land. So in other words, if there is an overlapping grant made by a revenue authority, the same cannot be adjudicated upon by the assistant commissioner while entertaining an application for resumption under section 4. Next, learned counsel for the petitioner, however, seeks to place reliance on subsection 3 of section 4 to state that the provision indicates that the provisions of section 4 can be invoked even in respect of an order of any authority. In my view, this argument is misconceived. Subsection 3 of section 4 categorically states that the provisions of subsection 1 and 2 of section 4 would apply even in respect of sale of any land sold in execution of a decree or an order of a civil court or of an award or the order of any other authority. The indication, the intent of section 3 is that there must be primarily a sale. And if the sale is pursuant to any of those 3 conditions mentioned, subsection 3, section 4 can still be invoked. In this case, admittedly, there is no sale of the property, no sale of the granted land. And therefore, the question of invoking section 4 would not arise. Consequently, I find no grounds to entertain this writ petition. Writ petition is therefore dismissed.
Great. Lord, your lordship may reserve liberty, my lord, to challenge the grant, my lord, because all these years, my lord, would
I
be.
thought I would do it, but you already served a decree. You have, if you want me to say that, I'll say that.
ಗ್ರಾಂಟ್ ಅದು
May not
ಬಗರುಕುಂ ಅಂತ ಹೇಳ್ತಾರೆ. ಅಪ್ಸೆಟ್ ಪ್ರೈಸ್ ಕಲೆಕ್ಟ್ ಮಾಡಿ.
ಬೇಡ ಬಿಡಿ ಅವರು. ನಾನು
Yes,
PTCL ಬರಲ್ಲ ಅಂದ್ರೆ
It
ಸಾಕು.
is not a- yes.
47.
My lords, 47 now for the petitioners, my lords. Lords, I
Yes.
for a short date, my lords, counsel on record is unwell. Morning, colleagues of counsel on record try taking
It's
adjournment.
2015.
Yes, yes,
And
my
I
lords.
already granted you time once, isn't it?
My lords, one opportunity, my lords, one date. A week's time.
It's the last chance. We list on. Next time you don't come, I'll dismiss it.
I'm grateful.
22nd.
I'm grateful. My lords, interim order to continue, my lords.
Interim order to continue.
I'm grateful.
43, T. Sheshgiri Rao.
Lords, I am appearing in the number. WP number 22712 of 2016. Lords, last occasion your lords directed.
WP?
22712 of 2016. Post again.
First matter.
First matter.
Yes.
Lords, last occasion your lords directed the government advocate to secure the records pertaining to the grant said to have been given in the year 1928.
NVRಗೆ.
So lords, the dispute has arisen like this, my lords. There is one Muniga who claims there is a grant made by Bangalore South Taluk Tahsildar in the year 1928 when there was no Bangalore South Taluk. He executes the sale deed.
You are the purchaser of the grant.
Lords, I am the grantee of this property in the year 1964. Now what happens? The LRs of the first Muniga who claims that there is a grant of 1928, he files an application saying that the land should be resumed. Now, there are some orders passed in that matter at the first instance when,
Muniga claims that the land was alienated.
yes, Muniga claims that land was alienated in favor of a purchaser. That Muniga is different.
No, no, all right, that sale is not.
Yes, that the sale is what is now not interfered with, Milords. Now, the question is whether that grant itself is there or not, because in the previous round of proceedings, the authorities have recorded a finding that 1928 grant cannot exist because it is said to have been
An application for resumption was filed by Muniga's LRs.
Muniga's LRs, the grantee of 1928.
Now that application is allowed or refused,
That is refused.
against which an appeal was preferred by the purchaser.
Yes.
And that has been-
Initially it was allowed, then it was,
Ultimately, it has been.
ultimately now as things stand, the deputy commissioner has dismissed the application.
Assistant Commissioner had allowed it.
Yes, Milords.
The deputy commissioner has refused it.
Yes.
And you are challenging the refusal to resume.
Milords, now
Being
what
the grantee.
happened, because the subject matter was the same, they implemented me. I was implemented in the proceedings. Deputy commissioner, while passing the order, has made a reference to the fact that my appeal is also dismissed because there was a remand order
Why
which
did
was
you
passed.
prefer an appeal?
So that's the problem, Milords, that come before in the first round itself, they had filed an application because there
You also claim to be a grantee.
I am a grantee. Milords,
Yes,
my
yes,
possession
yes.
was disturbed. Milords, what happened in the earlier proceedings between these two, my possession was disturbed because of these inter se proceedings. So that's when I went before the court and
How can you invoke PTCL Act at all?
Milords, the reason is only this. I cannot invoke PTCL Act. What your lordship said, the first thing which struck to my mind is, but the difficulty, Milords, is a proceedings which took place in this manner, Milords, resulted in the possession being disturbed at some point of time because of these proceedings. That's why we got ourselves implemented. Now there are findings which is recorded, Milords, which is conflicting my interest in the subject matter. That is the 1964 grant. Last occasion, your lordship directed, Milords, that the grant records needs to be secured to verify. If both the grant records are there, it's as simple as this. If both the grant records are there, my remedy lies elsewhere. If one grant record is not there, Milords, I'll be out because either of the ways I'll have to go to the civil court. If 28 is not there, only 64 is there, I will not really.
I'll be recording finding. Why don't you go to the civil court and
Milords,
establish that fact?
Milords, that 1928, whether it's there or not, because the finding is recorded.
Simply file a suit declaration of the 64
Milords,
grant.
the finding is recorded, Milords, by the deputy commissioner, who will be the competent authority,
I will
saying
say
that
that will be the no consequence. It will not come in the way of the civil court determining the issue independent.
But that again, Milords, that's the reason why I said, if your lordships were to only summon the records to see whether
Then
it's
I'll
there
have
or
to-
not.
Once I record a finding, it will prejudice either of the parties. Suppose I hold it against you.
Yes.
So remedy under the civil court will go. Suppose I hold it.
No,
in our favor.
Milords, I would put it this way, Milords, either of the ways I'll have to take an order at your lordship sense for this reason. If
No, I will say-
1928, Milords, your lordships can even summon the records. May I just pass on this? We have some difficulty,
The
Milords.
writ petition is filed only against the order of resumption.
Yes.
The refusal to resume. I have simply said that you are a grantee and therefore there's no prejudice cost to you. It's in your benefit.
Milords, the DC records are finding my grant is illegal.
Then you may have to
That is what is challenged before your lordships.
live to that extent.
Only to that extent.
Where's the prayer in the writ petition?
Milords, prayer, of course, is to set aside the entire thing. This is what I've advised them, Milords, that what can be challenged is only the finding which records that my grant is not legal. That's the reason why your lordship said,
I don't understand. Why did you file an appeal at all in the
Milords,
first place?
then what happened, Milords, it was not an appeal. It was an impleading because of the earlier order of resumption, my possession was disturbed.
You were not the applicant who had made the application for resumption.
Wasn't.
So then
ಅವ್ರು ಏನ್ ಮಾಡಿದ್ರು ಪೊಸೆಷನ್ ಡಿಸ್ಟರ್ಬ್ ಮಾಡ್ಬಿಟ್ರು ಈಗ ಯಾರೋ ಅವ್ರವ್ರ ಲಿಟಿಗೇಷನ್ ಮಾಡ್ಕೊಂಡು ನನ್ನ ಪೊಸೆಷನ್ ಡಿಸ್ಟರ್ಬ್
one
ಮಾಡಿದ್ರು
thing, I'll permit you to withdraw the appeal.
ಅಲ್ಲ ಲೀಗಾಲಿಟಿ ಆಫ್ ದಿ ಗ್ರಾಂಟ್ ಬಗ್ಗೆ ಇದೆ.
I'll permit you to withdraw the appeal that you had filed and give you liberty to go to the civil court to establish.
Milord, there's a connected matter. Two separate petitioners are claiming to be the descendants of a Muniga, who was the original grantee.
The PTCL can't be invoked to decide this question.
Yes, my lord.
You claim to be the grantee.
No, I'm not the grantee, my lord. I am a subsequent purchaser. I'm for respondent number 11 in the main case and respondent number 3 in
You
the
have challenged the order of
case.
resumption?
No, my lord.
He's a purchaser,
I'm the purchaser. The resumption was challenged by the applicants, the impleading applicants in the original
DC
proceedings.
has refused to resume. Therefore, your title is safe.
Yes, my lord. Hence, my lord, if such liberty is granted, I'm led by a senior counsel. A date may be fixed. We shall address our, my lord.
Even if you withdraw the writ petition, what can you do?
No,
You
no.
can still go to the civil court, isn't it?
My lord, but his
How can the
claim
deputy
will be.
commissioner- How can the deputy commissioner record a finding in an appeal against an order of resumption being passed regarding a parallel grant?
Yes, my lord. My lord, if a date may be fixed, my lord, I'll.
Today is the date fixed.
Yes, my lord, I understand. No, I'm led by a senior counsel, that's why, my lord.
I think
ಅವರು
the-
ಏನೋ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೋತಾರಂತ ಅವ್ರ ಕ್ಲೈಂಟ್ ಹತ್ರ ವೆದರ್ ವಿ ಕ್ಯಾನ್ ನೋಟ್ಸ್.
What is the other writ petition about?
Other writ petition is by the 1928 Munigas LRs. There are two Munigas, 1928 Muniga and
They
1964
are
Muniga.
challenging the refusal to resume.
Yes, that will remain.
Who appears for that? For
ಹೌದು ಯಾರು?
They have filed NOC, my lord. After that, they have not been represented.
No, you are for the purchaser, right?
I'm for the purchaser.
Who appears for the LRs of Muniga?
The advocates who were on record, they had filed their memo of retirement, and after that, nobody has appeared. A
Then I'll
notice was
dismiss it,
directed.
non-prosecution.
Yes, my lord.
I'll dismiss it, non-prosecution.
Obliged, my
That will help you.
That will help.
ಆಯ್ತು, Wednesday ಮಾಡ್ತೀನಿ ಅವ್ರು.
ಆಯ್ತು.
Obliged.
ಅಸಲ್ ನಾ ಅವ್ರಿಗೆ ಬಂದಾಗ ನಾನು ಹೇಳ್ದೆ ಅಲ್ಲ ಇದು ಅವ್ರ ಜಗಳದಲ್ಲಿ ನೀವ್ ಯಾಕೆ ಹೋಗಿ ಸಿಗಾಕೊಂಡಿದ್ದೀರಿ?
You invited this order. Filing an appeal.
My lord, records, my lord, the grant records
ಏನ್
is
ಬೇಡ?
not available.
ಬೇಡ.
ಇಲ್ಲ ನಮ್ಮಲ್ಲಿ.
20 seconds.
Please, Vilas.
Cinema 49. Vivek Ravi Prakash.
The petitioner.
Yes.
Now the state has to file objections.
What? You are for the purchase of a grant.
Purchase.
What is the date of the grant?
I am
1950.
appeared for granting my lordship. In this case, they are challenging the constitutional validity of the recent amendment.
ಮಾಡಿದಾರ?
Yes.
Challenge ಮಾಡಿದ್ದಾರೆ sir.
Post along with.
Cinema 50. Amresh Angadi. Amresh Angadi.
Please.
There are two petitions connected, my lord.
Yes.
My lord, this honorable court, page 30 annex D,
ನೀವು granting a purchaser da?
granting, my lord.
Purchase.
Earlier occasion, this honorable court, page 30 annex D, remanded the matter to the deputy commissioner. Page 33, para 3 onwards, my lord.
The permission was granted.
Yes. That is a doubtful. There's a court directed to verify.
Now the finding is that there was permission granted.
There is no permission.
Now what is the finding recorded?
There is no permission to grant, still the.
In madam finding ಇಲ್ವಾ? Permission ಇರ್ಲಿಲ್ವಾ?
ಇಲ್ಲ ಪರ್ಮಿಷನ್ ಇಲ್ಲ ಅಂತಾನೆ ಹೇಳ್ತಾರೆ. There is no permission as such.
ಅಲ್ಲ ಇದ್ರೊಳಗೆ ಪರ್ಮಿಷನ್ ಇದೆ ಅಂತ ನನ್ನ ಸ್ಟ್ಯಾಂಡ್. ದಟ್ ಇಸ್ ದಿ ಲೀಗಲ್. ಡೆಪ್ಟಿ ಕಮಿಷನರ್ Annexure J.
The assistant commissioner dismissed the appeal for non-prosecution.
Non-prosecutions.
Deputy commissioner?
Allowed, my lord. Against that, they filed a writ petition, earlier writ petition. Then remanded, my lord. Again, my lord, the land has taken to government, my lord.
The DC has recorded that the land was granted and without permission you have purchased.
Yes, ma'am.
They have purchased it.
Then why are you before the court?
ಅಲ್ಲ ಇದ್ರೊಳಗೆ ಚಂದ್ರಶೇಖರ್
Land has been resumed to the government on. Last pair, post, last post, next ray.
Page 23 ಅಲ್ಲ.
ಮರುದಾನ ಮಾಡೋದು. ಇಲ್ಲ ಜಮೀನು ಅರ್ಜಿದಾರರಿಗೆ ಮರುದಾನ ಮಾಡೋದು.
And the next ray, page 23, my lord. Operative portion.
Page 23 ಅಲ್ಲಿ ಮೇಡಮ್. ಮರುದಾನಕ್ಕೆ ಅರ್ಹರಲ್ಲ ಎಂದು ತೀರ್ಮಾನಿಸಿ ವಿವಾದಿತ ಜಮೀನನ್ನು ಸರ್ಕಾರದಲ್ಲಿ ವಿಹಿತಗೊಳಿಸಲು ತಹಸೀಲ್ದಾರ್ ಕೋಲಾರ್ ಅವರನ್ನು ನಿರ್ದೇಶಿಸಿ ಆದೇಶಿಸಿದೆ. This resumes to the government, not to the legal.
ಮಾಡಕ್ ಬರುತ್ತೆ ಮೇಡಮ್ ಅದು?
Again, we need to regrant, my lord, resume to the legal aids of the grant.
Then on what way, why did he say this? This order is not challenged by the purchaser?
Purchase challenge ಮಾಡಿದ್ದಾರೆ. ಅದು next petition.
ನಾನು ಇದರೊಳಗೆ ನಾನು ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಆರ್ಡರ್ ಐ ಹ್ಯಾವ್ ಚಾಲೆಂಜ್ ದಟ್ ಇಸ್ 50
On what
ಎಂ
ground?
ಚಂದ್ರಶೇಖರ್.
On what ground?
The matter, I have produced the grant permission for sale permission I have produced.
What is the finding of the deputy
Finding
commissioner
is-
regarding permission?
Finding deputy commissioner.
Refresh.
Read page 22.
ಅದು our petition, ನಿಮ್ petition. ನಮ್ petition is separate.
Page 4 of the order of the TCO, this, sir.
Yes, restored earlier, annexure C is earlier I have approached before this honorable court, matter remitted back.
Under the impugned order,
Yes,
deputy commissioner has recorded finding that there is no permission obtained.
yes, that is.
Please read that paragraph. I think that is page 17 in your writ petition.
Yes, I will what. ಆದೇಶದಲ್ಲಿ ಕೆಳಗೆ ಮೇಲೆ ಚರ್ಚಿಸಿರುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಅಲ್ಲಿಂದ 18.
Para 4, the internal para 4.
Alla, please read
Para 4.
the second paragraph in page 4. ಮೇಲ್ಮನವಿದಾರರ ಮೇಲ್ಮನವಿ ಲಿಖಿತವಾದ.
ಮೇಲ್ಮನವಿದಾರರ ಮೇಲ್ಮನವಿ ಲಿಖಿತ.
ಎಲ್ಲ ನ್ಯಾಯಾಲಯದ ಆದೇಶ
ಇದು
ಕಡತದಲ್ಲಿ
ಮೇಲ್ಮನವಿ ಲಿಖಿತ, ಅದೇನೆ.
ದಾಖಲೆಗಳು.
ಅಲ್ಲಿ ವಾದ 2 ಮತ್ತು 3ನೇ ಎದುರುದಾರ ಲಿಖಿತವಾದ ಕೇಳಿ ನ್ಯಾಯಾಲಯದ ಆದೇಶ ಹಾಗೂ ಕಡತದಲ್ಲಿ ಲಭ್ಯವಿರುವ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಯಿತು. ಈ ಪ್ರಕರಣದಲ್ಲಿ ಮಾನ್ಯ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯವು ತಮ್ಮ ಆದೇಶದಲ್ಲಿ ಸೋ ಅಂಡ್ ಸೋ ನೀಡಿರುವ ಮಾರಾಟ ಮಾಡಲು ಅನುಮತಿ ಪತ್ರದ ಸೇಲ್ ಪರ್ಮಿಷನ್ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಿ ಪ್ರಕರಣವನ್ನು ಇತ್ಯರ್ಥಪಡಿಸಲು ಸೂಚಿಸಿರುತ್ತದೆ. ಅಂತೆಯೇ ಪರಿಶೀಲಿಸಲಾಗಿ ಸದರಿ ಪತ್ರದಲ್ಲಿ ಕರ್ನಾಟಕ ಸರ್ಕಾರದ ಆದೇಶ ಕಾರ್ಯದರ್ಶಿ ಕಂದಾಯ ಇಲಾಖೆಯವರು ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಕೋಲಾರರವರಿಗೆ ವಿವಾದಿತ ಜಮೀನನ್ನು ಇತ್ತೀಚೆಗೆ ಮಾರುಕಟ್ಟೆ ಬೆಲೆಗೆ ಮಾರಾಟ ಮಾಡಬೇಕು ಹಾಗೂ ಕೊಳ್ಳುವವರು ಭೂ ಸುಧಾರಣಾ ಕಾಯ್ದೆಯಡಿ ಅರ್ಹಿಸಿರುವ ಷರತ್ತು ವಿಧಿಸಿ PTCL ಕಾಯ್ದೆಯ ಕಲಂ 4(2) ಅನ್ವಯ ಮಾರಾಟ ಮಾಡಲು ಸರ್ಕಾರ ಪೂರ್ವಾನುಮತಿಯನ್ನು ನೀಡಿದೆ ಎಂದು ತಿಳಿಸಲು ನಿರ್ದೇಶಿತನಾಗಿದ್ದೇನೆ ಎಂದು ಬರೆದಿರುತ್ತಾರೆ. ಆದರೆ ಈ ಪತ್ರ ವ್ಯವಹಾರದ ನಡೆಸಿರುವ ಕಡತ ಈ ಕಚೇರಿಯಲ್ಲಿ ಲಭ್ಯವಿಲ್ಲದ ಕಾರಣ ಮೇಲೆ ತಿಳಿಸಿರುವ ಮಾರಾಟ ಅನುಮತಿ ಪತ್ರದ
ರೆಕಾರ್ಡ್ಸ್ ಇಲ್ಲ.
My lord, 30 years ago ಅಂತ ಹೇಳ್ತಾ ಪೂರ್ವಾನುಮತಿ ನೀಡುವ ಪ್ರಕರಣ ಸರ್ಕಾರದ ಪತ್ರ. There is no.
88. You must have record to show whether there is permission granted or not, is it?
That I'll verify, my lord. Yes, my lord, I'll secure.
How can you say that there is no such permission? And you have not responded to his request.
Yes, my lord.
Where is that permission?
Yes, under these circumstances, I think it is necessary that the matter remitted back to the deputy.
We'll pass the same order, isn't it?
Yes, my lord, I can say.
Let the matter go back.
Permission is granted, then the matter can be closed here only if there is permission.
That is not.
Annexure J which I have produced.
Yes.
46 page. ಕೋಲಾರ ತಾಲೂಕು ವೇಮಗಲ್ ಹೋಬಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ 4 ಎಕರೆ ಜಮೀನು ಹನುಮಂತಪ್ಪ ಬಿನ್ ಹನುಮಂತಪ್ಪರಿಗೆ ಮಂಜೂರು ಆಗಿರುವ ಜಮೀನನ್ನು ಮಾರಾಟ ಮಾಡಲು ಅನುಮತಿ ಕೋರಿರುವ ಬಗ್ಗೆ ಪತ್ರದ ಸಂಖ್ಯೆ ಸೊ ಮೇಲೆ ಕೊಳ್ಳುವವರು ಭೂ ಸುಧಾರಣಾ ಕಾಯ್ದೆಯಡಿ ಕೊನೆಯಲ್ಲಿ ಕಲಂ 4(2) ಅನ್ವಯ ಮಾರಾಟ ಮಾಡಲು ಸರ್ಕಾರ ಪೂರ್ವಾನುಮತಿಯನ್ನು ನೀಡಿದೆ ಎಂದು ತಿಳಿಸಲು ನಿರ್ದೇಶಿತನಾಗಿದ್ದೇನೆ. ಲಾಸ್ಟ್
ಕೊಡಿ ಸರ್. ಒಂದು ಕಾಪಿ ಬೇಕು ನಿಮಗೆ, ಕೊಟ್ಟಿಲ್ಲ ನೀವು.
This must be available, isn't it, madam? How can you say that this?
Sir,
not
if it is, my lord, if it is genuine, my lord, definitely it is available, my lord. If it is many matters, my lord, say permission, they'll create documents and some other survey numbers document, whatever it is, my lord, I'll clarify, my lord. Next date of hearing. And this copy I needed, my lord, they have not served.
I'll further, my lord, further in the sentence.
If the permission is granted,
Further in the same order, my lord. Same para.
which order?
Same para.
ಕೊಡಿ sir.
Yes.
ಅದು ಸದರಿ ಯಾವುದೇ ಸ್ಪಷ್ಟಕ್ಕೆ ಬಂದಿಲ್ಲ. ಸರಿ ಸರ್. ದಿನಾಂಕ 27 ವರ್ಷ ಕೇಟೆಡ್ 27/9
ಎಲ್ಲಿ ಓದ್ತಿದ್ರೆ?
ಅದೇ ಪ್ಯಾರಾದಲ್ಲಿ
ಯಾವ paragraph? ಯಾವ
ಪ್ಯಾರಾ 4 ದಲ್ಲಿ ಇಂಟರ್ನಲ್ ಪ್ಯಾರಾ 4 ಮೇನ್ ತರೋ ಇನ್ನೇಗ ಅದು ಓದಿರಲ್ಲ ಅವರು ಸೇಮ್ ಪ್ಯಾರಾ
ಈಗ
ನಮ್ ರೇಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ
he relies upon annexure J, the sale permission.
ಅದನ್ನ ನಾನು RTO ದಲ್ಲಿ ಕೇಳಲಾಗಿ ಅಲ್ಲಿ ಇಲ್ಲೇ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅವ್ರು ಹೇಳಿಲ್ಲ RTL ಕೇಳಿದ್ರು suppose there is permission granted.
ಅದಕ್ಕೆ ಇದನ್ನ ಅಲ್ಲಿ DC ಹತ್ರ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಒರಿಜಿನಲ್, ಅದಕ್ಕೆ ಹೈಕೋರ್ಟ್ ರಿಮಾಂಡ್ ಮಾಡಿತ್ತು. ತಾವು ರಿಮಾಂಡ್ ಮಾಡಿದ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಫಾರ್ ಮೀ.
22nd.
ಅಲ್ಲ ಐ ವಿಲ್ ನಾಟ್
ಅಲ್ಲ ರಿಮ್ಯಾಂಡ್ ಮಾಡಿದ್ರೆ ಬೋತ್ ಅಗ್ರಿ ಪಾರ್ಟೀಸ್ ಬೋತ್ ಅದರಲ್ಲಿ.
ಅಲ್ಲ ಏನಂತ ರಿಮೈಂಡ್ ಮಾಡ್ಲಿ ನಾನು.
ಅಲ್ಲ
the finding is
Yes.
record was not sent by the government.
Yes.
He relies upon an reply to an RTA application.
Yeah.
Which says that there is no record. On what basis do I remind?
I have produced-
opportunity is not given to other parties.
Definitely.
Establish whether it is that
To establish.
particular permission.
I'll get a finding from her only here. Let her make a statement.
That's it. And 22 I will not be in the station, my lord.
Yeah.
28.
Opportunity is not given to.
28 will not. My lord, December 9th onwards, my lord, I will not be in this. Many marriage ಇದೆ. After December 9th. 12th December.
Number 51, Kumar JC.
Petitioner has taken the NOC with file, my lord. I'm supposed to file the retirement memo. I have informed to the petitioner also today, since the matter is listed. Morning.
Argument ಕೇಳಿದ್ನಾ? Argument ಕೇಳಿದ್ನಾ?
ಇಲ್ಲ ಇಲ್ಲ.
Application just.
ನಾನು ಲಾಸ್ಟ್ ವೀಕ್ ಅವ್ರು NOC ಕೇಳಿದ್ರು, ಇವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ ಹೇಳಿದ್ದೆ. And then they have
Continuously, so they are taking time.
because they are taking a NOC from me. Therefore, I informed to the other side also last week.
Not consider the petitioner files a memo in which it is indicated that he had returned the papers. The petitioner. And he therefore seeks to return. The memo contains the signature of the petitioner. In view of the above, we consider the petitioner is permitted to return. Office to print the name of petitioner in the cause list and relist it on.
Records are required. Records are required, original records in this matter.
29. Number 52 adjourned. Number 53, Sri Prasanna Kumar P.
Your lordship, kindly pass over, my lord.
Lordship permits me. Photo number 16 matter, serial number 2. List number 2, serial number 3, there is some urgency.
Urgency.
22nd.
Please.
My lords, list number 2, serial number 41 may kindly be taken up on Tuesday. There is urgency, my lords, in the matter.
Court officer said there are too many matters on
My
Tuesday.
lords, Wednesday.
Therefore, they'll adjust the posting accordingly.
Please, my lords, but there is urgency. The serial number 41, list number 2 can be taken up on Wednesday then, my lords.
My lord. Serial number 56 to file the statement of objection phrase
Number?
56. To file the statement of objection phrase 2 weeks time.
56/1 my lord. ಇದರಲ್ಲಿ BD acquisition ಆಗಿದೆ. I am but the grantee.
Connected ಹೆಂಗದು?
ಎರಡು ಕ್ಲಬ್ ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಎರಡು ಕ್ಲಬ್ ಮಾಡಿ ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಅದಕ್ಕೆ ಸೇಮ್ ಡೇಟ್ ಮೇ ಬಿ.
ಎರಡು ಒಟ್ಟಿಗೆ ಬರುತ್ತೆ.
I will produce the documents.
ಎರಡು ಒಟ್ಟಿಗೆ ಬರುತ್ತೆ.
ಹೌದು ಸ್ವಾಮಿ, ಎರಡು ಒಟ್ಟಿಗೆ. Update.
Remaining matters.
Date ಮೇಲೆ.
Same.
20.
My lord, serial number 59, list number 1. I pray for time,
Which year is
2 weeks, time. 2020, 2020.
Sir, what is 56?
59, serial number.
Playlist.
59.
56 my lords.
Serial number 61. LCR ಬರ್ಬೇಕು ಸ್ವಾಮಿ.
Sonary, 2011.
Serial number,
Please.
my lords, serial number
In
56.
56, in other matters.
Serial number 56.
kindly be heard.
In
ಅದು?
56, 29 ಬೇಡ ಸ್ವಾಮಿ, ಅವತ್ತು ವೆಡ್ಡಿಂಗ್ ಇದೆ ಒಂದು ಮನೆಯಲ್ಲಿ. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಯಾವ್ದಾದ್ರು?
56 year adjournment ತಗೊಂಡ್ರಲ್ಲ.
ಅಲ್ಲ ತಗೊಂಡ್ರು ಅವರು.
29th.
There are other matters also there. There are other grounds also there. ಎಲ್ಲವೂ ಕ್ಲಬ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಗ್ರೋಮೋರ್ ಸ್ಕೀಮ್ ಅಂತ ಹೇಳಿ.
ಇದು ಗ್ರೋಮರ್ ಅಂತ ಕ್ಲಬ್ ಆಯ್ತು ಇನಿಷಿಯಲಿ.
Next week decide ಮಾಡ್ತೀನಿ.
ಒಂದು ಎನಿ ಡೇಟ್ 21st ಹತ್ರ ಕೊಡೋಣ. 21st. ಸರ್
22nd.
ಆಯ್ತು ಮಚ್ಚ.
22nd. Please.
Application file ಮಾಡ್ತಾರೆ. 74 2 weeks. On the other. Application grant is children.
ನೀವು ಯಾರಿಗೆ?
Pardon my lord.
ನೀವು ಯಾರು?
I am for the objector before the authority.
Let us see, wait, please wait.
69 my lord. The record was called for, record ಬಂದಿಲ್ಲ. 69 I am for the petitioner. Respondent to the, it is the 96 sale 2004 initiation petition.
Sonary, 2015, please wait.
ಮೇಡಮ್ 50 ಏನಾದ್ರು ಅರ್ಜೆಂಟ್ ಆಗಿದೆಯಾ?
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಅಲ್ಲಿ ಡೇಟ್ ಕೊಡಿ.
56 22nd. 58 ಇಲ್ಲ ಅಲ್ಲ.
ಸರ್
Court of list 2 ಅಲ್ಲಿ serial number 27. Urgency ಇದೆ list 2
ಎಲ್ಲ
serial
dates
number
ಕೊಟ್ಟಿದ್ದೀನಿ.
27. Sir, ಇಲ್ಲ urgent 19 ಬೇಕಿತ್ತು.
ಹೇಳ್ತೀನಿ. ಯಾವ್ದು ಸರ್? ವಾಸು.
ಸರ್ ಲಿಸ್ಟ್ ನಂಬರ್ 3 ಥರ್ಡ್ ಟೈಮ್ ಇರೋದೆಲ್ಲ ಕಂಡೀಷನಲ್ ಆರ್ಡರ್. ಥರ್ಡ್ ಟೈಮ್
ಫಸ್ಟ್ ಟೈಮ್ 2 weeks.
2 weeks.
ಫೋರ್ತ್ ಟೈಮ್ 1 week. ಮಿಕ್ಕಿದ್ದೆಲ್ಲ ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ದಾರೆ, ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಓಕೆ.
Sir, serial number 59. Serial number 59 sir. 13 or 20.
29
29. Thanks.
ಆಗುತ್ತೆ.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 20.
ಎಲ್ಲ ಚೆಕ್ ಮಾಡಿ ನೆಟ್ ಅಲ್ಲಿ ಡೇಟ್ ಇದು ಮಾಡಿರ್ತೀವಿ. ಎಲ್ಲರೂ 40 ಜನ ಒಂದ್ ಕೇಳ್ತಾ ಇದ್ರೆ 40 ಜನ
Sir, please sir.
ಇರ್ಲಿ ಹೇಳಿ ನೋಡ್ತಾನೆ.
Wednesday ಹಾಕ್ಬಿಡಿ sir.
13 26 ಇಂಟರ್ ಆರ್ಡರ್ ಇರೋದಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನಲ್ಲಿ 20.
Sir, 41.
20 27 27
27.
41. Sir, 55.
ಹೇಳ್ತೀನಿ.
Sir, 55 ಇದೆ ಅಲ್ಲ? 55.
ಫಸ್ಟ್ ಲಿಸ್ಟ್. ಸರ್ ಇವಾಗ ಪಾಸ್ವರ್ಡ್ ತಗೋತಾರ
ಧಾರವಾಡದಿದೆ, ಕಲಬುರ್ಗಿ ಇದೆ.
ಇದೆಯಲ್ಲ?
ಸರ್ ಅದೇ ಕೇಳಿದ್ರು ಯಾವತ್ತು ಬರ್ತಾರೆ ಬಂದಿದಾರ ಹೇಳಿ, ಯಾವ ಡೇಟ್ ಬೇಕು ಹೇಳಿ.
ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ.
ಹೇಗೆ ಅವ್ರಿಗೆ ಹೇಳ್ತೀರಾ? ಹೇಗೆ ಭಾನುಪ್ರಕಾಶ್ ಅವ್ರಿಗೆ ಹೇಳಿ.
ಅದೇ ನಾನು ಈಗ ಅಲ್ಲಿ ಎಲ್ಲ ಕಾಯ್ತಾ ಇದ್ದೀರ, ಅದಕ್ಕೋಸ್ಕರ ಅಪ್ಡೇಟ್ ಒಬ್ಬರದ್ದು ರೆಡಿ ಇದೆ.
ಫ್ರೈಡೆ
ಫ್ರೈಡೆ
ಸರಿ
29 22nd. ಅದು ಫೈಲ್ ಹೋಗೇ ಇಲ್ಲ, ಚೇಂಬರ್ ಅಲ್ಲಿ ಇದ್ದೋಗಿದೆ ಫೈಲ್.
ಅಪ್ಲೋಡ್ ಆಗಿದೆ ಈಗಲ್ವಾ?
ಪಾಸ್ವರ್ಡ್ ಎಷ್ಟೊತ್ತಿಗೆ?
ಎನ್ನೆ ಅಪ್ಲೋಡ್ ಮಾಡಕ್ ಹೇಳಿದಾಗ ಅವ್ರು ಹೇಳಿಲ್ಲ ಫೈಲ್. ಮೇಡಮ್ ಎಲ್ಲ ಆಗ್ಬಿಟ್ಟಿದೆ ಮೇಡಮ್ ಅದೆಲ್ಲ.
Court officer. Hello, court officer. Court officer.
ಮಲ್ಲಾಪುರ್ ಸರ್ ಹೇಳಿ
ಬರಕತ್ತದ್ರಿ
ಸರ್.
ಐ ಆಮ್ ಆಡಿಯೋಬಲ್ ಅಲ್ರಿ? ಹಲೋ, ಧ್ವನಿ ಕೇಳಿಸ್ತಾ ಇದೆಯಲ್ಲ? ಲಾಸ್ಟ್ ಟೈಮ್ ಮ್ಯೂಟ್ ಆಗ್ಬಿಟ್ಟು.
ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆ, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅಲ್ಲ ಬಟ್ ನಮ್ಗೆ ಕೇಳ್ತಾ ಇದೆ.
ಥ್ಯಾಂಕ್ ಯು.
ಅಡ್ವೊಕೇಟ್ ಬೇರೆ ಕಡೆಯಿಂದ ಬಟ್ ಕೇಳ್ತಾ ಇದೆ ಸರ್.
ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಹಾಗೆ ಮಲ್ಸರ್ ಹೇಳಿ. ನಮಸ್ತೆ. ಅದು 60 days ಏನದ ನೋಡ್ರಿ ಆಫ್ಟರ್ ರಿಸೀವಿಂಗ್ ದ ಕಾಪಿ. ಅದಕ್ಕೊಂದು ಇದು ಡಿಲೇ ಹಾಕ್ಬೋದ್ ಬಿಡ್ರಿ ಅಪ್ಲಿಕೇಶನ್.
ಡಿಲೇ ಹಾಕ್ಬೋದೇನ್ ಮೇಡಮ್? ಯಾಕಂದ್ರೆ ಈಗ ಗವರ್ಮೆಂಟ್ ಇಂದ ನಾವು ಅಪೀಲ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಗವರ್ಮೆಂಟ್ ಇಂದ ಆರ್ಡರ್ ಬೇಕು.
ಅದೇ ನಮಗ್ ಜಿಯೋ ಮಾಡಕ್ಕೆ ಲೀಗಲ್ ಒಪಿನಿಯನ್ ತಗೊಳಕ್ ಲೇಟ್ ಆಯ್ತು ಅಂತ ಅದೇ ಅಫಿಡೇವಿಟ್ ಹಾಕ್ಬೇಕಂತ. ಆ ರೀಸನ್ ಮೇಲೆ IF ಫಾರ್ ಕಂಡೋನೇಷನ್ ಆಫ್ ಡಿಲೇ ಹೇಳ್ಬಿಟ್ಟು ಪೆಟಿಷನ್ ಫೈಲ್. ಅವ್ರ ಕಂಟೆಂಪ್ಟ್ ಹೋಗೇ ಹೋಗ್ತಾರ. ಅವ್ರ ಕಂಟೆಂಪ್ಟ್ ಹೋದ್ರುನು ನೀವು ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಿ ಅವಾಗ ಏನಾಗ್ತದೆ, ಈ
ಸರ್ ವಿಜಯ್ ಕಲ್ಸೂರ್ ಮುಟ್ರು ಲೈನ್ ಆಗಿದಾರಾ? ವಿಜಯ್ ಅವರೇ
ಹೇಳ್ರಿ.
ನಿಮ್ಮ ಮ್ಯಾಟ್ರ್ ಎಡ್ಜನ್ ಆತಲ್ಲ ಬುದ್ಧಿ?
ಹೆಜ್ಜೆನ್ ಆಯ್ತಾ?
ಹಾ.
ಎಲ್ಲಿ ಮೇಲೆ ಎಲ್ಲಿ ನೀವು ಇಲ್ಲಿ ಬಿಸಿ ಕುಂತ ಅಲ್ಲಿ ಎಲ್ಲಿ ಹೆಜ್ಜೆನ್ ಆಗತ್ತದು?
ಇಲ್ಲ. ಎಷ್ಟನೇ ಮ್ಯಾಟ್ರ್ ನಿಮ್ದ?
ನಮ್ದು 1, 2.
ಓಕೆ ಸರ್, ಬಾತ್ ಆಗ್ತದ ನಿಮ್ದ? ಜಲ್ದಿ ಮುಗಿತದ?
ನಮ್ದು 1 ಸೆಕೆಂಡ್.
ಓಕೆ, ದೆನ್ ಐ ಬಿ ಹಿಯರ್ ಓನ್ಲಿ. ಎಸ್ ಸರ್, ಎಸ್.
ನಿಮ್ಮಷ್ಟು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಂಗಿಲ್ಲ ನಾವು.
ನಮ್ದು ಎಲ್ಲಣ ಆರ್ಗ್ಯುಮೆಂಟ್. ನಿಮ್ನಂತೂ ನಾವು ಹೆದರಿ ಇಡ್ತೇವ.
ಮಾಂತೇಶ ಮಾಂತೇಶ
ಹಾ ಹೇಳ್ರಿ.
ನಿಮ್ದು ಎಷ್ಟು ನಿಂತದ?
ನಂದು 4 ಏನೈತಿ
ನಡೀತದನ?
ನಡಿಬೋದು, ಅವ್ರು ಅದರ್ ಸೈಡ್ ಟೈಮ್ ತಗೊಳತ್ತಾರ 4 ಅದ.
Seal number? Court. ಎಣ್ಣೆ ಸಲ ಕೊಡಕ್ಕಾಗಲ್ಲ. ನಿಮಗೆ ಕೊಟ್ರೆ ಎಲ್ರು ಕೊಡ್ಬೇಕು ನಾನು. ಎಲ್ಲರಿಗೂ 2 days time.
Lordship, kind permission.
18 to 22 days, 2 days. From 16th.
Your Lordship,
My lords, one submission, my lords.
kind-
Lord,
kind
CPC matter, my lords, for end of the list. The urgency is this, my lords. Delivery warrant has been issued, my lords, where police are already at the place, my lords.
70? ನೀವು ಯಾರಿಗೆ? Realist.
With your Lordship, kind permission.
Yes.
Matter at serial number 61, my lords. I am appearing for the petitioner.
Yes.
Some inconvenience I am not keeping well, my lords, today. Next week, if this matter may kindly be taken.
2011 ಚಿಕನ್ ಕೊಟ್ರೆ ಅದಕ್ಕೆ ನಾನು ಕೊಡಲ್ಲ ಅಂದೆ.
Minal ಹುಷಾರಿಲ್ಲ ಅದಕ್ಕೆ.
Finally, realist.
Next week, my
ಆಗಿದೆ.
next week, my lords.
Yes. 22nd.
Please.
Forward bench matters. For order, serial number 1, R.H. Angdi.
My lordship, in this matter, my lordship, I may kindly permitted to withdraw the petition, my lordship, since,
As requested, petition is dismissed as withdrawn.
please.
Serial number 2, Srimati Pallavi.
Restriction of time. Serial number 2,
Serial number 2,
Pallavi.
Pallavi Mohan Palekar.
ಇದೇನು ಕಾಣ್ತದೆ? ಇದೇನು ಮಾಡ್ತೀವಿ? 101. ಸಂಬಂಧ ಇಲ್ಲ, ಮುಗಿದ ಸಂಬಂಧ. Please notice that I 1/2024 seeking for extension of time has wrongly been. ಏನೇ ಮಾಡಿದ್ದೀನಿ? HCGP, serial number 2.
Jai Kalsurmat.
Kalsurmat. HG will take notice for responding. We list on. Please notice that application is filed seeking for extension of time in respect of criminal petition. One 101-908 of 2023. It is wrongly posted in criminal petition 101098 of 2024. The same be delinked and tagged along with criminal petition 101908 for 2023.
Serial number 3, PT Anuma Reddy.
Lords, I represent the respondent in this case, my lords.
My lords, in this case, accused number
Yes,
2
in
is
this-
case against accused number 2 already been quashed, my lords. He is RTO and he is a case worker. There is no allegations in the complaint, my lords. Not so pleased to see my lordship's order at it.
My lords, in this case, this petitioner is involved in as many as 3 cases, my lords. Just now I got the records of all the cases. Need to file detailed objections in this, my lords, so far as this petitioner is concerned.
This case,
This case,
Please, my lords.
with respect of this case is concerned.
case, how will it make a difference?
Ala, ಏನಾಗಿದೆ, similar offenses he has committed, my lords. He is an habitual
My lords,
offender.
kindly see, that is for
File objection.
So therefore, my lords, let the objections be on record, my lords. Next week, if your lordship have it, my
Next
lords,
week.
I'll file it. Any date in the
Next
next week, my lords.
23rd.
Are both so. Grateful.
Pleasure.
Seal number 4. Shares are open.
Please, my lord.
Respondent, my lord.
My lord, the petitioners are not able to deposit the interest, my lord.
All right.
Lordship, please.
Viresh Budihal.
Lords, I am for respondent, please, my lord. Lord, since my lords, the competent authority has already filed a section 5.2 petition before the Honorable Special Court, my lord. Keeping open all the questions to be considered by the Honorable Special Court, my lord, the petition may be disposed of, my lord.
Then annex referral, what?
Please, my lord.
Page number?
Page number 139, my lord.
This petition is filed challenging an order by which the competent authority has called upon the revenue authorities to make an entry in column number 9 of the RTC to the effect that there are dues recoverable in respect of the lands in question. A prayer is also made for issuance of a direction to the respondents to issue an objection certificate in favor of the petitioners in respect of the petition schedule lands by deleting the entry made in column number 9 of the revenue records. It is not in dispute that in the pendency of this writ petition, a petition has been filed by the competent authority to make the attachment absolute in terms of section 5.2 of the Karnataka Production of Financial Intermediary Act. So, in my view, since the question of attachment over the properties in question is pending consideration before the competent court, it would be improper to entertain this writ petition to delete the entries made in column number 11. Consequently, I find no reason to entertain the petition. Petition is dismissed. Liberty is reserved to the petitioners to raise all such contentions that are available to them in the proceedings initiated by the competent authority under section 5.
Pleasure.
Lords, one request, no. Serial number 3, my lords, may I request on 21st, lords, instead of 23? There is some inconvenience. Please, grateful.
Kalburgi bench matters for further consideration.
Lordship,
Seal
applying
number
for the
1,
petition.
Viresh Budihal.
Applying for the petitioner, sir. Lordship.
Yes, madam.
Lordship, the contesting response is R2 and R3.
Level other than a daily wage than
Alla, sir, it is that Dental Council of India, the arrears of the petitioner, the private respondent has to consider. He is online.
Yaro.
Lordship, applying for the petitioner, sir. Lordship.
Kadganchi was there.
Kadganchi ore.
Kadganchi, sir. Testing.
Kadganchi.
Sushit Kad.
Your Lordship, we had, as per your orders, we had informed him, Your Lordship, on the last date of hearing that the matter has been posted today.
ಇದ್ರಂತೆ ಆಗ್ಲೇ ಇವಾಗಿಲ್ಲ. Realist. Tell him next time he does not come, I'll dispose it off.
Sure. Obliged. Obliged.
Number 2. SG Mutt.
My lord, next to signal lesson by requested to AG officer. Hence, I'm representing before the office, my lord. Same connected matters, more than 10 cases in I want to club in this matter. Same connected matters ಇದೆ. Just 2 weeks time, please to grant.
2 weeks, sir.
2 weeks time, sir.
Where's Vijay Kumar?
Lordship, we will appear since these employees are working in social welfare department as well as the minority department, Lordship. I have received the affidavit from the minority welfare department. I am yet to receive the affidavit from the social welfare department. The employees who are working in those departments.
Madam, Yeshtina, madam.
Madam,
Sir, especially in this 2.5 and 2.6 in one petition, there are around 200 petitioners are there. Lord. So for each of them, I have to collect the
Lord,
first
may I make one more submission, Lord, sir? I am also one of the petitioners, Lord, in these batch of writ petitions. We have been, Lord, continued in the service as an assistant cook at various BCM hostels through, Lord, agency. Nevertheless, Lord, the departments, they have not been paying the wages of the petitioners regularly. 5-6 ತಿಂಗಳು ಕೆಲಸ ಮಾಡಿಸ್ಕೊತಾ ಇದ್ದಾರೆ, ಪೇಮೆಂಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ಅದಕ್ಕೆ earlier, Lord, an application was filed. Since, Lord, it was through an outsourcing agency, Lord, this honorable court felt that, Lord, in the absence of outsourcing agency being a party to this proceedings, Lord, no order could be passed.
Madam.
Lordship, in some of the places, due to the interim order, they have continued, and in the same place, the regular employees were also appointed.
ಇಲ್ಲ ಸಂಬಳ ಕೊಡೋದು.
ಒಂದು ಪ್ಲೇಸ್ ಅಲ್ಲೇ interim order ಇರೋದ್ರಿಂದ ಇಬ್ರಿಬ್ರು ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. That was the instruction.
ಇಲ್ಲ ಕೆಲಸ ಮಾಡಿಸ್ಕೊಳ್ತೀರಾ, ಸಂಬಳ ಕೊಡ್ಲೇಬೇಕು ತಾನೆ.
Specific. I will file one separate affidavit with regard to wherever it is not been paid and the reason for not payment.
ಕಷ್ಟದ ಕಾಲದಲ್ಲಿ ಎಲ್ಲ ಕೆಲಸ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡ್ಕೊಂಡು ಕೋವಿಡ್ ನೋಡ್ಸ 29 ಬಿಟ್ಟು ಬೇರೆ ಯಾವ್ದಾದ್ರು ಡೇಟ್ ಕೊಡಿ ಅದ್ರ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅದ್ರಲ್ಲಿ ಪ್ಲೀಸ್
ಡಿಸೆಂಬರ್ ಸರ್
ಪ್ಲೀಸ್
C number 3 Ganesh Subhash Chandra Kalburgi.
My lord, for petitioner filed an application seeking amendment and include the letter in prayer para. My lord, she want to challenge that letter, which was filed by the respondent number 2 along with his memo. The application is filed on 14/10, my lord.
It's not put up. File ಮಾಡಿದ್ರೆ
ಸರ್ ಎಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ರಿ ಸರ್?
ಇಲ್ಲೇ ಕಲಬುರ್ಗಿಯಲ್ಲಿ ಮಾಡಿದ್ವಿ.
Despite the order dated 8/11/2024, the registry has not put up the amendment application. Stated that the amendment application was filed on
14/10/2024.
Office is once again directed to put up the application. Relist on
22nd.
Much obliged.
C number 4 Mahatesh Patil.
My lord, I am appearing for respondent.
I appear for the petition.
My lord, as per the action of this honorable court, I have put words to my clients, my lords, to pay the compensation, but they expressed that there is an inability to pay the amount. That's
this matter.
What are the facts?
My lord, the petitioner was appointed in the year 2006, my lords, as an assistant teacher in the respondent school. Thereafter, my lords, in the year 2015, on 15/4/2015, she was not allowed to continue the service, my lords. Thereafter, in the year 2000, we...
1 minute, 1 minute. WP 2026.
026.
Sir. ಬರ್ತಾರೆ ನೋಡ್ರಿ ಸರ್ ಅದೇ ನಿಮ್ದು ಡೇಟ್ ಏನೋ ಆಗ್ಯದ ಅವ್ರಿಗೆ ಪೆಟಿಷನರ್ಗ ಸಾರಿ.
Yes.
Notes exhibit P6 and P7 notes are the documents which probabilizes that she was
The
as a
tribunal has dismissed
government
the application
employee.
on the ground that she was a temporary employee.
How?
For how many years did you work?
From 2006 to 2015.
2006 to
2015. On 15/4/2015, they not allowed to work notes in the school. Then I raised, I filed an appeal under section 94.
Have you produced at P5 and P6?
Notes P5 and P6, we have produced notes Provident Fund paid receipts, and P6 and P7 are the school's service certificates, wherein they stated that for 3-4 years I have been worked there and I have been continuous and my service is satisfactory. And the statements and the PF receipts are showing there is no breakup in their in her service. And the further the aspect would probabilize merits in view of the cross examination, wherein the respondent management has admitted certain things.
Yes. What do you say, respondent? She has worked from 2006 to 2015. She can't be considered as a temporary employee, isn't it? Unmute ಮಾಡ್ಕೊಳ್ಳಿ.
My lords, kindly pass or my lords, a senior will.
ಏನ್ ಪಾಸ್ ಅಷ್ಟೇ ತಾನೆ. I'll direct reinstatement, 50% back wages.
My lords, since one pass or my lords, senior is held up in another court.
Seal number 5.
I am appearing for the appellant in this case.
Yeah, sure.
So this was the issue regarding, my lord, the check issued for,
regarding
the check issued, my lord, towards premium, my lord, had bounced. What would be the liability of the, my lord, insurer?
ಏನ್ ಸುಭಾಷ್ ಅವರೇ?
My lords, my only contention is, my lords, that the check was dishonored thereafter on 13/12/2012. Am I audible, my lords? 13/12/2012, the policy was cancelled and the intimation was sent on 3/1/2013.
When?
The accident
Intimation
3/1/2013, my lords. The accident took place on 21/7/2013.
and the policy was valid till?
My lords, 30/12/2013 up to
30/12.
13/8, my lord.
13/8.
13th of August 2013, my lord.
Yes.
Policy was.
And when was the check given?
check was given in 2012 August only, my lord, at the time of, my lord, issue.
You have the date? You have the date?
Check dated 14/8/2012.
12/8/2012, Allahabad Bank of Mumbai.
12/8 or 14/8?
12/8.
R3 ಅಲ್ಲಿ 14/8 ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ ಚೆಕ್ ಡೇಟೆಡ್ ನಂಬರ್.
I can't hear you. The date of the check is 12/8 or 14/8?
14/8, my lords, 14/8.
13th is the date of expiry.
Yes.
But
Then 12th of August is the date of the check.
ಅಲ್ಲ ಸ್ವಾಮಿ 12th of the check date is, my lord, of 2012.
Correct. The previous policy expired on 13/8/2012.
Yes, my lords, 38/2012, the policy had
30th or 13th?
30th.
Are you sure?
No, I am not sure.
ಪ್ರೀವಿಯಸ್ ಪಾಲಿಸಿ ಬಗ್ಗೆ ಎಲ್ಲೂ ಏನು ಬಂದಿಲ್ಲ ಸರ್.
ಏನು ಬಂದಿಲ್ಲ.
Why did you take 4 months to present the check? Subhash.
My lords, even almost at the time of expiring of the policy, the accident took place and he has not, my lords, if your lordship goes to see that, after almost, my lords, 10 months from the date of issue of his check.
Lala, why did you take 4 months to present the check for encashment?
My lords, if Allahabad Bank, sometimes, my lords, if it is the check is not on par, the check has to go to the branch and thereafter, my lords, it has to come back. My lords.
Have you produced the check?
On par check idre same city alli idu agutte.
Alla, idu idbada guess bada. As a matter of fact, was it drawn on some other city branch?
Allahabad Bank. I don't have the copy of the check.
Lord, we were on the issue of, Lord, what will be the liability of the respondent number 2, whether they will have to pay and recover, or, my lord, they can, my lord, defend their case against the third parties as well, my lord. On that, my lord, there were 2 judgments furnished.
Deposit ಮಾಡಿದ್ರ ನೀವು ಪೂರ್ತಿ?
ಇಲ್ಲ, my lords, it is appealed by the claimants, my lords.
Claimants, sir.
Yes. My liability is not exonerated. I am exonerated.
Insurance company is exonerated. Lord, I am before the court. Lord, the first contention is the intimation regarding, my lord, cancellation is not there to the, my lord, owner. What they have produced is exhibit R5, which is a, my lord, list of their office showing that it has been sent by some registered, my lord, post or, my lord, a courier. Whether it has reached the owner and, my lord, whether he is informed regarding, my lord, the cancellation of policy, my lord, nothing is there.
My lords,
This judgment that rely upon the 3-judge judgment, antane?
Yes, my lord.
my lords, may I take your lordship to, my lords, Seema National Insurance versus Seema Malhotra and others. 2001, my lords, wherein there is reference of the 3 judges, my lords. May I read, my lords?
2000?
2001.
Citation
National
could be-
Insurance versus Seema Malhotra and others, my lords. In
Now
that,
put the
the
citation.
reference is also made over the,
Now give me the entire citation.
yes, my lords. AR 2001 Supreme Court 1197.
1197.
97, my lords.
Year 2001, Supreme Court 1197.
May I read the relevant portion, my lords?
Yes.
My lords, in para, a three-judge bench in Oriental Insurance versus Indrajit Kaur, 1998, so and so, they left this point unconsidered in the case of premium was paid by check, which was later dishonored, and the insured was intimated about it by the insurance company 2 months after the vehicle got involved in the accident. When the claim was made by the legal heirs of the driver who died in the accident, the insurance company resisted the claim on the strength of 64 VB of Insurance Act 1938. Repelling the contention, the insurance company, the 3 judges held thus. We have therefore this position despite the bar created by section 64 VB of the Insurance Act. The appellant, an unauthorized insurer, issued a policy of the insurance to cover the bus without receiving the premium. Therefore, by reason of the provisions of section 147(5), 149(1) of MV Act, the appellant became liable to indemnify the third party in respect of the liability which the policy that covered, and to satisfy the award of the compensation in respect thereof, with notwithstanding its entitlement. To avoid or to cancel the policy, reason that check was issued in the payment of premium thereon that not been honored. Thus, the 3 judges refrained from expressing any opinion on the question of the insurer's entitlement to avoid or cancel the policy as against the insured when the check issued for the payment of the premium was dishonored. Subsequently, same question was mooted before 2 judges of this court in New India Insurance versus Rula and others. But the question of insurer's right to repudiate the claim against the insured.
But the finding was the
My lords, thereafter, my lords, it has come to the conclusion. I'm continuously reading. If your lordship taking this into consideration, there was an interpretation. May I read, my lords?
Yes.
But the question of the insurer's right to repudiate the claim as against the insurer in a similar situation did not arise therein. Hence, the bar parried the question. Thus, the question now, this bench has discussed. Thus, the question now has to be considered as same as the crux of the issue involved in the case. As pointed out earlier, the insurance is a contract whereby one undertakes to indemnify another against loss, damage, or liability arising from an unknown or contingent event and is applicable only to some contingency or act to occur in the future. We have to consider how far the legislature has controlled the insurance business. Section 2, subsection 9 of the Insurance Act defines insurer inter-alia as any corporate body carrying on the business of insurance, which is a body corporate incorporated under law for time being in force in India. The section 2D of the Act says that every insurer shall be subject to all the provisions of this Act in relation to any class of insurance business, so as long as it is his liability in India in respect of business or class remains unsatisfied or otherwise provided for. It is in aforesaid context, we have to consider the impact of section 64 VB of the Insurance Act, as subsection 1 and 2 of the Act alone are materials for the purpose we extract them from herein. No insurance shall assume any risk in India in respect of any insurance business on which the premium is not ordinarily payable outside India unless and until the premium payable is received by him or is guaranteed to be paid by such person in a manner in which within such time as prescribed or unless until the deposit of the amount as may be prescribed is made in advance in prescribed manner. For the purpose of this act, two manners. For the purpose of this act, in cases of risk for which the premium can be ascertained in advance, the risk may be assumed not earlier than the date on which the premium has been paid in cash or by check to the insurer. The subsection 1 is not applicable. Not applicable to the cases in which the premium is ordinarily payable outside India. In other words, the insurer has no liability to the insured unless and until the premium is payable received by the insurer, as the premium can be paid in cash or by check. What is the position when the check has issued to the insurer is dishonored by dry bank? That is the question mark. The Lordship got one.
Yes.
Let's say at page number 5, read ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
ಯಾವ paragraph?
I don't have the number, my lords. Section 150 to 150, section 52, 51, 52, 54 of the contract.
Yes.
Dry bank. The section 51, 52 and 54 of the Indian Contract Act can profitably be referred to for the purpose of deciding the point.
Yes.
They are subsumed under the subtitle Performance of Reciprocal Promises in the Act, in the said Act. Section 1 deals with the contract concerning the reciprocal promises to be simultaneously performed, and in such contract, a promise is absolved from performing his promise unless the promisor is ready or willing to perform his part of the promise. Section 52 says that where an order in which the reciprocal promises are to be performed has not been expressly provided in the contract, such promises shall be performed in that order which the nature of transaction warrants it. Illustration given under section 252 highlights the utility of the provision. That illustration is as follows. A and B contract A that A shall make over his stock in trade to B at a fixed rate, and B promises to give security for the payment of the money. As promise need not be performed until the security is given, for the nature of the transaction requires that A should have the security before he delivers such up his stock. Section 54 of the contract is to be read in the background, in that background. It is the extract below. When the contract consists of reciprocal promises, such that one of them cannot be performed, or that its performance cannot be
But Subhash,
until yes,
Subhash, in this case, it was a case where the insured's wife and child had raised a claim against insurance company.
No.
This
no,
is not a case where a third party had made a claim.
My lords, here the question is not regarding the claimant, my lords. It is regarding the contract.
Correct.
When there is a failure on part of the, my lords, the insured to perform his part, that becomes null, and that is what further it has stated.
Paragraph 1, my lord, about 5th line. They start with the, my lord, discussion saying that there is no dispute insofar as the position of insurer paying, my lord, to the third parties. Paragraph 1, my lord, leave granted under the contract. It starts with, my lord, under a contract of insurance. About not the number may be different. I'll read, my lord, the first paragraph, the first half. Under a contract of insurance, the insured gave a check.
Yeah, this is what was referring to.
There is no
dispute that the insurer is liable as against third parties because it is covered by the statutory provisions contained in Chapter 10 of the Motor Vehicle Act.
Yes, but
that you are bound, isn't it?
Yes.
My lord, sir, and also the coordinate bench of this honorable court in my lord, sir, MFA 23909 of 2013, my lord. This honorable court based on
MFA?
the MFA 23909 of 2013 disposed on January 24, 2024.
Consider MFA 2390
9, my lord.
of 2000
13, my lord.
disposed of one.
On 31st January 2024, my lords. There, the honorable
31st
court
of
has
January
held
20.
31st January 2024.
Look, that judgment is
ಅಲ್ಲ
already-
ಅದ್ರೊಳಗೆ ಏನಾಗಿದೆ he has slept over, my lords, without checking whether the, my lords, his check has been honored or dishonored, my lords.
No, is this
It
referred?
is even the role of, my lords, here almost on a lapse of even the insurance policy which was issued.
No. In this
would
judgment,
have lapsed another next month, my lords.
in this judgment, Subhash, in this judgment, they have not relied upon, they have not considered the three-judge decision, isn't
My
it?
lords, they have relied upon the Seema Malhotra case, my lords, where, my lords,
Seema Malhotra case is not applicable.
a contract, my lords, according to section 65 of the contract, that says when a contract becomes void, any person who received the advantage under such is.
No, but in Seema Malhotra's case, they have categorically said that this not be applicable to a third-party claim.
My lords,
Alva?
my argument would be, my lords, any contract which is void. So the question of insurance company indemnifying, my lords, that is my argument. So,
Alva?
asked.
Reserved.
But one, my lord, information I may have to give it, my lord. The respondent, one counsel is dead, my lord, but anyhow, my lord, that may not make a difference because there will be no orders against the owner.
All right.
There was one division bench judgment as well, my lord, dated 17/4/2023. That is already, my lord, the copy is given. MFA number 306 of 2019, where, my lord,
MFA?
MFA 306 of 2019, dated 17.
All right.
Yes, it's already furnished, my lord.
All
Wait.
right. Reserved.
Wait.
Make the amount in dispute illa alva?
Allah, it's a ECA claim, my lord. It's almost right, my lord. There is no issue.
Yes.
Bandra ಅವರು ಶಿವಗೆ ಮಠ.
My lord, see, the matter is going on, my lord. Another 2 minutes, it will be finished, my lord.
Your bench matters, passed over matter. The number 10, Shri V.B. Sidramaya.
In this case, my lord, we are seeking a transfer from Bengaluru to Bagalkot, madam.
Complaint ಮಾಡಿದ್ರಾ?
Complaint ಮಾಡಿದ್ವಿ, madam.
Bangalore to
Bagalkot, madam. My lord, respondent has filed a MC petition before the family court, my lord, for dissolution of marriage.
petitions for take out copy of court notice and the counsel who represent the respondent in the trial court. Interim stay.
Grateful.
Released on that date, inform them, it will be taken up.
Please,
29th.
Sir?
29th.
Please. Grateful.
The number 14.
Recalling the Assistant Commission's order with sanction. Earlier order, my lord, at annexure G. And after the instructions of the Lokayukta, my lord, the ACS reopened the order. But the complaint is also not filed by the grantee or any interested person. One Manjunath, my lord, he has filed the complaint.
The first order of resumption has become final.
Yes, ma'am. They are not challenged. And before the Lokayukta, one Manjunath, my lord, who is nowhere connected to the land, filed a complaint.
Where is the first order of resumption?
The annexure G, my lords.
Page 77.
70, my lord. 26/2007. ಪ್ರಸ್ತಾವಿತ ಜಮೀನಿನ ಸರ್ಕಾರದ ಸ್ವಾಧೀನಕ್ಕೆ ಪಡೆಯಲು ಹಾಗೂ ಸದರಿ ಜಮೀನಿನ ಹಕ್ಕು ದಾಖಲೆ ಮೂಲ ಮಂಜೂರಿದಾರರ ವಾರಸುದಾರರಾದ ಅರ್ಜಿದಾರರಿಗೆ ಪುನಃಸ್ಥಾಪಿಸಲು ತಹಸೀಲ್ದಾರ್ ದೇವನಹಳ್ಳಿ ತಾಲೂಕರಿಗೆ ಆದೇಶಿಸಿದೆ. This order has not been challenged by any one of the parties. And after, my lord, 3.5 years, my lord, one Manjunath who is now connected with the, my lord, he approaches the Tahsildar. I mean, the Lokayukta. And the Assistant Commissioner also once again made known to the Deputy Commissioner that there is already an order passed. This order passed. I cannot reopen the file. But despite the direction given by the Lokayukta, my lord, he reopens the matter. Lokayukta, next document, my lord.
If you notice annexure A,
No, annexure A came to be passed.
but how can you do it? How can you recall it? 90?
Annexure N, my lord,
Yes.
to the Assistant Commissioner.
You're directed to take action to pass an order. How can the local
Against the
issue-
officials.
Where original grantee who are the respondent 4 to 8 are not the original grantees. There is land has been granted in year 1961 Muni.
Lala.
Muni Marappa.
First, TM Krishnappa and two others made an application for resumption.
But they are not the original grant.
But an order is passed in their favor.
But they are, in that view of it, the locals are directed to declare.
Like this order of resumption is passed, how can it be modified? By the Assistant Commissioner.
They have been played a fraud, have been played.
Who played the fraud?
Respondent 4 to 8.
Yes, sir.
TM Muni Marappa and but they are Muni Marappa and their children have been played a fraud.
In fraud.
They are not the original granted. And has been originally granted to one.
But you should challenge this order, isn't it?
Where I had to challenge, where the petition doesn't have a local standing. When he is not a party to either of the annexation.
No, but if he is a purchaser of this land, any order of resumption of.
Where the annexation A. Annexation A is passed in the year.
To which he is not a party.
He is
To-
not a party. He is not a party. For annexation G also he is not a party.
Correct.
So can you make it is saying?
Page number?
Page number 131.
Yes, Krishnappa.
Yes.
Krishnappa would,
Krishnappa.
he was a person who had got the benefit of the resumption.
No.
Yes, my lord.
Yes.
Oh, yes. It dated 28/2011.
Ah.
Document is dated.
Correct.
TM Krishnappa, they are not the original legal names. Original legal names of TM Muni.
He is a third party, my lord.
They are the children of Muni Maraya. The land has been granted to PM Muni Marappa. Muni Ramaya.
He is a purchaser who purchased the land after obtaining permission.
No, as on date of 2011, there is permission itself is not there. I can again. There is this ready page number 131.
135, page 135. Whereas the vendors got permission to sell the scheduled property by the Deputy Commissioner, by RO numbers dated 14/7/2011.
11. Where this document is registered in the year 2017.
ಅಲ್ಲ ಯಾವನ ರಿಜಿಸ್ಟರ್ ಆಗಿರ್ಲಿ ಸೇಲ್
He is waiting, after passing of the order of the Assistant Commissioner. He is waiting to pass the order.
the sale deed is registered
Yes.
after the permission is granted.
Where that permission itself now has been cancelled.
ಇವಾಗ ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ರೆ ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ if this
If there has been played, a fraud has been played. They
ಏನ್ fraud has been played?
Where Munimarappa is the Munimarappa PM and Munimara, they are not the original grant.
Why was it kept pending registration for 6 years?
Yes,
Well, it was only for the seeking for sanction by permission.
So when the state was presented for registration, there was no permission.
No, my lord.
No.
After obtaining sanction only, man. 28 is 11 is the
No, then why was it kept pending for
next month only 14/7/2011 ಅಲ್ಲಿ sanction ಕೊಟ್ಟಿದ್ದಾರೆ.
Then why was it kept pending registration for 7 years?
7 years ಅಲ್ಲಿ 28/2011 ರಿಜಿಸ್ಟರ್ಡ್ ಆಗಿದೆ ಸೇಲ್ ಡೀಡ್.
ಇಲ್ಲ ರಿಜಿಸ್ಟರ್ ಆಗಿರೋದು 2017ರಲ್ಲಿ
ಪ್ರೆಸೆಂಟೆಡ್
11
28 ಡೇಟ್ ಆಫ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ 28/11 ಅಂತ ಇದೆ ಟಾಪ್ ಅಲ್ಲಿ.
2011 only it's got
11
registered.
Paying for 146. This case is completed on 23/6/2017. Document is written on 2011.
ಏನಕ್ಕೆ why is this?
ಅಲ್ಲ that explanation I don't know, man, because I am the purchaser.
It's your sale deed. It's your sale deed. ಏನ್
ಡೇಟ್
ಏನಾಗಿದೆ?
2011 ಬರ್ದಿದ್ದಾರೆ.
ಏನಾಗಿದೆ ಅದ್ರಲ್ಲಿ?
ಅದು ರಿಜಿಸ್ಟ್ರೇಷನ್ ಅಂತ ಅಂದ್ ಗೊತ್ತಿಲ್ಲ. ದಿನಾಂಕ 28/2011 ಅಂತಲೇ ಇದೆ.
ಇಲ್ಲ ಸೇಲ್ ಡೀಡ್ ಡೇಟ್ ಕರೆಕ್ಟ್.
ಹೌದು.
ಬಟ್ ಲಾಸ್ಟ್ ಪೇಜ್ ರಿಜಿಸ್ಟ್ರೇಷನ್ 23/6/2017. ಏನಕ್ಕೆ ಪೆಂಡಿಂಗ್?
ನಂಬರ್ 17-18 ಅಂತಿದೆ. But whatever is the reason, may not, because he cannot have any say, may not, because the order once is passed. Now whether question remains, lordship is, may not, whether the earlier order could be annulled or invalidated by virtue of another order at the instance of Lokayukta, who does not assume any jurisdiction of usurping the jurisdiction of the.
No, I want to know why was it kept pending registration?
Well, that I have to verify. Sub register Devanali 23/2017 ಅಂತಿದೆ.
List.
Well, in the meantime, I filed the application for notice also, well, that may also be ordered.
Notice to whom?
Paper publication, R3, 4 and 8, my lord.
Yarna, whom do you want to notify?
6 and 8, my lord.
Who 6 and 8?
6 and 8, my lord. 6 to 8, my lord.
Yaro?
No, they are the LRs.
LRs of?
Of my lord, original grantees, my lord, TM Krishnappa. I mean, my lord, TM Krishnappa.
ನೀವು ಯಾರಿಗೆ?
ಅವರು ಮುನಿಮಾರಯ್ಯನವರಿಗೆ 12ನೇ. And this is the persons, my lord, R4 ಅವರು ನಮ್ಗೆ ಮಾರಾಟ ಮಾಡಿದರು.
ಯಾರು? ಇಬ್ರಿದ
ನಮ್ಗೆ ಸೇಲ್ ಮಾಡಿದರು. ನಮ್ಗೆ ಸೇಲ್ ಮಾಡಿದರು.
You are supporting him. You are support ಮಾಡ್ತಾರೆ.
One more thing, where vendor of the petitioner had filed an application.
ಇವಾಗ TM ಕೃಷ್ಣ for notice service ಬೇಕು ಬೇಡವಾ? Because the order is in his favor, isn't it? The order of resumption is in his favor.
Well, I want to take action R6 and R8, my lord. They are the LRs of, my lord, the TM Krishnappa. The persons whom against I want to take notice with the LRs of TM Krishnappa. So they are necessary parties also.
No, this is only in favor of Muni Nanjamma. So Muni Nanjamma is the only person who's necessary. TM Krishnappa, they have not challenged this order.
They did not. They have executed the idu. ನಾನು ಸೇಲ್ ಡೀಡ್ ನಮಗೆ ಕೊಟ್ಟಿರೋದು. ಅವ್ರು ಚಾಲೆಂಜ್ ಮಾಡೋ ಪ್ರಶ್ನೆ ಬರುವುದಿಲ್ಲ. ಮಾಡಲಿಲ್ಲ ಅವರು.
Annexure A is an order passed on the petition filed by TM Krishnappa, TM Rajanna, AK Dudmuniamma and Muni Nanjamma.
Muni Nanjamma.
In this, the order of presumption is in favor of Muni Nanjamma. It's not in favor of Krishnappa, Rajanna and Dudmuniamma. Therefore, they have accepted this order.
Annexure A, my lord.
So they have accepted this order.
Accepted this order.
So why should they be notified?
Because since they are the parties to the proceedings, I made them party.
That filed an appeal.
You pending idea?
No, pending. Now, as on today, it is pending.
It is stated that an appeal has been filed by respondents 6 to 8, ಇಲ್ಲ 5 to 8.
ಮಾಡಿದಾರಾ?
ಇಲ್ಲ 4 to 8.
They have not served any copy.
4 to 8. before the deputy commissioner.
Petitioner has also filed an impeding application now.
ಅಲ್ಲ ನೀವು ಅಪ್ಪಿ ಆಗ್ತಿಲ್ಲ ಟಿ ಎಂ ರಾಜಣ್ಣಗೆ ಅಪ್ಪೇರ್ ಆಗ್ತಿರಲ್ಲ.
They are not.
With deputy commissioner appeal number against the very same impugned order.
PTCL 18 of 2020.
Very PTCL appeal ಅಂತ ಬರ್ದಿಲ್ವೇನೋ. Detail ಬರ್ರಿ. In view of the above, the petitioner is directed to take out notice on the counsel who represents R4 to R8 before the deputy commissioner. Relist on.
Well, I will verify from DC's office, man. I will verify from the DC's office.
22nd.
They have to notify me, man. I will not be knowing.
ಇವಾಗ ಗೊತ್ತಾಗತ್ತಲ್ಲ ಹೋಗಿ ನೋಟಿಫೈ ಆಯ್ತಲ್ಲ ನಿಮ್ಗೆ. You are now notified.
ಅಲ್ಲ, ಇದು ಯಾರು ಅಂತ ಗೊತ್ತಿಲ್ಲ.
ಅಲ್ಲ ಅವ್ರ ನಂಬರ್ ಕೊಟ್ಟಿದ್ದಿಲ್ಲ. I am permitting you to serve a copy on them.
I lost my on second week of December. I will verify that.
12th December.
Please.
12th December. Number 41. Shiv Shankar.
My lordship, since morning that passed out for the no work, what happened in this case, my lordship, no work is pending, my lordship. Already bill as amount has been transferred, my lordship. Hardly amount is 2,565, my lordship.
ಸಲ ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ ನಾವು ಮುಗಿಸೋಣ ಯಾರು ಇವತ್ತು ಅವ್ರು ಬಂದು ಹೇಳಿ ಏನಂತ.
Seal number 55, sorry, seal number 53. Prasanna Kumar.
For the petitioner, not suit for partition. I am my lord's the son, defendant, number 1. My mother, my lords, files the partition suit. I had, my lords, filed my written statement.
You are the plaintiff or defendant.
I am the defendant number 1, the son. My mother had filed the suit for partition. My lords, I am the only one, my lords, contesting the suit. For the reason that, my lords, few of the properties that are, my lords, part of the
What is the order impugned?
order impugned is, my lords, I had filed, my lords, an application seeking, my lords, transposition of D2 to D5, who are the daughters, as, my lords, the plaintiffs.
The first defendant makes an application to transpose
D2 to 5
as plaintiffs.
as plaintiffs,
What
because,
is
my
your interest?
lords, because what had happened is, my lords, I am the only one, my lords, contesting the suit.
Ah.
All of them, my lords, have colluded with the plaintiff, the mother, and, my lords, they have given, my lords,
How can you seek for transposition?
that, my lords, I had filed an application under, my lords, section order 1 rule 10 sub rule 6.
What
my
is your right? How can you?
Because, my lords, I am, my lords, we are not sailing on the same boat, because they have, my lords, given a complete go by to my defense.
It's a suit for partition.
Please, my lords,
Everybody is a plaintiff there.
please, my lords.
Then what is
Alla,
the?
ಅದಕ್ಕೆ, my lords, on this point, my lords, the Supreme Court says, my lords, in other cases, my lords, either, my lords, the suit has to be abandoned or, my lords, withdrawn by the plaintiff in order for, my lords, me to seek a transposition. However, my lords, in a suit for partition, my lords, the stand of the parties changes.
I'm doubting your locus standi to make the application.
No, because, my lords, order 1 rule 10 sub rule
How
6.
can the defendant say who should be the plaintiff or who should be the defendant?
The court can, my lords, exercise. the
Plaintiff
power.
is a master of the list.
Please, my lords,
She has arrayed her daughters as defendants.
please, my lords.
How can the son come and say, no, the daughters also should be the plaintiffs?
No, because I had filed the written statement. They have also, my lords, now filed a written statement. Where, my lords, they have, my lords, given, my lords, complete go by to my defense or whatever the setup that I have made. And, my lords, secondly, my lords,
Trial court dismiss the application.
my lords, the trial court says, my lords, it refers to, my lords, order 23 rule 1A, my lords, transposition under, my lords, order 23. There it says, my lords, either the plaintiff should have withdrawn the suit or, my lords, they should, she should have abandoned the suit. That is not the case here.
Trial court has not considered the question as whether you could have made the application.
Please, my lords, because order 1 rule 10 sub rule 6, my lords.
Considered that
No, that point has not been considered, my lords. Because, my lords, the court has so much of power to exercise such power.
So much ನಿಮಗೆ ಅಧಿಕಾರ ಇದೆಯಾ ಅರ್ಜಿ ಹಾಕಕ್ಕೆ?
ಅಲ್ಲ, because, my lords, order 1 rule, ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ಹೇಳುತ್ತೆ, any person can make an application, my lords, is what the
So
provision
according to
says.
defendant, suppose there are 4 plaintiffs.
Please.
Defendant can make an application to transpose 4th plaintiff as the 5th defendant because you think there's a conflict of interest. So you are you are kind of monitoring the entire list.
No, the reason is this, my lords, because my defense is very clear, my lords. The properties that are in the leases.
I'm only on the question of your
Ah.
locus standi to make the application. Jana? The petitioner was the first defendant.
But I'll just place on record, my lords, one judgment.
The suit for partition, which was incidentally filed by his mother, not only against him, but also against his sisters. In the said suit,
Para number 13, my
the
lords.
petitioner made an application seeking for transposition of his sisters who had been arrayed as defendants 2 to 5 as plaintiffs 2 to 5. This application has been rejected by the trial court and hence the petitioner is before this court. In my view, the petitioner who was the first defendant before the trial in the suit would have no right to make an application to transpose his co-defendants as plaintiffs. The question as to whether it was only up to the defendants 2 to 5 to have made an application seeking for transposition, and the petitioner had absolutely no right to seek for such transposition. Therefore, of the view that there is no merit in the writ petition, the petition is therefore liable to be dismissed. ಯಾವ ವರ್ಷದ
Lords, 2020, my lords.
ಯಾವ stage?
No, senior escalator. Senior escalator.
Trial court to expedite the hearing of the suit. 2020 ಕಂಡ್ರೆ ಇನ್ನೂ ಲೇಟ್ ಇರೋದಿದೆ. 2020
Seal number 55, Srimati Jayalakshmamma.
Writ of mandamus, my lord, I have given a representation before the respondent number 1 and 2 to seeking permission to sell the property, my lord. And also the respondent number 2, one has given intimation to the respondent number 2, my lord, stating that consider their representation as per rules, my lord. Till today, they have not considered.
State government DC na?
DC, my lord.
State government permission. State ne party ಮಾಡಲಿಲ್ಲ ನೀವು?
And I have served the copy. Deputy Commissioner and
No.
Tahsildar has made a party, my lord.
I don't think they are entitled to.
I given intimation, my lord. The respondent number 1 has given intimation. Annexure K, my lordship, kindly see, my lord.
Next year?
Annexure K, page number 36, my lord. 16/10/2023, given intimation to the Tahsildar. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಶ್ರೀಮತಿ ಉಮಾ ಎನ್.ಜಿ. ಹೋಂ ವೆಂಕಟರಾಮ್ ನಂಬರ್ 176 ವಿ ಗುಟ್ಟಳ್ಳಿ ಗ್ರಾಮ ಅವಣಿ ಹೋಬಳಿ ಮುಳಬಾಗಿಲು ತಾಲೂಕುರವರು ಉಲ್ಲೇಖದಂತೆ ಈ ಕಚೇರಿಗೆ ಮನವಿ ಸಲ್ಲಿಸಿ ನಾನು ಕಾಮಸಮುದ್ರ ಹೋಬಳಿ ನಡಂಪಲ್ಲಿ ಗ್ರಾಮದ ಗೋವಿಂದಪ್ಪರವರ ಮಗಳಾಗಿದ್ದು ನನಗೆ ಮೇಲ್ಕಂಡ ವೆಂಕಟರಾಮರವರಿಗೆ ಸುಮಾರು 15 ವರ್ಷದಿಂದ ಮದುವೆ ಮಾಡಿಕೊಟ್ಟಿರುತ್ತಾರೆ. ಅಂದಿನಲ್ಲೂ ನಾನು ನನ್ನ ಗಂಡನ ಮನೆಯಲ್ಲಿ ವಾಸವಾಗಿರ್ತೇನೆ. ನಮ್ಮ ತಂದೆಯವರು ನನಗೆ ಅವರ ಆಸ್ತಿಯಲ್ಲಿ ನನಗೆ 2 ಎಕರೆ 20 ಗುಂಟೆ ಎಕರೆ ಜಮೀನನ್ನು ವಿಭಾಗದ ಮೂಲಕ ನೀಡಿರುತ್ತಾರೆ. ಸದರಿ ಜಮೀನಿನಲ್ಲಿ ವ್ಯವಸಾಯ ಮಾಡೋದನ್ನು
I don't think Tahsildar has the power to do this.
Yes, my lord. Already order is ordered, my lord. I have given, sir, notice also served, my lord.
I will direct the deputy commissioner to forward the request to the state government to take a decision within a month or 2.
Whatever document are there, my lord, I have produced along with the writ petitions, my lord. And in respect of grant, there is no dispute, my lord.
If you wanted to produce any particulars, let her know what are the particulars she should furnish. ಯಾವಾಗ ಹೇಳ್ತೀನಿ? 23rd.
Okay.
P6 adjourned.
Bill number 57, Shri Narasimhamurthy.
Hearing for petitioner, my lord. Challenge the annexure D, grantee petition, my lord.
Annexure.
Annexure D, my lord. Sorry, annexure C, page 38, my lord. Para number 17. Why was it refused? My lord.
Why did application refuse resumption?
My lord, divergent finding.
ಏನಕ್ಕೆ?
ಇದು ಸೆಕ್ಷನ್ 4(2) ಪೂರ್ವಾನುಮತಿ ಪಡೆಯದೆ ಅಂತ.
ನೀವು ಗ್ರಾಂಟ್ ಇತ್ತಾನೆ?
ಹೌದು. ಈ ಎಲ್ಲಾ ಅಂಶಗಳನ್ನು ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಉಪವಿಭಾಗರವರು ನಿಯಮಾನುಸಾರ ಪರಿಶೀಲನೆ ಮಾಡದೆ ಆದೇಶ ಹೊರಡಿಸಿರುವುದು ಸಮಂಜಸವಾಗಿರುವುದಿಲ್ಲ. PTCL ಕಾಯ್ದೆಯಡಿ ಸರ್ಕಾರದ ಪೂರ್ವಾನುಮತಿಯನ್ನು ಪಡೆದು ವಿವಾದಿತ ಜಮೀನು ಪರಭಾರೆಯಾಗಿರುವುದರಿಂದ PTCL ಕಾಯ್ದೆಯಡಿ ಮರು ಮಂಜೂರಾತಿ ಮಾಡಲು ಅವಕಾಶ ಇರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಪ್ರಶ್ನಿತ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಉಪವಿಭಾಗರವರು ಹೊರಡಿಸಿರುವ ಆದೇಶ ಮಧ್ಯೆ ಪ್ರವೇಶಿಸುವ ಸೂಕ್ತವೆಂದು ಭಾವಿಸಿ ಕೆಳಕಂಡಂತೆ ಆದೇಶಿಸಿದೆ.
They had obtained permission and then sold the property.
Please, my lord, kindly, Assistant Commissioner order, operative portion, page 31, my lord. ಚಿಕ್ಕಬಳ್ಳಾಪುರ ತಾಲೂಕು ನಂದಿ ಹೋಬಳಿ ನುಗತಲ್ಲಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 54, ಹೊಸ ಸರ್ವೆ ನಂಬರ್ 160, 2 ಎಕರೆ 37 ಗುಂಟೆ ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದ ಮಂಜೂರುದಾರರು ಸರ್ಕಾರದಿಂದ ಪೂರ್ವಾನುಮತಿ ಪಡೆದಿರುವುದಿಲ್ಲವಾದ್ದರಿಂದ ಕಾಲಂ 4(2) ಅನ್ವಯ ಪರಿಶಿಷ್ಟ ಜಾತಿ ಪರಿಶಿಷ್ಟ ಪಂಗಡದ ವ್ಯಕ್ತಿಗಳಿಗೆ ಮಂಜೂರಾದ ಜಮೀನನ್ನು ಸರ್ಕಾರದ ಪೂರ್ವಾನುಮತಿ ಪಡೆಯದೆ ಮಾರಾಟ ಮಾಡುವಂತಿಲ್ಲ.
ಇಲ್ಲಿ ಮಾಡಿದ್ದೀನಿ ಅಂತ ಅಂತಾರೆ ಡೆಪ್ಟಿ ಕಮಿಷನರ್.
Deputy Commissioner is, my lord, kindly. My lord, the one N.M. Muniyappa son of Munishamappa is sold the property. Permission is granted.
There is a permission.
Permission. One N.M. Muniyappa son of Munishamappa is created the documents. My lord, annexure A, grant certificate.
ನೀವಲ್ಲಿ ಹೇಳಿದ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ it is granted permission. Okay, how will you know?
ಅಲ್ಲ. My lord, the land grant in favor of one Ramakrishnappa son of Gundalappa. Permission is granted in favor of Muniyappa son of Munishamappa. Is created the documents.
ನೀವು ಯಾರು?
Now grantee daughter Bharatamma. Ramakrishnappa maglu.
ನಿಮ್ ಪ್ರಕಾರ ಗ್ರಾಂಟಿ ಯಾರು?
Grantee annexure A, my lord, page number 10, Ramakrishnappa son of Gundalappa. Is create the documents. ನಾನು ದತ್ತುಪುತ್ರ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕ್ರಿಯೇಟ್ ಮಾಡ್ಕೊಂಡು ಸೋಲ್ಡ್ ದಿ ಪ್ರಾಪರ್ಟಿ. There is no relation between the Ramakrishnappa and N.M. Muniyappa. Suit is dismissed and appeal also is allowed. My favor, my lord.
You had filed a suit.
Suit is filed. Gundalappa is filed the suit. Ramakrishnappa is filed the suit. The evidence correct ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅಪೀಲ್ ಅಲ್ಲಿ ಅಪೀಲ್ ಅಲೋ ಮಾಡಿದ್ದಾರೆ.
ನೀವು ಭಾರತಮ್ಮ.
ಹೌದು.
You claim that the property was granted to Ramakrishnappa, your father.
Please.
What was the suit that you filed?
Suit is filed one Ramakrishnappa.
That is your father.
Please.
Against whom?
N.M. Muniyappa.
Against your adopted son.
Adopted son ಅಂತ. ಅದು ಸೂಟ್ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು. ಅಪೀಲ್ ಹಾಕಿದ್ಮೇಲೆ ಅಪೀಲ್ ನಮ್ಮ ಫೇವರ್ ಆಯ್ತು. ರಾಮಕೃಷ್ಣಪ್ಪ ಫೇವರ್ ಆಯ್ತು.
ಏನಕ್ಕೆ?
ಇಲ್ಲ.
Suit ಏನಕ್ಕೆ ಹಾಕಿ? ಡಿಕ್ಲರೇಷನ್ ಆಫ್ ವಾಟ್?
ಡಿಕ್ಲರೇಷನ್ ಆಫ್ ದಿ ಗ್ರಾಂಟ್ ಸರ್ಟಿಫಿಕೇಟ್.
Judgment court. You have the copy of the judgment in OS?
Partition. After that, without challenging the complementarity, Ramakrishnappa had filed one more suit. That has been.
Your father suffered he entered into compromise decree, saying that Muniyappa is the absolute owner. So you are going to come and say that no, my father was wrong. Land was granted to your father.
Please.
Your father entered into compromise with Muniyappa, considering that he is the owner.
There is no relation between the Muniyappa.
But ನಿಮ್ ತಂದೆ ಒಪ್ಕೊಂಡಿದಾರ?
I get instructions, my lord. ಯಾಕಂದ್ರೆ ಅದು ಗೊತ್ತಿಲ್ಲ, ತಿಳ್ಕೊಂಡಿಲ್ಲ.
ಇಲ್ಲಿ ಇದೆಯಲ್ಲ ಡಿಗ್ರಿ ಇದೆಯಲ್ಲ.
Next week. Next week, my lord, I get instructions. The petitioner is before this court, contending that our father Ramakrishnappa was granted the land, and this land has been sold in favor of the fifth respondent in contravention to the terms of the grant. The petitioner had made an application seeking for resumption on the ground that the land had been sold in contravention to the terms of the grant. So the Assistant Commissioner allowed the said application and ordered the resumption of the lands. Next, an appeal was preferred by the fifth respondent to the Deputy Commissioner. The Deputy Commissioner has recorded a finding that the land was sold by one N. Muniappa after he had obtained permission from the government as contemplated under section 4.2, and therefore the entire proceedings initiated under the PTCL Act were run without jurisdiction. Not counsel for the respondent. Fifth respondent also points out that the father of the petitioner was the defendant in OS 368/1996, which had been instituted by N. M. Muniappa, his vendor. And the said suit was one for declaration and for injunction. In the said suit, Muniappa and the petitioner's father Ramakrishnappa entered into a settlement whereby it was conceded that N. M. Muniappa was the absolute owner of the said property. In view of the fact that N. M. Muniappa was considered to be the owner of the property in a suit filed by him against the father of the petitioner, the argument that N. M. Muniappa could not have been granted permission to sell the granted land cannot be accepted. The Deputy Commissioner, in my view, was justified in coming to the conclusion that the land had been sold after prior permission under section 4.2 had been obtained. There is no justification for interfering with this order. The petition therefore dismissed.
Final dispose. Sheet number 58, Mahesh Chaudhary.
Appear for the petitioner, your lordship. IA, we filed one IA, your lordship. It is for one IA. The matter has.
I have no objection for allowing it. Clearly stated, evidence on behalf of petitioner in support of her petition for revocation of a probate granted by this court is being recorded further to direction by this honorable court. The fourth commissioner was examined. During the course of his evidence, he has stated his term since got over. He has surrendered the fourth commissioner register, seal, etc. to the registry. And upon his inquiry, registry has informed him that it is destroyed. So they want the registry to cause production of record or whatever has been done with it.
This is a petition for revocation of the probate. Huh?
Yes.
Yes, your lordship.
Probate was granted in whose favor?
Probate was granted in favor of the husband by the wife. The party.
There are two probates.
By the
Let him submit.
probate was granted in favor of the husband in respect of the bill under which he was.
Husband andre
ಇಲ್ಲಿ ತಮ್ಮ ಮುಂದೆ ನಾವು ಇರೋದು ಸಿಬ್ಲಿಂಗ್ಸ್. ನಮ್ಮ ತಾಯಿ ತಂದೆಗೆ ಬಿಲ್ ಮಾಡಿದ್ರು. ತಂದೆ ಪ್ರೊಬೇಟ್ ಮಾಡಿಸ್ಕೊಂಡು.
May I explain your?
Daughter, petitioner daughter. Respondents ಅವರ ತಮ್ಮಂದ್ರು. ನಾವು 3 ಜನ ಮಕ್ಕಳು.
testator ಯಾರು? Testator
Mother. Originally it belonged to mother. May I explain your lordship?
ಫಾದರ್ ಪ್ರೊಬೇಟ್ ಮಾಡಿಸ್ಕೊಂಡು. ಫಾದರ್ ಪ್ರೊಬೇಟ್ ಮಾಡ್ಕೊಂಡ ನಂತರ ಅವರು ತಮ್ಮದೇ ಒಂದು ಬಿಲ್ ಮಾಡಿ ಮಕ್ಕಳಿಗೆ 40-40-20 ಅನುಪಾತದಲ್ಲಿ ಕೊಟ್ಟರು. ಅದು ಕೂಡ ಮಕ್ಕಳು ಇಂಡಿವಿಜುವಲಿ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಆದ್ರಿಂದ they got probated that bill. After 7-8 months, based on an affidavit given by one of the attesting witness to mother's will, who sought to say that his signature was obtained and related to death ultimately. The probate revocation.
Seek for revocation of the probate granted in favor of the father ಬಂದಿದ್ದು. Father's probate ತಗೊಂಡಿದ್ದು revoke
ಮಾಡ್ತಾರೆ. ಫಾದರ್ ನಿಮಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಮಕ್ಕಳಿಗೆ. ಈಗೇನಾಗಿದೆ ಅಂತಂದ್ರೆ ಎವಿಡೆನ್ಸ್ ರೆಕಾರ್ಡ್ ಮಾಡಲಿಕ್ಕೆ ಡೈರೆಕ್ಷನ್ಸ್ ಬಂದಿದೆ. ಈಗ ಅವರು ನೋಟಿನಿ ಅಥವಾ ಓತ್ ಕಮಿಷನ್ PW ಆಗಿ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದಾರೆ. ಡಾಕ್ಟರ್ ಕನ್ಸರ್ನ್ ಅವರನ್ನ ಹಾಸ್ಪಿಟಲ್ ಇಂದ ಕರೆಸಿ ಅವ್ರದ್ದೊಂದು ಎವಿಡೆನ್ಸ್ ಆಗಿದೆ. PW1 ಫರ್ದರ್ ಕ್ರಾಸ್ ಆಗಬೇಕು. ಈಗ IF4 ಅವರು ಹಾಕಿರೋದು ಏನಕ್ಕೆ ಅಂತಂದ್ರೆ ಈ ಓತ್ ಕಮಿಷನರ್ ಇಷ್ಟು ಸರೆಂಡರ್ ಆದ ನಂತರ ಅದು ಡೆಸ್ಟ್ರಾಯ್ ಆಗಿದ್ಯಾ ಆಗಿದ್ರೆ ಯಾವ ಟೈಪ್ ಆಗಿದೆ ಏನು ಡೀಟೇಲ್ಸ್ ಕಾಲ್ ಫಾರ್ ಮಾಡಿದ್ದಾರೆ.
Oath commissioner ಯಾಕೆ he had
the will of the attestors to the will. ಅದನ್ನ ಕಾಲ್ ಫಾರ್ ಮಾಡೋದು ನಂದಿಲ್ಲ ಸರ್.
Allah, why we filed this, I'll explain. In original CP7 of 2014, one affidavit was filed of one of the witnesses who goes by the name Kashinath, Umesh Kashinath. He filed an affidavit confirming to the content of the will, saying that, yeah, the will was executed in my presence and the content of the will is correct. Post that, your lordship, out of his conscience, he came on record and he told us that when the will was executed, he was not there. Much after the death of the person who executed the
When did your mother execute the will? What's the name of your mother?
what is the name?
ನಿಮ್ಮ ತಾಯಿ ಹೆಸರು?
Sarojini Devi. Sarojini Devi is the name of the mother.
What is the date of the will?
25/11/2013.
He died on 5/12/2013.
Just a week before her death,
20?
supposedly 25/11/2013.
Date of death?
5/12/2013.
2013.
5/12.
Who are the attesting witnesses to the will?
One is Kashinath, Umesh Kashinath, and another one is Ines Watts. Now Ines Watts has passed away.
Umesh Kashinath and
Ines Watts, INES,
the Umesh Kashinath and
Ines Watts, INESZ, his spelling goes by that.
INESZ. Ines.
Watts, WATTS.
Where was the will executed?
Will was in Bangalore.
This is a registered will or?
Unregistered will.
And under this will, the property was given to your father.
Father, yes.
Entire property.
Entire property.
Only one property?
The entire property belonging to the mother was given to the father.
Was that is Baswa Purnaya.
Yes, yes.
Father is alive?
Father is not alive.
When did he die?
He died on 20th July 2015.
Will ಬರ್ದಿದ್ದು ಅವರು?
ಅವ್ರು ಬರ್ತಿರೋದು 30/3/2015. ತಾಯಿ ಇನ್ನು ಪ್ರೊಬೇಟ್ ಆಗಿರೋದು.
This was in favor of two sons and daughter.
Two sons and daughter, yes.
In the ratio of
40/40/20.
In detail ಕೊಟ್ಟಿದ್ದಾರೆ. Property ಕೂಡ in detail ಕೊಟ್ಟಿದ್ದಾರೆ.
40/40 to the sons, 20 to the daughter.
40 to the daughter, the petitioner.
Is it?
Another 40.
Another son.
First responding, the elder son.
Ah.
ಕಡೆಯವರು 20%. ಅವರು ಮೊದಲೇ ಫ್ಯಾಮಿಲಿಯಿಂದ ಹೊರಗಡೆ ಹೋಗಿದ್ರು. ತಾಯಿ ಬಂದಿದ್ಯಲ್ಲ ಅಂತ ಹೇಳಿ ತಂದೆ ಏನ್ ಮಾಡಿದ್ರು, ಅವ್ರು ಒಂದು 20.
ಇವ್ರು ಯಾವಾಗ ತೀರೋದ್ರು?
2015.
ತಂದೆ 20 ಜುಲೈ 2015.
20th of July?
2015.
And the father obtained the probate when?
Father's probate
4/9/2014. 4/9/2014. Your lordship, the present issue is relating to one IA.
1 minute, 1 minute. Let me understand the basic facts.
Yes.
I want. In this probate granted to the father,
Yes.
they were not made parties.
No, no. Citations were not issued to the interested stakeholders, and that was one of the ground to seek revocation of the probate already granted.
Basically, if the probate is revoked,
Yes, that is a prayer in the present petition.
probate in favor of your father is revoked.
Yes,
Your mother would have died intestate.
yes.
Yes.
And
Then
all
it has to devolve upon as per the intested.
you will stand to lose
No, no.
Yes.
because what the land council said was right. Under the father's will, you got 40%. If you want it to be given to you intestate, it will become 33 and 1/3%.
Yes.
So you will get a reduced share. Are you sure that you want to go through this?
This will was obtained for fraudulently. I understand your lordships are saying that father has willed it in favor of daughter to the extent of 40%.
If I accept this request of yours and revoke this probate,
Yes.
the net result is your mother would died intestate. You got a larger benefit under your father's will.
No, your lordship, on instructions, we've been told to seek revocation of the probate and let it devolve upon as an intestate debt.
That is why you have filed the petition.
Yes.
But are you sure that you want a lesser share
Your lordship,
of granting the?
considering the properties that have been listed in the will of the father to devolve upon daughter and the sons, that is something that is not acceptable to us. He has listed certain properties to go to daughter, certain properties to go to sons and all those things. That is not acceptable to us, and that is the reason why we don't want it to happen.
Submission.
And if you look at the true value of the properties that is there,
You have not been given a share in all the properties.
no, your lordship, he has made a schedule and is distributed among the 3 children. But the main ground, let me state this, your lordship, the main ground on which revocation is now being sought is in CP 7 of 2014, this honorable court granted the probate. That is, by considering the affidavit filed by Kashinath, 7 of 2014, order passed on 4/9/2014.
4/9/2014.
4/9/2014, yes. In that case, your lordship, what happened? The 2 witnesses who were witnesses to the will filed an affidavit before this honorable court confirming to the content of the will.
It is Umesh and Ines.
Umesh and Ines. Later on, Ines passed away, and Umesh, out of his conscience, came forward and told us that when he signed on the document, our mother was not there, and he has never ever met our mother also. Let me complete. Let me complete. So 3 things he disclosed. 1, when he signed the document, the mother had already passed away. She was not even alive, but it was misrepresented to him that mother is alive. He is an employee in father's and mother's company, UTL. And being an employee,
He has been summoned, he has been examined.
yes, he's been summoned, he has not yet been examined. I believe there is an advocate representing him, and he's also filed an IA seeking a virtual evidence to be led because he's very old. And appointment of court commissioner to assist with the evidence. He has also been summoned in the evidence.
Who
No.
represents it?
Sorry.
Who represents it?
Advocate. Huh? Rabi Sebastian. So, your lordship, the main reason why it was allowed probate in first place was relying on the affidavit of one Kashinath. Now, your lordship, in the present proceedings, again, he has filed an affidavit stating that the contents of the wills are not verified by him. He has never met the lady, and months after the death of the lady, the will was signed by him. Now, your lordship, the previous affidavit, which was relied upon by this honorable court, was administered oath by one particular person who goes by the name Ramakant. And now he was summoned and he was examined by us. And during the course of examination, he said that he has attested the notary. He has notarized the affidavit given by Mr. Kashinath. But then we asked him where is the register where he maintains the notary details.
In what way is the evidence of the notary relevant?
Because, your lordship, the entire reason why the CP 7 of 2014 was allowed was based on the affidavits filed by the witnesses.
No,
And that affidavit is not right, it's fraudulent. We are trying to prove that.
Umesh Kashinath did not dispute the filing of the affidavit.
He is disputing now. He's saying he did not notarize the affidavit. He did not file that affidavit. He's taken the stand now. And in order to prove that the notarization was a fraudulent act on the part of the respondent, it was never really notarized. We summoned the oath commissioner, and oath commissioner has been examined.
You're talking about your father.
Respondent is the brother, my brother.
Nimshar, your father had filed the probate.
Yes.
December 14.
Yes, in
that probate, Umesh had given an affidavit.
yes.
So are you saying that your father committed fraud in?
Yes, we've taken that stand. Yes, that is the plea that we've taken. Yes, our father committed the fraud and through fraudulent ways, he got this will in his favor. And then he distributed the properties among his children in the way he wishes. And we are not satisfied with that. And that is the reason why we're challenging this. And the reason why CP 7 of 2014 was allowed was relying on that affidavit. And now we've taken a stand that this affidavit itself is fraudulent. It's a fabricated document. And the same stand is corroborated by the Kashinath also, who's supposed to have executed that affidavit. And for this purpose, we've examined the oath commissioner who executed that affidavit. And the details of that affidavits are mentioned in that register, which we wish to verify. And when we sought that register to be produced by the oath commissioner, he said that he's retired from this in 2015. And the register had been submitted to the High Court registry. And all that we are seeking in the present IA, Your Lordship, is that that register may be furnished for the purpose of evidence. And if the register, orally he went on to state during the course of evidence that the register has been destroyed by the High Court registry, but there is no record to state so. If the registry of, if the Honorable High Court registry,
Where is the IA that you have filed?
29th October 2024, we filed the IA, Your Lordship.
Where is this affidavit saying that it is destroyed?
Evidence was recorded by the evidence was recorded by the registrar. During the course of recording of evidence, he has told, he went to the office of the
It is on record. He has made the statement.
That's all it is. If this idea is allowed, the evidence before the registrar of protocol will continue.
But just one sentence, one small submission I made. I have no objection for summoning this record. Only thing is, Lord, making allegation against the father, they can be played fraud of mother and augmented his property. That is the statement made.
No, but he has a.
Suppose now we are into inquiry for revocation. Once it is revoked, who has put the will? He is not alive today. And there is nobody to, he is not in a
If the
position
probate,
of-
if the probate is revoked and is held, and it is held that the will has not been established, then interstate.
Thing is, the sole legatee and executor under that will.
If the will is genuine,
not in a position to defend himself here.
if that will is genuine,
Yes.
if the attesting witnesses to the will say that they have not attested the signature, then the question of granting probate will go.
But
Then the question of the father being entitled,
the fate accomplished this, father gave this property to all the three. They have probated the father's will, and in fact, the second respondent has fully.
you have probated the
taken
father's
it.
will, you have probated the father's will,
Yes.
Lordship, even
probated the father's will.
we were party to it. We've challenged that order also on the, in the present, there are two cases.
You're seeking
Two
revocation of your mother's will as well as your father's will.
Yes, yes, because if
Getting
the,
the benefit of it.
yes, because if the mother's will goes away, consequentially, the father's will also go away. And we got to know that the mother's will was obtained by the father fraudulently much later. And that is the reason why you challenge this. Your Lordship, another important thing here is when this was brought to the,
ಈ ಮಧ್ಯದಲ್ಲಿ ಮಾತಾಡ್ತಿದ್ರೆ ಯಾರ್ದು ಕೇಳ್ಸಲ್ಲ.
ಅಲ್ಲ, ಏನಾಗಿದೆ?
Allah, Your Lordship, when the prima facie, Your Lordship, when the prima facie case was made out, let me submit this.
I'll allow this application. I'll allow this application.
Yes, Your Lord.
The petitioner has filed an application. The petitioner has filed an application seeking for direction to be issued to the registrar of this court to produce the oath commissioner register from an endorsement issued by the registrar for surrendering the oath commissioner register and see of Sri Ramakant Rao L. Yakapur. Since it is stated by Ramakant Rao L. Yakapur that he had surrendered the register. Then it comes to appearing for the respondents. I have no objection for the said application being allowed. Consequently, IA 4/24 is allowed, and the registrar is directed to furnish the oath commissioner register The endorsement issued by the registrar for surrendering the oath commission register of Sri Ramakant Rao L. Yakapur. Released on. You want it to be, it's before the registrar, right?
Yes.
The said register and document be produced by the registrar to the registrar protocol, who is deposing the evidence of the oath commissioner. When is it posted there? Before 24.
ಮಾಡಿಸ್ಕೊಂಡು 8 ತಿಂಗಳ ನಂತರ ಯಾರು ಇವ್ರು ಬಂದು ಹೇಳಿದ್ರು ಅಂತ ಹೇಳಿ ಇದನ್ನ ಹಾಕೊಂಡಿರೋದು.
ಅಲ್ಲ ನಿಮ್ಗೇನು ನಿಮ್ಗೇನು ತಕರಾರು ಇಲ್ಲ ಅಂದ್ರೆ 3 ಜನ ಸಮಾಗ ಹಂಚ್ಕೊಡಿ.
ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ಬಹಳಷ್ಟು ನೀರು ಚಾನೆಲ್ ಕೆಳಗಡೆ ಹೊರಟೋಗಿದೆ.
ಅದಕ್ಕೆ ಬೇಡ, ಈಗ ಆಗೋಗಿದೆ. ಆಸ್ತಿ ಹೆಂಗಿದ್ರು 3 ಜನ ಮಕ್ಕಳಿಗೆ ಬರ್ದಿರೋದು ತಂದೆನೋ.
1 ವರ್ಷ ಕನ್ಸಿಲೇಷನ್ ಆಯ್ತು, ಡಿವಿಷನ್ ಬೆಂಚ್ ಇಂದ ಕನ್ಸಿಲೇಷನ್ ಹೋಯ್ತು. 1 ವರ್ಷ ಇಸ್ ಲಾರ್ಡ್ಶಿಪ್ Justice Satyanarayan presided over and tried his best, and a report has been given by him.
No, I will not try for a settlement. All that I am saying is, if all of you are children, share it equally.
My lord, it's not question of sharing. Today, subscribe to her allegation, father was a fraud.
Oh, don't go back.
No.
Don't go back. Ultimately, the property will go to waste if all of you are fighting forever.
I am not going to lose anything if it comes down by 13%.
So why are you wasting your time?
In fact, I gave a proposal. Nan share nin tokolomma, nin share ನಾನು ಕೊಡು. ಇಲ್ಲ ಅಂತಂದ್ರೆ
ಸಮಭಾಗ ಮಾಡ್ಕೊಂಡು ಮಕ್ಕಳು ಶನಿಯವರೇ
ಕೂಡ ಇನ್ನೂ 10% ನಿಂಗೆ ಕೊಡ್ತೀನಿ ಅಂತ ತಯಾರಾಗಿ.
ಶನಿಯವರೇ ಅವರು 40 ರಿಂದ 33 ಬರಕ್ ರೆಡಿ ಇದ್ದಾರೆ. 40 ರಿಂದ 33
ಬರಕ್ಕೂ ರೆಡಿ ಇದೆ. ಹೌದು.
ಯಾರಿಗೆ?
ಅವರು 40% ಇಂದ 33 ಬರಕ್ ರೆಡಿ ಇದ್ದಾರೆ.
Let them file a application to
Intested.
ಅವ್ರು ಇವಾಗ allow
ಮಾಡಿದ್ರೆ consequential thing will be same thing. Consequentially, if there is no will, intested. No.
On concession, I don't want to.
You are fighting, Shanayore,
This honorable.
You are fighting only on ego. Even if.
It's not my ego, my lord. A dead person has at least some amount of, my lord, all his life is tried for his children, his family.
Therefore,
this is a court of record.
Therefore, enjoy the property that your mother had left behind. Why do you want to fight?
Father was a fraud. He played fraud on mother and procured all the properties. Not on that cost, my lord.
So you want to fight?
Not the fight. I don't want that stigma to be there on my father. It's not question of fight, my lord. She is the one who has brought the matter before this court, not me.
So to me, my common sense says it's better the three of you take 1/3 and get on with your lives.
If she had come straight away asked, you would have agreed. We respect her as my sister even today. But sister is not the person who is doing it.
You are now litigating. You are now litigating for the past 7 years. So this will not stop here. Right.
ನಾವು ಸಾಕಷ್ಟು ಲಿಟಿಗೇಷನ್ ನೋಡಿದ್ದೇವೆ.
ಅದಕ್ಕೆ that is why I thought it's
10 ಪೈಸೆ ಕೊಂಡೋಗ್ ನಾವು 10 ಪೈಸೆ ಕೊಂಡೋಗ್ ನಾವು ಹೋಗ್ತಾ ಮಕ್ಕಳೇ ಕೊಟ್ಟೋಗಿದ್ದಾರೆ. ಬೇರೆ ಸಂಸಾರ ಇರ್ಲಿಲ್ಲ. ಮೂರನೇ ಕ್ಯಾರೆಕ್ಟರ್ ಮೂರನೇ ಹೊರಗಡೆ ಕೊಟ್ಟಿಲ್ಲ.
I don't see the end game in this. Apart from your ego that you will prove something, you will not enjoy the property.
Some of the properties are in the company. ಈಗ ತಮ್ಮನ ಹೆಂಡತಿನ ಮಗಳನ್ನ ಡೈರೆಕ್ಟ್ ಹೊರಗಾಕಿದ್ದಾರೆ. Company is being drained out. I am not the beneficiary of this litigation.
And you don't want it to end.
They are going to build a company. 3,000 ಜನ ಕೆಲಸ ಮಾಡ್ತಾರೆ. ಇವತ್ತು 75 ಜನ ಇದ್ದಾರೆ.
Operation and mismanaged procedure.
For I am telling you, it's better that. ಮೂರನೇ ಒಂದು ಭಾಗ ಮಾಡ್ಕೊಂಡು ಮುಂದಕ್ಕೆ ಹೋಗಿ ಸುಮ್ಮನೆ ಹಿಂದಕ್ಕೆ ಹೋಗ್ತಾ ಇದ್ರೆ
ಕಂಪನಿ ಡ್ರೈನ್ ಮಾಡ್ಕೊಂಡು ನಾಳೆ ನಮ್ಗೆ ಸುದ್ದಿಲ್ಲ ಇದ್ರಲ್ಲಿ.
ಅದಕ್ಕೆ ನಾನು ಹೇಳ್ತಿರೋದು ರಾಜಿ ಮಾಡ್ಕೊಂಡು ಹೋಗಿ ಮುಂದಕ್ಕೆ ಇವಾಗ ಯಾಕೆ ಸುಮ್ಮನೆ ಜಗಳ ಆಡ್ತೀರ ಅಂತ ನೀವು
ನೋಡಿ
ಎಲ್ಲಾದ್ರಲ್ಲೂ ಮೂರನೇ ಭಾಗ ತಗೊಳ್ಳಿ, ಎಲ್ಲಾದ್ರಲ್ಲೂ ಮೂರನೇ ಭಾಗ ತಗೊಂಡು ಮುಂದಕ್ಕೆ ಹೋಗಿ ಯಾಕೆ ಸುಮ್ಮನೆ ಜಗಳ ಆಡ್ಕೊಂಡು ಕೂತಿದ್ದೀರ? ಅಷ್ಟೇ ಟರ್ಮ್ಸ್ ಇನ್ನೇನು ಮೂರನೇ ಒಂದು ಭಾಗ ಎಲ್ಲಾದ್ರಲ್ಲೂ ಎಷ್ಟು ಜಾಸ್ತಿ ಇದೆಯೋ ಮೂರನೇ ಭಾಗ ತಗೊಂಡು ಹೋಗಿ ಮುಂದಕ್ಕೆ. ಸುಮ್ಮನೆ ಮೀಸೆ ತಿರ್ಗಿಸ್ಕೊಂಡು ಕೂತ್ರೆ ಯಾರಿಗೂ ಏನು ಬೆನಿಫಿಟ್ ಆಗಲ್ಲ. Are you prepared to give 1/3?
No, your lordship, the dispute, real dispute, what he said.
Forget about the real dispute.
Yes.
Whatever the properties are there, are you
No,
prepared to give
No,
1/3?
we'll have to take instructions. Our instructions are that share certificates, shares that are there in the
Good luck to
UTL.
all of you, keep fighting for the next 15 years.
Allah,
Enjoy
your lordship, that's why this honorable court ordered evidence before registrar protocol to see if the revocation is in order or not. Let the revocation be decided eventually and then it.
Your eminent lawyers, you will have good work for the next 10 years. Enjoy.
Great.
ಏನ್ ಬೇಡ ಎವಿಡೆನ್ಸ್ ಆಗ್ಬಿಟ್ಟು ಬರೋದು.
For final hearing, seal number 59 adjourned. Seal number 60, Sri Vivekanand Anand, Anthony Brito.
For the petitioner, sir. Lord, in this case, I filed a petition. The evidence is led. This is only, application is filed to permit these witnesses to be summoned, my lord.
Who are the witnesses?
There are two witnesses' names are given in the application by me.
They are the attesting witnesses?
Yes, my lord. They are attesting witness to the will. And they are required to prove the execution of the last will and testament dated 8/8/2010. Hence, my only humble submission is this honorable court can direct the notices be issued to the witnesses.
Witnesses mentioned in IA number 1/2024. Calling upon them to appear before the court to depose regarding they are attesting the will dated 8/8/2010, executed by Mr. Shankar Vinay Kumar, also known as SV Kumar, released on.
And we'll take it by RPAD, my lord, registered post. That one sentence came back.
This means by RPAD.
6th December, 6th December.
And the date can be fixed, my lord, say 13th of December or so. By then we will try to.
December.
Is fixed date.
12th December.
12th December. Okay. Obliged, my lord.
61 adjourned. Seal number 62. Sridhar Murthy.
Lord, what has happened in this case is, last occasion, your lordships had directed, my lord, the state to procure the document. State to procure the original, my lord, grant records. The finding of the court below is that on an earlier occasion, my lord, the grant records are not available. These are the persons who are the children of the original grantee. The facts are like this. The grant is of the year 1930-31. Thereafter, at that point of time, my lord, 29 rules were in force. According to which 20 years non-alienation clause was there. Be that as it may, in 1953, the original grantee had executed a nominal deed in favor of, my lord, his own relative. He wanted some financial assistance. He purchased the same in 1974. The original grantee purchased back the same in 1974. The sale was never intended to be acted upon. All the revenue records stood in the name of the original grantee. The revenue records stood in the name of the original grantee. At the time of purchase, the original grantee wanted to divide between the two. He had two wives. 1 acre was purchased in the name of one of the wives. Another, my lord, 35 guntas was purchased in the name of son of another wife. That is how there was a partition. This was in 1974. 78 Act comes into force. An application for restoration is made. Two applications came to be made. One by the person, 1 acre 5 guntas, the first wife. The second 35 guntas, my lord, was by another family member. Originally, the authority allowed the application and restored it. It was carried in appeal. Appellate court, namely the deputy commissioner, remands the matter back to the assistant commissioner. After the remand, there was again an order of restoration. Against that, my lord, an appeal came to be filed. In the appeal, my lord, appeal has been allowed. My restoration has been set at naught on the ground that whether at all your the act is applicable to you.
For the grantee.
I am
Then
the
since-
son of the grantee and daughter of the grant.
So you had purchased, the property was purchased in your name by your father according to you in the year 74.
74.
Then who made the application for resumption?
We are the person. So 74, thereafter he died.
No. Your father sold the property in year 54.
53.
53. Then there's an reconveyance deed in the name of his first wife, son.
And second wife.
So who made the application for resumption? If you
The
are.
children, the person in whose name, my lord, the property was purchased.
The remaining children.
No, these persons, the very persons in whose name there was a repurchase, they've made an application.
Why did you seek for resumption since you were already the owner?
No,
After
no.
reconveyance deed?
After the act came into force, there was a sale. This is the second sale. After 1978, the property is sold by the purchaser in 1992. That purchase was without permission of the government. Therefore, an application for restoration, my lord, came to be filed. The argument advanced now before your lordship are that because of the fact that there was already a sale in 1953, it does not, the act is not applicable, but because the question of the land being in the nature of a granted land may not be available is one argument advanced.
No, the alienation was made in the year 53 beyond the period of alienation prescribed under the rules.
Yes.
So then how can you invoke?
The question is, that was not a sale. Title did not vest with the purchaser. It was a nominal sale deed. My lord, even in a regular civil proceeding.
The nominal sale it or not, there is a sale.
There may be a sale.
The assistant commissioner can't give a finding whether it's a nominal sale or not.
My lord, that is not the intention of the act. The intention of the act is.
Can the assistant commissioner give a finding that it is a nominal sale?
Nobody gave any finding on any of these things.
If that
they do not hold that in 1953 there was already a sale, therefore act is not applicable. That is not the reason.
Fact remains that in the year 53 there is a registered sale deed.
The fact is that there is a registered sale deed.
That registered sale deed indicates alienation made after the period prescribed under the terms of the grant.
Appears so. There are two things anyway.
Then how can you invoke PTCL at all?
Correct. Now please see the interpretation of the act. In 1978, my lord, if the grantee himself, original grantee himself or his family member, if they are in possession of the property, and therefore your lordship, my lord, may have to say that in 1978, notwithstanding the fact that there is already a sale or not, if it is a grant and assuming that there is a sale and repurchase by the same person or any of this thing, and in 1978, when the act came into force, the original property which was granted is in the hands of that family, my lord, then the restriction, my lord, that subsequent to act coming into force, my lord, if there is to be a sale, would they not acquire, are they not required to take permission or not is the issue. According to me, my humble submission to your lordship is, in 1978, my lord, because the property was in the hands of the original grantee themselves,
If
my lord,
if the 53 sale is held to be a sale,
correct.
all subsequent sales are automatically saved. Because only those sales made in violation of the terms of the grant can be declared to be null and void. If the first sale.
No, first sale issue will not arise in this case is what, because
there is a sale deed. The fact that you repurchase the property indicates there's already a sale.
Correct.
So if the first sale deed is valid, automatically second sale deed is valid, then all subsequent sale deeds are also valid.
My
The
humble,
question of it coming under the PTCL Act will not arise.
my humble submission is this. The second sale is the first sale here. The first sale is not a sale at all. My lord, otherwise,
That you can't,
therefore, the rigor of the act would be applicable, is what my submission is. That's what, my lord, the issue, that is how it arises. The first sale, my lord, in this case, my lord, it is a nominal sale deed.
how can, who's to say it's a nominal sale deed? Can the assistant commissioner say that in a resumption proceeding? That's beyond his jurisdiction. He will invoke the provisions of the act only if he finds that there has been a sale in contravention to the terms of the grant.
When is the question? When is the question? It does not lie in the mouth of the assistant commissioner to say, if as on the date when the act came into force, my lord, the property is in the hands of the original grantee or their family members.
Of no
The act is applicable.
whether it is in your hands or anybody else's hands. If the first sale is valid, second sale, third sale, all of them will be valid. You are leading a very anomalous situation. First sale is valid, but the second and third sale are invalid.
I'm not saying that in this case, my contention is it was never intended to be acted upon.
That not now.
Well, it is open, my lord. My lord, the Honorable Supreme Court has held that assuming that there is a sale, there is nothing.
You can't use the provisions of this act to get over the sale deed executed by you. You're using this act.
No, I'm sorry. No, it's slightly different. My lord, everybody is proceeding on the assumption that because by the time act came into force, there is already a sale and purchase, maybe by the same family, the property would go out of the purview of the act is what is being.
I'll put it like this. It is of no consequence whether you are the grantee's son or the second wife.
That's material.
You claim to be a purchaser.
No, I don't claim to be a purchaser.
A purchaser under the 78 sale deed.
I don't claim I claim to be a original grantee's children.
There's a sale deed in your favor.
Maybe.
Then if you're claiming title under that sale deed, how can you go back to the grant?
I'm not, my lord, claiming under the sale deed. I'm not claiming under the sale deed. The title never went out of the family is what my contention is. If title continued notwithstanding the sale, is such a situation not available or not is one question.
You can't put for the contention having obtained a sale deed. Your father sold the property, you repurchased the property.
My father purchased it in my name.
Whatever that is.
It's a benami. It was permissible in those days. Well, it was permissible in those days.
Either way, it's not a granted land for you to invoke PTCL.
That's the issue to be determined, my lord. It cannot be, my lord. So otherwise what happens is more than 50% of the transactions, my lord, are like this. This, my lord, buttresses the original intention why the act was brought into force. If I cannot, my lord, if the original sale deed by the father, the original grantee, if it continues, my lord, notwithstanding the sale, because the sale was a nominal sale. That's the only issue, my lord. If your lordship, my lord, come to the conclusion that because of the fact that in 1953 there was a sale, and because there was a sale and it was repurchased, my lord, in the year 1974, in the name of the first wife and second wife's children, whosoever it is, if your lordship holds that it is a sale intended to be acted upon, I may not have any case. If your lordship come to the conclusion that by looking into the record, because all the records stood in the name of the family only, it was because of the fact that they wanted some money. It was sold for some 200 rupees in those days, repurchased for 600 rupees or so in those days. It amounted to the equivalent of, my lord, 6% interest. Why the records were called for was, Assistant Commissioner proceeded on the assumption or proceeded that the grant is of the year 38-39. The IL and RR suggest grant is of the year 30-31, but grant certificate was issued subsequently. My lord, if the grant is of the year 38-39, then the issue would be that there is a permanent non-alienation clause.
What is the date of the grant?
That's what the grant certificate is not available here,
You made the application. What was the date that you set up?
30/31.
30/31. And what is the finding?
Please see the IL and RR.
What is the finding of the Assistant Commissioner?
There is no grant records at all. My lord, please see
What is the date of the grant, madam?
the records were called for, my lord.
30/31, 20
They are
years.
supposed to produce the document.
20 years avaga.
The order of the assistant deputy commissioner,
Finding by the Assistant Commissioner is 30/31.
no. Finding by the assistant commissioner is 38/39 if they proceed.
What is the finding of the Deputy Commissioner?
Deputy commissioner impugned order, your lordship finds it at page 29 and 30. Page 30, last paragraph onwards.
In 30/31.
Yes. The records are not available and IL and RR records cannot be relied upon, even assuming that they are to be relied upon. But
You are the second respondent before the trial court, before the Deputy Commissioner.
yes,
So you also admitted it was 30/31.
30/31, correct. But and they contended that we do not belong to that caste at all. And then, my lord, we have produced this thing. It was a grant, my lord, under depressed class rules. And we belong to Adi Karnataka, this thing. We have produced that document. Be that as it may. Supposing, my lord, if it is 38, earlier order of the deputy.
You set up the plea, it was 30/31.
Yes.
Deputy Commissioner has recorded a finding, it is 30/31. The rule as on that date was 20 years. The alienation is made after 20 years.
No. What deputy commissioner says is this.
Yes, that's what he says in para 31.
In the absence of original grant records.
No, he says according to the entries in the, even now the specific condition of the second respondent is that the land in question was granted as per sub-divisional officer Hukum number so and so, 30/31. According to the entries in the RR as well as already pointed out in the earlier order dated 8/8/2006 of the then special DC, there are entries in the RR with regard to grant of land in number 93 to several persons. In fact, in terms of certain person, it is specifically recorded as depressed class rules prakara Adesha number 11/4/1930. Beneath the said entries, there's the names of so and so. So that is the finding. Grant was of the year 1930. Alienation is made after 20 years.
This is according to. Please come to the 32 last paragraph.
Yes.
Even otherwise, if it is without considering particularly the absence of original grant record. Original grant record illa illi.
You also say it is a granted land. They also say it is a granted land. All of you admit it is 30/31 grant. 20 years period.
That is an admitted fact.
Mugita ಅಷ್ಟೇ ಬಿಡಿ.
The 20 years was the non-alienation period. Would your lordship, my lord, like to see the original RTCs which stand in the name of the family, notwithstanding the sale?
It is of no consequence because the moment you admit there is a sale of the year 53.
It's an admitted fact. Nobody disputes that.
Then nothing can be done.
The legal issue is only this. Notwithstanding such a sale and this thing, as on the date when the act came into force, in the act, there is nothing contra is indicated. Please read the act, my lord.
Really?
There is something contrary to this. First sale may be before the act itself. There is nothing in the definition granted land.
4(1) only talks about transfer of a granted land in contravention of the terms of the grant.
Correct.
It's not in contravention. There is no question of invoking section 4.
There was no transfer at all here.
You admit this sale deed of the year 53.
That is a nominal sale deed is what I...
That can't, show me a provision in the act which says nominal sale deeds can be ignored.
No, act doesn't contemplate that. It's a civil consequence. A civil consequence cannot be allowed.
Then maybe your remedy may lay elsewhere, not under the PTCL Act.
No. It's only under PTCL Act. Otherwise, I have no remedy. For the simple reason that after the act came into force,
Once there is a sale deed and a reconveyance, it no longer is a granted land. Especially when it is not in terms of the contravention of the grant. It is regular grant or regular land of a person who was acquired title on the expiry of 20 years. You cannot retransfer it to be a granted land. On the assumption it was only a nominal sale deed and we had purchased it on behalf of the family. Once there's a sale deed, there ends the matter.
no, father himself purchased it in two bits in different names.
The
It
father
was a kind of a
purchases-
family settlement, my lord, by the father
Whether
in
the
1973.
Father purchases it in your name or he purchases in his own name. The moment he has sold it, if he gets it back, it is his absolute property. It is not a granted land.
My lord, my submission would be to the contra,
I can't accept that contention.
because after 1978, as on the date when the act came into force, if the property is in the hands of the original grantee himself, then all other this thing would apply. And after coming into force of the act,
In fact, under the act, if somebody else is in possession of your lands, then there can be a presumption that the alienation in violation of the terms of the grant. That much I concede. But once you admit the sale,
no, that
And
they are the
repurchase.
facts.
nothing can be done.
That's all, man.
But
Specifically, the very words finding is recorded. 20C, annexure A, ink page 34. Or right side bottom,
Correct.
right side top, 13. Just applying the law of principle.
yes,
In very words, yes.
My endeavor was only to say that as on the date when act came into force, if the property continues to be the hands of the grantee, my lord, then what is applicable is only that I sold the property after act came into force. This is a restoration application vis-a-vis the persons to whom I sold the property after act coming into force, because I sold the property somewhere in the year 92. And thereafter moved an application for restoration. These are this thing. Therefore, my lord, the rigor of section 4(2), that after act coming into force, my lord, without prior sanction of the government, there cannot be a sale. My lord, would be applicable is what my submission is.
your Sharadamma, na?
ಒಂದರಲ್ಲಿ ಶಾರದಮ್ಮ, ಇನ್ನೊಂದರಲ್ಲಿ ಅಕ್ಕಯ್ಯಪ್ಪ.
ಎರಡು ಕೇಸ್ ಇದೆಯಾ?
ಎರಡು ಸೇಲ್ ಡೀಡ್ ಇದೆ. ಇಬ್ರು ಅದು ಫ್ಯಾಮಿಲಿನಲ್ಲಿ ಶಾರದಮ್ಮಂಗೆ 1 ಎಕರೆ 5 ಗುಂಟೆ ನಮ್ ತಂದೆ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ರು. ಇನ್ 35 ಗುಂಟೆ ಅಕ್ಕಯ್ಯಪ್ಪನ ಹೆಸರಲ್ಲಿ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ರು.
62 is by Sharadamma.
ಒಂದರಲ್ಲಿ
The other one is by?
ಅದು ಅಕ್ಕಯ್ಯಪ್ಪ, ಅದು ಲಿಸ್ಟ್
ಆಗಿದೆ 62.1.
ಅದು ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ 23637 and 23638. ಶಾರದಮ್ಮ ರಿಟ್ ಪಿಟಿಷನ್ 13806.
Both of you filed an application for resumption, ತಾನೆ?
Yes, at different points of time.
Venkatesh is the son of Akayamma, na?
Yes.
Sharadamma,
My lord, ಶಾರದಮ್ಮ
she is the petitioner in WP 13806.
ಎಲ್ಲೋ ನೋಟ್ಸ್ ಇದೆ. My lord, Chandraappa is the propositor. Chandraappa had 2 wives.
No, I want to know you made an application for resumption of lands which you had sold.
Yes,
Sharadamma,
Sharadamma had sold.
when did Sharadamma sell her land?
My lord, Sharadamma sold the land. My lord,
92.
30th June 1992.
30th June. Timmaka ಅಂತಾರೆ.
ಅದೇ ತಿಮ್ಮಕ್ಕ.
Who's Timmaka?
Timmaka, my lord, is the second wife
Application for resumption was filed by whom, Chandrasekhar? Where is the order of the AC?
Nandon blue sheet.
He is a wife of Chandrayappa.
Yes. My lord, Timmakka is the Nandon blue note.
One favor, one sealed in favor of Channappa, son through the first wife, and the other in favor of Timmakka, the second wife.
Second wife.
Now, who is this Shardamma?
Shardamma is the wife, Channappa.
She is the daughter-in-law of Chandrayappa.
Shardamma,
Yes.
Yes,
The-
another is at page 127.
Shardamma,
Yes.
the wife of Channappa, and the daughter-in-law of the original grantee,
Chandrayappa.
Chandrayappa, filed an application seeking for resumption of the land, contending that it was a granted land, and the same had been conveyed in favor of
My lord, same had been conveyed, my lord, in favor of Ramachandra.
Ramchandra
Yes.
on 19/9/1982. Similarly, another application was filed by Timmakka,
By Venkatesh,
by
Akkayappa and Venkatesh.
Yakayappa and Ventesh,
Venkatesh. Children of Chandrayappa.
wife and who was the second wife and the son of the original grantee Chandrayappa,
Yes.
seeking for resumption of the land that they had sold on 19/9/92 in favor of one Govindappa. The said application for resumption was accepted by the Assistant Commissioner, and an order of resumption was passed. Being aggrieved, the purchasers preferred an appeal to the Deputy Commissioner, and the Deputy Commissioner with the impugned order has allowed the appeal and dismissed the application for resumption. Hence, this writ petition by the applicants who had sought for resumption. These facts are not in dispute. In the year 1930-31, land bearing circle number 93/4, measuring 2 acres, situated Tanisandra village of Kiarpura Hobli, Bangalore East Taluk, was granted to Chandrayappa under the then existing rules. The Deputy Commissioner in the impugned order has recorded a clear finding that as per the revenue entries, the lands were granted on 11/4/1930. Since these lands have been granted in the year 1930, the rules which prevailed on that time prescribed a period of 20 years as the non-alienation period. It is not in dispute on 3/8.
The functions are dictating only in 806. That should be read.
Both together.
ಮಾಡಬಹುದು ಒಂದೇ ಡಿಫರೆನ್ಸ್ ಅಂದ್ರೆ ಅಲ್ಲಿ by order in action K, Assistant Commissioner also rejected. They filed
That is the second application.
Starting amendment, application was filed for resumption. The Assistant Commissioner.
ಅಕ್ಕಯ್ಯಪ್ಪ ವೆಂಕಟೇಶ್ ಮಾಡಿದ್ರಲ್ಲಿ
Both Assistant Commissioner and Deputy Commissioner rejected the application.
The Assistant Commissioner rejected the application filed by Venkateshappa.
Venkatesh
Akkayappa and Venkatesh. While in respect of the claim for resumption by Shardamma, the Assistant Commissioner accepted the application for resumption and passed an order of resumption. Being aggrieved. Akkayappa, Akkayamma,
Akkayamma and Venkatesh.
Akkayappa ಅಂತ ಹೇಳಿ.
Akkayappa.
Huh?
Akkayappa ಕೈಪಾಡಿದ್ದಾರೆ.
The second wife.
ಇಲ್ಲ, ಅದು ಅಕ್ಕಯ್ಯಪ್ಪ.
Akkayappa and Venkatesh preferred an appeal to the Deputy Commissioner. Being aggrieved by the passing of an order of resumption, the purchaser Ramchandrappa preferred an appeal. The Deputy Commissioner dismissed the appeal of Akkayappa and Venkatesh, and as a consequence, they are before this court in WP 20637/2012. The Deputy Commissioner allowed the Deputy Commissioner allowed the appeal filed by Ramchandrappa and rejected the application for resumption that had been filed by Shardamma. And as a consequence, Shardamma is before this court in WP 13806/2011. ಇದು ಸರಿ ಹೋಗುತ್ತಲ್ವಾ? Period of non-alienation. It is not in dispute that the original grantee Chandrayappa sold the land that had been granted to him on 3/8/1953. That is beyond the period of 20 years prescribed under the terms of the grant. It is therefore clear that the land had been sold by the grantee as permissible under the terms of the grant and not in contravention of the terms of the grant. It was however the case of the applicants who had sought for resumption that they were the legal heirs of Chandrayappa in as much as they were the first wife and the sons of the second wife. And the sale deed dated 3/8/53 executed by Chandrayappa was essentially a nominal sale deed. It was their case that it was a loan transaction and they had repaid the loan. And as a consequence, the property was reconveyed to the family on 10/10/74. It was their case that at that point in time, the grantee Chandrayappa decided to get the deed of reconveyance executed in the name of his first wife, sons, and the second wife in order to avoid a conflict and to effect a division. And in essence, the property continued in the family right from the date of the grant. The applicants thereafter proceeded to contend that the land, by virtue of it being a granted land, could not have been alienated, and the alienation that was made by them in the year 1992 attracted the provisions of the PTCL Act as it was conveyed after the Act had come into force, and Section 4(2) stood attracted. The Deputy Commissioner in these cases has come to the conclusion that the granted land was capable of being sold after the expiry of 20 years from 1930. And since the lands had been sold as permissible under the terms of the grant, the provisions of the PTCL Act could not be invoked and the land could not be resumed. The Senior Counsel appearing for the applicants, however, contends that the sale deed executed by Chandrayappa, the original grantee, was essentially a nominal sale deed. And therefore, that sale would be of no consequence. According to him, it is only the sale of the year 1992, which was made by the applicants herein, which would be relevant for the purposes of this case. He submitted that since it is admitted that the land was granted and the alienation made by them was after the act having come into force in 78, there was a clear violation of section 4.2 and the land was therefore required to be resumed. It is to be stated here that when the land was granted in the year 1930-31, the bar for alienation was for a period of 20 years. In other words, for a period of 20 years, the grant was a conditional grant. On the period of 20 years expiring, the conditional grant became an absolute grant and the grantee was at liberty to deal with the property in any manner as he thought fit. Since the grantee decided to sell the property in the year 53, which was perfectly legal, the provisions of the PTCL Act cannot obviously be attracted. The argument that the sale deed is only a nominal sale deed cannot be entertained at the request of the petitioners who had claimed to repurchase the land in the year 1974. The moment a sale deed was executed in the year 53, whether it was nominal or otherwise, the fact remains that there was a conveyance of title in favor of a third party, that is Chikana. It is also to be stated here that at the time of this conveyance, there was no prohibition for the sale and the land stood vested absolutely in favor of Chandrayappa. If the land stood vested absolutely in favor in the name of Chandrayappa, the question of it being a granted land as defined under the provisions of the PTCL Act would not arise. The subsequent repurchase by the applicants, even assuming it was repurchased by the grantee, would not change the nature of the land and would not retransfer it to be a granted land. The moment a purchase was made by the applicants from the purchaser who was entitled to purchase it, the land essentially becomes their personal property and cannot be construed as the property of the grantee Chandrayappa. Consequently, the sale made by them in the year 1992 can never be held to be a transfer in contravention of the terms of the grant. This we noticed here that the petitioners did not succeed to the property as the legal heirs of the grantee, but they had purchased the property under two registered sale deeds, and they cannot therefore contend that it is a granted land. In that view of the matter, the Deputy Commissioner was absolutely justified in coming to the conclusion that the provisions of the PTCL Act would not stand attracted and there was no alienation which could be declared as null and void. The petition is therefore dismissed.
We see that we can prove the contention that it was a grant for the money.
And I'm saying the act itself is not applicable, so.
Therefore, in the added sentence, other contentions may not be.
In the light of the above, the other contentions being advanced by the parties need not be considered.
Obliged.
In the light of dismissal or writ petition, the application for impeding also would not subject to consideration.
What the TPM matter?
Out on legal land. Pass over.
Pass over matter? Trading for petition. Bill number 41.
You made him wait from the morning. Not for me. I am sitting here.
My
Interim order, no.
two judgments recently Supreme Court has said. The draft case, other circumstances, the two nayak basic one
The
judgment.
charge is the same, Manu Latif. The department proceedings. The charge is the same, isn't it? Then what else remains? If he's exonerated in the department inquiry, how can you convict him?
Same ground not is not looked at as possible. Went up to Supreme Court. Supreme Court said it cannot be.
ಸುಮ್ನೆ ಅವ್ನು ಹಿಡ್ದಾಕಿದಾರೆ ಅಂತ ನೀವು ಅವ್ನು ಗೋಳಿಕೋಬೇಕು ಅಷ್ಟೇ ನೀವು.
Coordinate features also consider the same judgment as the nayak case number 2022 is our like fight that is also a draft case. Para E.
See para 9. We may also observe that it was the pleaded case of the Lokayukta before the High Court that the continuance of the trial was not on the very same evidence as what weighed with the authorities in exonerating the employee in the department proceedings. This fact. Is it your case that there's a different set of evidence?
There are other circumstances, even in the draft case.
In para 9, that is what it says, isn't it? That was your case in that case. That is not your case here.
Here it is not, the charge sheet was filed, aforesaid report tested positive.
Same charge. Is there any different evidence that you have to prove the guilt in the criminal trial?
I was not examined.
The allegation is the same. The charge, then you have no other evidence other than this.
Coordinate features, another report is.
Para?
16 onwards.
Same ಇದನ್ನೇ ರಿಲೇ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. There also it was a pleaded case. ಸುಮ್ಮನೆ ಗೋಳಿಕೋಬೇಕಂದ್ರೆ ಗೋಳಿಕೋದಿದ್ದಾರೆ ಅಷ್ಟೇ.
This is the case, but other circumstance, it includes the other IU and the scientific evidence. The draft which is the cocktail also. Other circumstance.
If the allegation that he demanded a bribe to do a particular work itself has want to be not proved in the department inquiry, can you say that he took a bribe for that?
Examined IU and other witness examined, I can see. But the view taken and coordinate which also they.
In stakeholder ಅಂತ ಹೇಳಿದ್ದಾರೆ ನೀವೀಗ.
And I'll argue it on direction.
It will be then council 6 for 10 to 5. Objections ಹಾಕಿದ್ದೀರಾ? After hearing both the learned counsel come, I'm of the view it would be appropriate to stay all further proceedings before the ಯಾವ court ಅದು? Which court?
In special C number 44/2023, my lordship.
In special crime number 44/2023. Relist on ಯಾವ್ದು ಬೇಕು? 23. Notice, don't keep this pending. ಇವಾಗೆ ಮಾಡ್.
Kalburgi bench, pass over matter, serial number 4.
Next week I'll make my submission.
Reinstatement 50% back wages, madam.
ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಕ್ವಶನ್ ಆಫ್ ಮೆರಿಟ್ ಬ್ಯಾಕ್ ಮಾಡ್ತೇನೆ ನಾನು. ಅವರು ಮೇಡಸ್ ರಿಕ್ವೆಸ್ಟ್ ದಟ್ they express their inability to pay the submission merit manner.
ಅದೇ ಮೆರಿಟ್ ಮೇಲೆ. He has worked for how many years? From 2006 till 2015.
That is the question. I will make my submission on merit manner. Before the EAT is maintainable or not, that is the question. Before whether the appeal filed before the EAT education appellate tribunal is maintainable or not, that is the only question. I will make my submission next week.
ಹೇಳಿ.
ಅಲ್ಲಿ next week 5 ಗಂಟೆ next week ಮಾಡ್ತೀನಿ.
ಇವತ್ತು ಮಾಡ್ತೀರಂತ ನಾನು ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ದು.
ಸಾರಿ ಬಲಾಡಿ, ಅದು ಇನ್ನೊಂದು ಯಾರು ಇದೆ 4-5 ಗಂಟೆ.
23rd. End of the list matter.
Delivery warrant is under challenge.
Who are you?
My lords, what had happened was a final decree is drawn. Pursuant to the final decree for partition, execution is filed, a delivery warrant to take possession of the house. Therefore, I am before this court. I don't have much case on the merits, only on the ground of equity. Equity, my lords. The equity, just I'll point out. My lords,
Final decree has become final.
But there is some problem as such. Kindly see, my lords, the schedule is 13 cents jage schedule. The allotment share is 1/8 share. Each party will get 1/8 share. My lords, I draw my lord's attention to page number.
Final decree is not challenged.
Not challenged. No, my lords, just a minute. Page 35. Page 35.
Whatever is the defect section.
Yes, I know that. Page 35, my lords. I know that. I am aware of that. Page 35. My lords, while granting a preliminary decree, my lords, he was denied with an allotment of share in respect of residential building. Page 35. Final decree is drawn. Now kindly see the final decree, my lords. I have not contested in the final decree. Page 116. Totally 8 members, my lords. 4 plus 4. 13 cents. 116, my lords. ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ
116 page ಇಲ್ಲ.
ಸಾರಿ 116 ಅಲ್ಲ 90. ಇದು ಯಾವ್ದು ಪೇಜು? 46.
Yes.
ಅನೆಕ್ಷ ಡೀಸ್ ಅದರಲ್ಲಿ 4 ಮೆಂಬರ್ಸಿಗೆ 2 ಭಾಗ ಮಾಡಿದ್ದಾರೆ. 13 ಸೆಂಟ್ ಜಾಗಲ್ಲಿ. ಯೆಲ್ಲೋ ಕಲರ್ ನನಗೆ 4 ಜನಕ್ಕೆ ಅಲಾಟ್ ಆಗಿದೆ. ಗ್ರೀನ್ ಕಲರು ಇನ್ನ 4 ಜನ ಅಲಾಟ್ ಆಗಿದೆ ನನ್ನ ಎದುರು ಪಾರ್ಟಿ. ಈ ಗ್ರೀನ್ ಕಲರ್ ಅಲಾಟ್ ಆದಲ್ಲಿ ಮನೆ ಇದೆ. ಅಲಾಟ್ ಒಂದು ಮನೆ, ಅದರಲ್ಲಿ ನಮ್ಮ ಕ್ಲೈಂಟ್ ಸ್ವಾಧೀನದಲ್ಲಿದ್ದಾರೆ. ಮನೆ ಬಿಟ್ಟು ಹೋಗ್ಬಿಡ್ತದೆ. ನನಗೇನಿಲ್ಲ, ಇಂಟರ್ಚೇಂಜ್ ಮಾಡಿದ್ರೆ ಆಯ್ತು ಅಷ್ಟೇ, ಬೇರೆ ಏನಿಲ್ಲ. ಸರ್ ಇಲ್ಲಿ ಸ್ವಾಧೀನದಲ್ಲಿ ಇದ್ದೀವಿ ಅಂತ ಅವರೇ ಕಮಿಷನರ್ ಹೇಳ್ತಾರೆ. ಪೇಜ್ 43. ಪೇಜ್ 43.
This was done in the year 2019.
ಕಂಟೆಸ್ಟ್ ಮಾಡ್ಲಿಲ್ಲ, ಮನೆ ಹೋಗ್ತದೆ. ಏನಾದ್ರೂ ಸೆಟ್ಲ್ಮೆಂಟ್ ಆಗ್ತದ?
ನಾನು ವಜಾ ಮಾಡ್ತೀನಿ. ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ಬರಲಿ ಸಾಹೇಬ್ರ ಮುಂದೆ. I would dismiss it, take a chance before the court.
ಒಮ್ಮೆ ಒಂದು ಸ್ಟೇ ಕೊಡಿ. ಇಲ್ಲ, ಗ್ರೇಟ್.
Tuesday.
19th. 4:30 PM matter.
My lords, the submissions were last date, yesterday was that he'll give me the copy of objection, but same submission was made before.
Cost, 10,000 ರೂಪಾಯಿ cost. ಆಯ್ತು, ಕೊಡ್ತೀನಿ time, 10,000 rupees. Because
I was waiting for.
last time also, I said finally. Yesterday, you again sought for time, I refused, but I said one day. ಅವ್ರು ಕೊಡ್ಬೇಡಿ, 10,000 to the clerks association.
My lords may taken up on 21st, my lords.
22nd.
23rd, my lords.
23rd.
25th then.
You choose, you agree on a date.
25th. 25th. Much.
Serial number 67, interim order is to be extended.
ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಚೆಕ್ ಮಾಡಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಎಲೆಕ್ಷನ್ ಎಲ್ಲ ಡೇಟ್ ಕೊಟ್ಟು ಫ್ರೈಡೆ ಸಾಟರ್ಡೆ ಬೇಕು ಯಾರಿಗಾನ ಫ್ರೈಡೆ ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ 22nd 22nd ಅದೆಲ್ಲ ಬೆಳಗ್ಗೆನೆ ಅಜ್ಜನ ಆಯ್ತು ಲಿಸ್ಟ್ ಆಚೆ ಹಾಕಿರ್ತಾರೆ ನೋಡಿ ಎಲ್ಲ ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ ಬರುತ್ತೆ
Sir, list 3 matter.
ಅದೆಲ್ಲ ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ ಬರುತ್ತೆ
List 3 na next Friday na sir.
Sixth or 29th. ಅದೆಲ್ಲ ಬೆಳಗ್ಗೆನೆ ಡೇಟ್
Sir, list 3.
ಇಲ್ಲ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೇವಲ್ಲ ಎಷ್ಟನೇ ಸೀರಿಯಲ್ ನಂಬರ್ ಯಾವ ಸೀರಿಯಲ್ ನಂಬರ್ ಯಾವ್ದು ಹೇಳ್ಬೇಕು ಎರಡು ಎಲ್ಲ 22ಕ್ಕೆ 22 11 ನೆಕ್ಸ್ಟ್
Sir,
ಫ್ರೈಡೆ
list 3.
ರೀಚ್ ಆಗ್ಲಿಲ್ಲ 62 ತನಕ ಬಂದಿತ್ತು.
List 3 ಅಲ್ಲಿ ಮೇಡಮ್ ಮೋಸ್ಟ್ಲಿ ಲಿಸ್ಟ್ ಕ್ವಾರ್ಟರ್ 16 ತಾನೆ ಅದೇ ಲಿಸ್ಟ್ 3 ಅಲ್ಲಿ ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿದೆ ಲಿಸ್ಟ್ 3 ಅಲ್ಲಿ ಲಿಸ್ಟ್ 3 ಅಲ್ಲಿ ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿದೆ ಕ್ವಾರ್ಟರ್ 16 ಲಿಸ್ಟ್ 3 ಕ್ವಾರ್ಟರ್ 14 ತಾನೇ ಇದು
ಯಾವತ್ತು
24, 22nd, 21st, 29th.
29.